to what is called here hearing 3. We have 5 presenters today. We will start with the Board of Healthcare Funders of Southern Africa, followed by Best Med Medical Scheme, thereafter the Government Employees Medical Scheme, followed by Cape Medical Plan, and the Emerging Market Healthcare. Now, I do want to emphasize one point, and that is those stakeholders who have filed written submissions as well as responses to written submission, they can approach the matter on the basis that we have read those written submissions. The other point that I want to highlight is the purpose of this first set of hearing. What we want to understand, at least at this stage, in order to provide context for the more focused hearing that will focus on competitive dynamics within the various stakeholders, is we want to get an understanding of how the various stakeholders interact with one another. Today, for example, we are listening to presentations by the medical scheme and the Board of Healthcare Funders. And really what we want to understand is how the medical schemes interact with other stakeholders in the private sector, and that is the hospital groups, the practitioners, the regulators, the brokers, the administrators, and other role players within the private healthcare sector. From that standpoint, therefore, as I have explained in the meeting that I had this morning with the stakeholders who are making presentation today, we need to focus just on that relationship. There will be further hearings, as you would have realized from the program of these hearings, that there will be hearings which will be focused primarily on competitive dynamics. So if you could just bear that in mind when you make your presentation. Thank you. Are we ready to start? Yes. Okay. Very well. If you could just place your name on record and indicate who you represent and how you propose to make your presentation. Thank you.
Thank you, Chair. My name is Humphrey Zokufa. I'm the Managing Director of the Board of Healthcare Funders of Southern Africa. I'm accompanied by Dr. Rajesh Patel, who is the Senior Manager at the Board of Healthcare Funders. We'll be making the presentations together. I'm going to start, and then he will finish off. And thank you very much for giving us the opportunity to make this presentation. The outline we have is that one of just making some introductory remarks to give the context. And then the 5 bullets there are just headings of the various topics that we're going to talk about. My presentation will focus mainly on the consequences of no price regulation of healthcare service in the private healthcare sector, and the last 4 bullets will be handled by Dr. Patel. Chair, I think it's important for the context to be made here quickly when it comes to BHF. It's previously REMS, which was a statutory body that was tasked with conducting negotiations with various healthcare providers to extract reasonable tariffs. Unfortunately, that was deregulated around about 1993-94, and that became BHF. BHF continued to perform that function, albeit non-statutory, but was stopped by then the Competition Commission ruling of 23204. We were fined at that time, and we paid a fine. As BHF, we're a non-profit company. We have membership in South Africa largely, but also footprints and membership in Zimbabwe, Namibia, Botswana, Swaziland, Mozambique, and Lesotho. So, as I mentioned before, BHF was fined in 2003 for anti-competitive behavior. It's important at this point to indicate that in 2006, it became clear to BHF that the decision of the Competition Commission is adversely affecting the industry. We therefore embarked on various activities to try and reverse that. In September 2007, we applied then in terms of Section 10 of the Competition Act for an exemption to the Competition Commission, and that exemption was denied. And then, of course, in November 2012, we also requested an advisory from the Competition Commission, an advisory that will indicate to us whether the restricted schemes who are our members are also subjected to that provision of the Competition Commission. Because as you know, Chair, we have got restricted schemes who don't compete for members. Restricted schemes simply sign up members who belong to that particular industry or company. Open schemes compete for members. Therefore, if you are saying that we as BHF, in terms of membership, we behave anti-competitively, we may accept the fact that maybe that applied to open schemes, but we are questioning whether that applies to restricted schemes. It was on that basis that we asked for an advisory. That was also denied, and the responses were not very helpful, I must say, except to say that they also see restricted schemes as schemes that are embarking on anti-competitive behavior. So it's important to note that parallel to that, BHF engaged the Minister of Health, the late Dr. Manto Chabalam Simang, on this issue, and she had an attentive ear to this, and convened then a health indaba in September 2007 to better understand this in Midrand. We made a presentation there, and various healthcare providers also made a presentation there to address this issue. She then followed it up by making an amendment to the National Health Act, and that amendment involved inserting a chapter in that Health Act which was obliging the various players in this industry to come together annually and negotiate on prices. And in the event that there's a standoff between the various parties, there'll be arbitration which will be under the directorship of the Minister of Health. Those amendments were made to the Health Act and passed by Cabinet and forwarded to Parliament. Unfortunately, the Portfolio Committee on Health did not process those amendments, and then there was a change of order. The change of order meant a new minister appointed, and that then made the activity not unable to go forward, and the whole thing was sent back to the department, and then there was a stalemate. When the new minister then was appointed in 2009, we engaged the minister on the same issue. He understood it and convened a meeting early in 2009. In that meeting, we were present, the Council of Medical Scheme was present, and the Competition Commission was present. There was a general agreement in that meeting that clearly that decision of 2003-2004 was not appropriate and is adversely affecting the market and the industry. And then an attempt was made to then establish a pricing commission which will look at various issues and enable an environment where the various providers can come together and negotiate on prices. Unfortunately, that didn't take off the ground because the healthcare provider side did not want to participate in that pricing commission, afraid of being penalized by the Competition Commission because the ruling of the Competition Commission was still in place at the time. Now, having said that, I think I want to also give the context here in terms of how this industry operates. The red circle where I put private healthcare funding industry, that is really the circle that includes the medical aid schemes and the 8.8 million members that are currently there. They collect 140 billion rand a year and pay out 124 billion rand a year. That's close to 90% of what gets collected. I think it's important to appreciate that the medical aid schemes collect the money, and a significant portion of it, up to 90%, gets paid out to healthcare. And I mention this because there are some accusations at times that this industry is not about healthcare and it's denying payments. To a large extent, those payments are made out, and it's only about less than 20% that remains within the industry to take care of non-healthcare costs and other costs associated with it. And there's a huge debate around that fraction that stays within the industry, whether it's justified, because those non-healthcare costs, the inputs there will be broker fees, managed care organizations, administration costs, and also some advertising and other costs are related to that. The Council for Medical Scheme, which is a regulator, is very sticky about that quantum of non-healthcare costs. And whenever schemes go beyond 10%, then the Council Medical Scheme is really, really sitting heavy on them. The next circle, where I say providers of health care, I'm just putting all of them there, who are in private practice because they are certain that there's an amount of money that is made available to them to pay for health care. So basically, the medical aid schemes are a mechanism to collect the money and pay. If that service was not there, all those private healthcare providers would be in a difficult situation to have certainty in terms of saying, we operate in the private sector and we will be paid. Then, of course, the last circle that talks about healthcare products, we're talking about various manufacturing agents, companies that are manufacturing various products that are sold in the private sector. And they're operating in the private sector, selling those products, because they've got some certainty that there's money that the private medical aid schemes is collecting and paying out up to the tune of about 90% of what gets paid out. Now, what I want to also indicate here with this slide, if it moves on, I don't know why it's stuck now. Okay. That when it comes to the providers of healthcare side and also the healthcare product side, we've got various investors who invest in those companies. They invest in those companies because they expect a return. They will not invest if there was no certainty about the source of the revenue. So they're comfortable enough to invest because there's a source of revenue. And what I want to highlight at this point is that, as you know, Judge, with the healthcare, the SA Constitution is primary. And then we've got various kind of legislation that is there. Unfortunately here, what I want to point out as BHF is the lacuna in the healthcare legislation and how that lacuna is maximally used and exploited by those who are operative in the industry. May I just add, when it comes to the medical aid schemes, whenever a medical aid scheme, firstly, before a medical aid scheme operates, it has to be registered with the regulator. Secondly,
Dr. Zogov, I wonder if I may just interrupt you at this stage. I apologize. Now, we've just been given a document which I assume is the presentation that you're making to us today. Okay. When was that submitted? Do you know?
The presentation, this one was submitted on Saturday.
Yeah.
And it only
this last Saturday.
This last Saturday. It only added 2 slides to the previous one.
Yes.
Which we submitted some time ago.
Okay. Now, which one do you want us to use?
The one on Saturday. The one that was printed on Saturday.
Okay. Now, just to make sure that we have all documents that you have submitted. We've got a document which lists the issues that you'd like to address in the course of your oral presentation.
Yeah.
And then you give us the written submissions. And then you give us a document which is headed Private Healthcare Cost Drivers. Yeah, unfortunately, these machines do not record the nodding.
Sorry, yes, Chair.
they are voice sensitive. Yes, very well. And then you've also provided us with your response to the submissions that have been submitted to us by the other stakeholders.
That's correct.
And then we have your comments to the draft terms of reference and your comments to the draft statement of issues. And then, of course, there is this additional document, which is the basis of your oral presentation today. Is that right? Is there any document that I have mentioned?
No.
Very well. Thank you. Yes, you may proceed, Ms. Dr. Zagufa.
Yeah. I was just saying that when it comes to medical aid, it has to be registered with the regulator. When a medical aid then comes up with various benefit options, those options have to be approved by the regulator. The quantum that has to be paid by a member on a monthly basis for those benefit options has to be approved by the regulator. So in no way can a medical aid scheme come up with various options and put a rand value to them without the prior approval of the regulator. Secondly, can I make the point as well that in the Act, the Regulation 29 is clear that a medical aid scheme must have a solvency ratio of 25%. And then also, there is a concern whenever your non-health expenditure is less than 10%. So as a medical aid, the medical aid, therefore, is under an obligation in terms of the regulator to come up with plans and quantums that they have approved, have to have a solvency ratio, and then have to watch the non-healthcare costs. So in no way is a medical aid in an environment where you can just willy-nilly use medical aid people's monies. I just want to indicate here in this slide, this is scene 1. Can I just say there are 6 scenes, and then on the 6th scene, that will be my last slide, then Dr. Patel takes over. What I'm trying to show in this scene is what has been happening since 2005. If you see, there have been deficits in terms of what the medical aids collect vis-a-vis what they pay out since 2005 to about 2010, 2011. The highest was in 2009, at 2.5 billion rand deficit. And then 2011, 2013, 2012, 2013, we saw some surpluses, which we're trying to understand well how that came about. And then, of course, the last report is indicating a deficit of about 464 million rand. On the right-hand side, just trying to indicate the way the contributions have been going. If you look at the bottom line, which is the green line, is just the increase differential. What one should look at is the contribution rate increases, which is the top line. And then the blue line, which is the average CPI. What this slide is indicating is that the contribution increases over that period of 2001 to 2014 has been above CPI on an annual basis and still is. So on one side of the equation, you have contributions that are higher than CPI on an annual basis. On the other side of the equation, you're hitting deficits. And at times hit surpluses, but the majority deficits, and the latest one is a deficit. The second slide that I want to just see too is the same scenario in terms of what gets collected and the deficits involved. But the graph on the right-hand side is just indicating what I was talking about solvency levels. Now, the solvency level should be around about 25%, according to the Medical Schemes Act regulations. If you look at those graphs, the top one is the industry average of restricted schemes. And you can see, to a large extent, the restricted schemes have got solvency levels that are higher than what is prescribed. The bottom line, the blue one, is the industry average in terms of open schemes. As you can see that there are open schemes which are below 25, and the majority of them are higher than 25. And then the middle one is just the industry average, which is showing that, on average, most of the schemes are higher than the 25 level. Now, the real challenge for the schemes is, for you to arrive at this statutory requirement, what do you do with what you collect and what you pay out so that you can reach that? And therein lies the problem. Sin 3, same amount in terms of what gets collected must get paid out. The first two bar graphs speak to hospital services, which is about 37%. Then the second one is medicines. But what one should appreciate is the way the specialist services graph has been disaggregated. If you add them up, you'll see that they amount to about 23%, 23, 24% or so, somewhere around there. So it's the hospitals first, and then the specialists, and then medicines dispensed. Then you can see all the other services really do not really take a lot of money away from the medical schemes. And that includes your GPs, that includes your dentists, that includes your allied health professionals. So to a large extent, the lion's share of what gets collected at a level that's higher than 60% goes to two categories, and that is private hospitals and specialists. And as you know, specialists work hand in hand with private hospitals. This Sin 4 is also trying to break that down. If you look at the graph on the right-hand side, the highest amount paid is to anesthetists. So I was listening very carefully to what the anesthetists were saying the other day. They get the lion's share of this. And then all the other surgical specialists come through, and then you have your radiology, dental specialists, and all of that. Then Sin 5, which is in my second last slide, Chair, is just showing the breakdown of healthcare costs for a period of 2003 to about 2014. What I want to indicate here is if you look at the bottom graphs, before you see the light gray one, they remain mainly flat over that period of time. The gray one is the medicines, and the blue one is specialists, and the top one is private hospitals. So in the private healthcare sector right now, most of the healthcare cost increases is attributed to two categories, private hospitals and specialists. The third one is medicines, which is beginning to rise. But then my last slide is going to talk more about that. If you look at the left-hand graph, where we are showing, if you look at the red line, which is, represents the medicines, and if you look at 201 point of that red line, there was a decrease in medicine expenditure from 201 to 202 roughly. That's attributed to about 19% or so of medicines. That was the time when the medicine price regulations were introduced. And then if you look at the right-hand graph, you look at the gray line, light gray line, you'll see in 201 into 204, there's a drop in the amount of money that was paid for medicines in that graph, which clearly indicates that the introduction of medicine price regulation at that time gave rise to the reduction in the cost of medicines. But look at what happens to the top line, which is the private hospitals, which increased significantly in terms of what get paid out, trying to make up for what they were losing on drugs. And you look at the specialist one, and then all the other graphs at the bottom stayed more or less stable. So we're making the point here that, one, the cost of healthcare, the increase in healthcare costs in the private sector is mainly attributed to two sectors. Within that sector, if you break it down, it will be private hospitals and specialists. If you further break it down, you'll see your radiology, your pathology, and then, of course, other medical specialists. And we're saying that if you should introduce price regulation in that sector, we should see what happened in medicines. But I will not forget to mention the point that was mentioned, that the pharmacists mentioned, that with the introduction of medicine price regulations, they are also experiencing some difficulties associated with that. And the reason for that is that not all the provisions in the Medicine Act are enacted. The 22G provision of medicine price regulations contributed to that decrease. That's 22G. But within the same Medicine Act, you have got 18A, 18B, and 18C, which talks to other interventions that have been made. And then the same Act talks about 22F, which is generic substitution. That generic substitution is structured in such a way that the pharmacist must tell the patient about the availability of a cheaper generic product. What we should have written there in that act is, must tell the patient of the availability of the cheapest generic product. But again, as you heard, it is the member who decides. It's not the pharmacist who decides whether to give a generic or not. It is the patient who decides. The pharmacist is obligated to tell the patient this. So we believe that if you then come up with a dispensation where you can regulate the tariffs related to pathologies, regulate the tariff related to radiologicals, regulate the tariff related to surgical procedures, bed occupancy rates, and the length of stay and all of that, we should be able to see a downward pressure on that cost pattern. And then, of course, linked to that regulation, you have to be able to have capacity to enforce it and monitor it. The biggest problem now with the medicine price regulation, and I think that's why maybe those medicine prices is increasing, is that we haven't finished the program. We haven't finished the program of introducing international benchmarking, pharmacoeconomic evaluation, and if you introduce those two issues and enforce the provision of 18A, 18B, 18C, we should see a further downward pressure on those medicine prices. Lack of doing that is leading to a situation where we begin to see a creep. So even if we begin to come up with regulations that regulate that price of the hospital services and medical specialists and what have you, linked to that, there has to be huge capacity resources that will make sure that that is enforced. And any kind of financial resource that goes into enforcing that will be paid back by the savings you'll make in terms of introducing this.
You know, I may just forget this question. I'm going to put it to you. You don't have to answer it now, at some point. Now, to what extent, if any, does the legislature or the ministry concerned cost the legislation before it is enacted?
Sorry, Judge, I don't understand the last part.
Okay. To what extent, if any, does the legislature, before enacting a law, cost the legislation? In other words, determine how much it will cost to implement the legislation. Take, for example, the Medical Schemes Act, the National Health Act, which have a series of councils and regulations that need to be implemented and regulatory bodies. Now, to what extent is that taken into account before the act is, well, before a bill is enacted, so as to make sure that when the law comes into operation, the infrastructure necessary to give effect to the act is in place, so that you don't have the kind of complaint that you're having at the moment. You don't have to answer that now. You can deal with it at a time when it is convenient to you.
Just my experience when it comes to this, that is not adequately done. When I was in the Department of Health involved with these medicine price regulations, we didn't go to a large extent to assess that in terms of what does it mean for the Department of Health to have all the resources to enforce this, so to extract the savings. That was not adequately done.
Would that be in relation to, would that be in relation to the, I'm thinking about the Nuclex case.
Yeah.
Yeah.
In relation to that,
yeah,
we came with a single elected price, which was enforced.
Yes.
We came with a dispensing fee, which was enforced. But there is no capacity to know exactly whether those who provide healthcare at the retail level stick to that dispensing fee as prescribed. And then, of course, the 18B that is outlawing bonuses, perverse incentives, and the rest, there's no capacity at all to make sure whether manufacturers are adhering to that or not.
I think it's an important issue insofar as giving effect to the legislation is concerned. It is an issue that I would like you at some point, with your experience with the pricing committee, to address. Not now perhaps when you come back at some point.
Will do, Judge.
Yes, thank you.
Yeah. Last point that I want to mention here, Judge, is the Section 90 of the National Health Act, which makes provision for the minister to come up with some regulatory framework when it comes to healthcare services and tariffs. The problem with that section is the language. The first language, it says the minister may, which means the minister may not. It's not saying the minister shall, the minister must.
This may, which means shall.
Sorry, Judge?
Isn't one of those may, which means shall?
I wouldn't know in terms of legalistic language, Judge.
Yes,
That's the first problem with that section. The second problem with that section is a reference price, which means it's a reference price. I can adhere to it or I can ignore it. And if it was saying a reference price above which you may not charge, then that's enforceable. So that section is totally inadequate for the Minister of Health to come up with a regulated environment in this area. So for me and for us at BHF, we're not condoning any kind of accusations that have been made before by various people here when it comes to their bitter and unpleasant experiences that they've had with medical aids. We're not condoning that. We are not supporting that. We believe that medical aid should behave in a particular way, in a way that satisfies the patients. So we're not presenting this thing as a defense to those kind of accusations. We're presenting this just to lift the other side of this ball that has got many sides to it.
Can I add this footnote to your question? Now, when the public hearings, and I assume that public hearings were held prior to the enactment of the National Health Act, did you take part in those public hearings?
When it comes to what the late minister did in setting that chapter, yes.
Yeah.
In fact, we were very instrumental even in drafting that section. We're very instrumental in making sure that we follow the process within Cabinet.
Does that include Section 90?
Section 90, Section 90 was
Section 90V. Section 90, subsection 1V.
Yeah. That section, Judge, during the time the minister inserted the chapter to enforce negotiations, that section was not interfered with during that time. It stayed as it was. And we indicated to the minister what I'm indicating here now, that you don't have adequate powers in terms of that section to introduce what you want.
Yeah, I understand. It's just that, because as I understand your concern in relation to that particular provision,
yes,
is that it is permissive.
Yes.
That's how you interpret it.
Yes.
In other words, the minister may or may not.
Yes.
There is nothing which compels the minister to do so.
Yes.
And secondly, it's just a reference.
Yes.
It's not something that's mandatory. And indeed, the section does provide that it is something that can be used by the medical schemes in determining their benefits. Yes. And that the private sector may use that, but they're not obliged to follow it. Yes. Now, as I understand it, your concern about this particular provision is that it doesn't make it mandatory.
Yes.
It is not worded along the same lines as Section 22, capital letter G of the of the Medicines and Substances Act. Yes, yes. Okay.
Correct.
All right. Thank you.
Thank you.
Thank you, Chair. I think it's important to note this statement that was made by Marcus Aurelius a while back. Everything we hear is an opinion, not a fact. Everything we see is a perspective, not a truth. And I think over the last few weeks, we've heard certain angles. We're going to present a little bit of a different perspective. Chair, we took note of your comments at the pre-hearing and now that you don't want us to talk about what's in the submission. And for that reason, this presentation will not focus on the issue of price of services. We've dealt with that adequately in our submissions. What we're going to focus on are two specific areas, and the one is healthcare accountability, looking at the role of the regulator and Department of Health, looking at the roles of healthcare accountability at the medical scheme level, and later on in the slides, I'll show you some healthcare accountability results from the service provision area. And important in this environment that we often hear in the newspapers about there's no accountability at government, no accountability at various levels. So it's important to take a note of this important area. And I'd like to start off with asking
You know, in the course of your presentation, there is a matter that, as you're aware, from having sat in these proceedings, which has been raised in the past by other stakeholders. Now, who are the players on the funding side of healthcare services? We have the medical schemes, we've got the medical administrators, we've got the medical scheme brokers, we've got the health management organizations, we've got the, I don't know what else you have.
I would add the regulator to that.
The regulator, yeah. I think what's important is this. Who do these represent? For example, your administrator. Whose side are they on? For whose benefit are they there? The brokers. And how do they interact with one another and with the scheme in particular?
Yeah.
If you could address that.
In this presentation, I will show tidbits of the role of managed care, administrator, etc. in this context. The bottom line is administrators and managed care companies are agents for the medical scheme to carry out the day-to-day function and activity of the medical scheme. The brokers are obviously the ones that would interact with the members and bring them through to the medical health schemes. Unfortunately, in this presentation, I haven't put anything on the broker issue, but I'll be happy to entertain the broker issue in question and answers if that's possible. I think when it comes to healthcare accountability, Chair, the question that needs to ask, what's your business, and particularly that of the medical scheme. And I've listed a few examples here. If you're a baker, the important thing that you need to know about your business is the flour that's there and recipes. If you're a shop owner, there's people do shopping at the malls, etc. Your business is groceries. So you collect money, pay money, etc. But your main business is groceries. If you're a bank, your business mainly is lending, so you need to understand lending risk and the interest rates. And the question in medical schemes then is, what is the business of a medical scheme? And before we go to the exact business of a medical scheme, it's important to consider Section 27, and I'm not going to bore the panel with all the details. You're familiar with it. And obviously the orphan Section 28(1), which no one really refers to. And in hearings, I think it was just Section 27 that related to this. But I want to highlight point 2, Chair, which says the state must take reasonable legislative and other measures to ensure that what's in Section 27 and 28(1) tends to happen, in particular 27. I'd like to then take you through to the Medical Schemes Act, Chair, which describes in the definitions the business of a medical scheme. And if you look at the first words, it says, means the business of undertaking liability in return for premium or contribution. This immediately indicates that in the eyes of the legislature and whoever developed this act, is that medical scheme is essentially a financing vehicle. And it's a financing vehicle for health-related claims. Only in point C, you really see some components of health coming through where it says to render relevant health service. And incidentally, if you notice previous submissions talked about, we'd like hospitals to be able to employ health service providers. This is a legislative mandate to medical schemes that medical schemes can actually employ health service providers to provide service. But the important message here, Chair, is in terms of the definition and the legislation, medical schemes are just financing vehicles. So if you're expecting accountability for health, it may not necessarily happen unless there's good, strong stewardship in the environment. So the point in the message we want to explain here is it's not explicit that the business of medical schemes must be to improve the health care of the beneficiaries or in pursuance of the constitutional mandate. Medical schemes essentially are quasi-insurance currently regulated by the Council for Medical Schemes and report to the Minister of Health. And as financing vehicles, one should actually ask the question, so why isn't it under the Financial Service Board? But I understand the issue that's health-related expenditure. What has happened since the late 80s and early 1991s, you had the Melamed Inquiry, and the Melamed Inquiry actually saw medical schemes as insurance vehicles. And the whole thinking about medical schemes as insurance vehicles started to be perpetuated after that. One of the major recommendations, besides managed care should be coming in to contain costs and manage costs, it was that the industry need actuaries. The Melamed Commission did not see medical schemes as providing a business of health in this environment. Following that, you've heard terms such as catastrophic cover coming in, which indicates that medical schemes are there to protect you against financial disaster, and terms like day-to-day care called discretionary expenditure. And just for the record, and I'll say this all the time, is if I have a boil on my backside, Chair, it's a disaster for me, and it's catastrophic. It's not discretionary at all. And I think that's something we need to really look at, whether there is adequate day-to-day care, day-to-day benefits. And I think the primary care practitioners last week and the previous week referred to that there's very little primary care benefits in the medical scheme industry. I think it's important also to mention, Chair, that there's inadequate stewardship and leadership in this environment, coming either from the regulators or the government, etc., that what the business of medical schemes should be in the context of the Constitution, in the context of healthcare and improving healthcare. What is important is that the business of medical schemes should include health governance, and this should be included in the definition. The whole insurance thinking is evident in what I call the current problematic PMBs. Over the last 2 weeks, we heard this thing that PMBs are the panacea and it's a big solution. And yes, it's a great policy to have included in the legislation, and I'm fully supportive of it. But when you go into the detail of what the benefits actually are, that's where you hit where you get a better understanding that it's actually a disaster. Firstly and importantly, it is discriminatory and poorly structured. Chair, I'm happy to spend a few minutes to explain why I say it's discriminatory unless we deal with it in question and answer time. How would you like me to deal with it? Should I explain it very quickly?
Yeah, go ahead.
I think it's mainly diagnosis based. And I think when our founding fathers that wrote the Constitution never imagined that people would discriminate on disease. They talk about race, sexual preferences, gender, etc. You won't discriminate on that, religion, etc. Never on disease. What we have in the diagnosis and treatment pairs and the chronic disease list are just diagnoses. If you have these diagnoses, you have all these benefits available to you. If you happen to have a diagnosis that's not on the list, well, then we've probably shown the cliff or the ocean or something. You get no benefit, essentially, from a statutory perspective. And I'm going to give you a couple of examples. Otitis media, which is inflammation of the middle ear, is a prescribed minimum benefit. But sinusitis, which is caused by the same pathophysiology, a viral infection, etc., is not covered at all. And there's reasons to this, and it's important to understand the history. I'm not going to bore the panel with those details. Maybe at a later stage we can go into the history, how it arose. But another example is autoimmune diseases. There's about 9 or 10 autoimmune diseases that are covered. There's about 4 autoimmune diseases not included. And an example of that autoimmune disease is a condition called polymyositis. Polymyositis is not a prescribed minimum benefit. Rheumatoid arthritis is a prescribed minimum benefit. But the first-line treatment for both conditions is the same. So the question needs to be asked, if the medicine is appropriate for rheumatoid arthritis and it's a PMB, why is that same medicine not appropriate for another condition, polymyositis, and why is it not included in the benefit? What had happened, this package originally started as an essential hospital package, got costed, not enough. They said, let's add in all the things that lead to the diagnosis and everything after. Makes absolute sense. It went through the Department of Health, Women's Health got added on. In the late 1990s, the whole termination of pregnancy was an important issue, so termination of pregnancy got included, but sterilization is not a prescribed minimum benefit. And you have all those type of anomalies in the PMBs that's there where if you happen to have those conditions, you get benefit. If you have this condition that's not on the list, well, you end up getting nothing. The concept where I say it's poorly structured, Chair, is you have some conditions listed in the diagnosis and treatment pairs. You have some conditions listed in the chronic disease list, and there's some conditions listed in both. Obviously, from a structural perspective, it's like, how do you then manage this if you have to just cross the chronic disease list, cross the diagnosis and treatment pairs, etc. But an important consideration in this whole thing is that the diagnosis and treatment pairs all over the show have severity components. So even something like ICD-10 codes is not enough to describe those conditions. All you can suggest is this might be a potential benefit. You have to see the severity level before you can consider that it will be a prescribed minimum benefit. And as I said, it's a limited set of conditions. Importantly, it's hospice-centric, adult-focused. There's emphasis on women's health. However, children's health is largely ignored. There's very little in this package for children. What is important as it stands right now, there is no formal policy with firm inclusion and exclusion criteria. Along the way, it's just been, for certain reasons, things got excluded, things got included, things got excluded. In the case of chronic disease list, one of the first things the regulator had done is approach funders and say, give us your most common conditions and give us your most expensive conditions. And that's what led to the first subset of conditions in the chronic disease list. Through the engagement processes, major depression got dropped off and osteoarthritis got dropped off. Now, there were reasons as to why it got dropped off, but I'm not going to go into the details. But suffice to say that those were two conditions that were dropped off. And I'm mentioning it because there was discussion 2 weeks ago about mental health inadequately covered. Sure. I think when you look at this prescribed minimum benefits, it was developed with this catastrophic concept in mind and the protection of expenses of people in mind. It wasn't developed with the mindset that we need to promote access to care, as envisaged in the Constitution. One of the critical things that I describe is that for those few conditions, you get a strong depth of benefit. However, if you look at the Constitution, Section 27, it talks about access to benefit. In reality, if you do have a benefit that speaks to the Constitution, what you need to create is a breadth of benefit that benefits most beneficiaries. However, the depth of benefit should be based on level of affordability. And I'll comment on affordability in a few moments here. One of the things that Humphrey talked about, medical schemes are paying 125 billion rand, so really they exist to pay claims. Medical scheme regulation 7, Chair, has somehow omitted to include chronic disease list as a prescribed minimum benefit, and I think this was in error. What you must understand, in 2006, BHF brought this omission to the attention of the regulator, and it's 9.5 years since that time. Nothing has been done to fix this error. So over the last 9.5 years, or should we say last 13 years, the benefit provided by medical schemes for chronic disease lists is in the spirit of the regulations rather than based on the letter of the law. The issue of insurance thinking evident in the current problematic PMBs, BHF policy has been, if you regulate a benefit and you want to ensure members are able to access it, it's critical to regulate a price at which that benefit can be procured, particularly if you want to protect the members from things like co-payments, Chair. In this context, it's important to note the Council for Medical Schemes interpretation of Regulation 8. In the true sense of the word, what it would create is unintended limitless liability, and I believe the medical schemes that follow will probably talk a lot more about it. This last point is the one that's important I want to highlight and spend a few moments on because it also speaks to the research that was done and presented here by WHO and OECD. The lack of price certainty makes PMB less affordable, particularly for the lower income earners. No cross-subsidy applies. Here I want to give you an example of a family of 4. And the reason why I choose family of 4 is because of the current tax credit system that's in place. If you consider what Pravin Gordon presented last week, the tax credits available to those who are above the tax threshold will be about 960 rands. If you believe the Council of Schemes costing of PMB, you would then estimate for this family of 4, PMBs would cost in the region of 2,400, 2,500 rand for that family of 4. If you believe the funding industry, and conservative estimate is that the cost would be in the region of 3,200. And if you look at that gap, it is quite vast. And lower income members would find extreme difficulty belonging to medical schemes if it wasn't for the employer subsidy or employer contribution. And even that, it becomes quite expensive if the contribution is 50-50. And the PMBs is obviously the total package, which includes the price of services and it includes utilization. And BHF has always said this, the utilization, yes, contributes, but it's not a significant contributor. The price of service is. And if I take this into account, when it comes to lower income members of medical schemes, PMBs is getting extremely affordable. I mean, not affordable, unaffordable. And to that extent, it's consistent with some of the conclusion that was drawn by the WHO OECD study, which obviously looked at the basket of procedures, but it looked at cost component only. So our suggestion on the way forward, particularly with prescribed minimum benefit, is that it shouldn't be discriminatory. What it should be is defined based on service levels. It should be service level based and not diagnosis based. And important that we define essential services such as essential drug list, essential pathology list, procedures, consultative services, etc. And that's how we should state the benefit, that any person, irrespective of the disease they have, if you define these services, then the patient will have access to those. Once a diagnosis is made, the question then can be determined how far do you go with the treatment, and that should be a function of affordability. Our view, based on the fact that the Medical Schemes Act definition of medical schemes is inadequate to look after the health of members, is that the whole Medical Schemes Act and its regulations should be aligned to Section 27 and other progressive government policies, and that this Medical Schemes Act and regulation should be addressed as a matter of urgency. Important to note that the prescribed minimum benefits has not been reviewed since 2003, 2004, when the chronic disease list was implemented. There were 2 attempts to try and review it, but unfortunately there were some faults with those processes and things got halted and really didn't take off. What we critically need in this industry is a lot of stewardship in the absence of the definition Medical Schemes Act, and we need to include health governance as part of the business of medical scheme. I'm very encouraged that in 2016, CMS Circular 15 makes reference to the Sustainable Development Goals and the indicators that are included in Sustainable Development Goals. The CMS want to include a lot of those indicators as part of the statutory submissions of medical schemes, and hopefully that will be some of the starting steps towards making schemes accountable for healthcare. Chair, when I talk about the business of medical schemes and health governance, what I'm referring to is the importance of identifying health needs, ensure that the health services are in place to address those needs, or in the case of a medical scheme, the benefits are in place to address those needs. That there's actions, programs, interventions put in place to address priorities, and there's monitoring and evaluation in place. What I've added to this list is, importantly, is the interrogation of the information presented, and that there's accountability by those finalists, for example, Council for Medical Schemes, government, and including medical scheme trustees. The last component that I want to talk about also relates to accountability, but it's more presenting you quality information, information on supply and use, demand, etc., but particularly quality. And this term I picked up was overspending on adverse health outcomes. I picked it up from the Canadian, describing the Canadian health system. Unfortunately, I lost the reference to it, otherwise I would have credited that person. I think importantly, when we read the submissions to the inquiry chair, there were words like high utilization and burden of disease as drivers of cost. From my perspective, a person from looking at it from a health perspective, it appears to be a level of ignorance, and those who don't understand health are trying to ascribe some reason for those increases. From a health perspective, when I look at the information and the data, what you really have is adverse health outcomes that they're describing as high utilization, and you have a lot of supply-induced demand, and I will show you some of this in a few moments. Is healthcare cost a problem? I think this was included in one of the slides I submitted to you. Chair, medical inflation has generally been going CPI plus 4.3%, and that's from 2009 to 2013. And not surprisingly, schemes have hit deficits when you have such high medical inflation. Health insurance as a percentage of household expenditure, as per Stats SA, was about 3.4% 2006-2007, about 7.2% of 2010, 2011. I was verbally informed it's close to 10% in 2015, but I haven't yet found the reference in Statistics SA. As soon as I have that, I'll try to submit that to the panel. Chair, essentially what's happening right now, we're overspending beyond levels of affordability in our environment. And therefore, it's critical that we get a handle on the healthcare cost. Chair, in the slide, I'd like to start from the bottom and work our way to the top. The prevalence of hypertension in this environment is described to be about 12.5%. If one applies epidemiology skills and consider what is the expected prevalence for high blood pressure in this environment, it's conservatively estimated about 16%. If we take the difference between 12.5% and 16 and extrapolate it to the 8.8 million lives, potentially we find that there's about 250,000 patients with high blood pressure on medical schemes with a medical aid card that either don't know they got high blood pressure or they know and they're not registered with medical schemes for access to benefits. And I think that's important to consider in the context that if the business of a medical scheme was health, this is what we'd be looking for, and this is what we'd be trying to find and address as well. Not just address when the claim comes in, that's when we deal with the claim issue. I'd like to start with the line before that looks at stroke admissions per 1,000 lives. Chair, the three columns, 2012, 13, and 14 are what was presented in the HQA report. For the purpose of completion on the process indicators, I took out the stroke admissions for the 2 years that was presented in separate reports. However, if you note the trend in the stroke admissions, Chair, it's going upwards. And this is the adverse health outcomes that we're referring to in stroke admissions. If you look at the major risk factor for stroke, high blood pressure in particular, I'd like to refer you to these various indicators, which are what we call process indicators, looking at the kidney function, which is creatinine coverage, looking at cholesterol testing, ECG testing, and glucose screening. Chair, in all of these, you will notice it's less than 50%. That essentially means that the doctors have about 5 consultations in a year to see a patient, because medical schemes are funding about 4 GP consultations and an average of 1 specialist consultation. So there's 5 opportunities to actually carry out what's in the guideline. And what is happening here is what is described in the guidelines that must be monitored at least once a year is what we're measuring. And it's quite clear that these figures are less than 50%. Just a quick analogy from a legal perspective, Chair, if you're standing in a court and imagine the lawyers presenting the evidence, present half the professional input. The evidence they bring to court is less than half of what is actually required. We can imagine what happens to the justice system. And unfortunately in health, we're being relatively quiet about this, and we actually take this for granted. And you hear in the newspapers that leave the private sector alone, the quality is great. Minister, you deal with the public health sector, etc. I think what I'm showing you here is the quality of care for the most commonest chronic condition is seriously substandard. And it's showing out in the adverse health outcomes. Newborns is important. Children's health in any country is absolutely important. Chair, the first indicator is low birth weight, which is less than 2.5 kilos. In the HQA survey, this was identified at 5%. Now, this is not so severe. The ideal one we needed to measure is the children less than 1.5 kilos. But unfortunately, this is a WHO indicator, and therefore we decided to be consistent with the WHO. It shows that the burden of disease for low birth weight is 5%. What I'll bring to the attention is 13% of newborns are admitted to a neonatal ICU. And that's quite significant. That means 1 out of 8 newborns is taken into a neonatal ICU. This either means that we have a really sick and rotten society, or it means that the maternity services are absolutely hopelessly inadequate, or the last one, which is probably the true one, that there's supply-induced demand. It's important to note that when patients are treated in an ICU, there's a special code that's charged. It's about 2 to 3 times higher than the consultation fee. In the context of the newborns, Chair, there's a modifier called 0019, which you can add an additional 50% on, which obviously means there's a good incentive to treat patients in an ICU. Maybe the reason is to allay the fears and that of the parents, I'm not too sure. But what I would also like to bring to the Chair's attention is this modifier 0019. That is the precursor to the Council's belief that PMBs must be paid in full. If I may have a few minutes, Chair, I'd like to give you the brief history of modifier 0019. After the Competition Commission's intervention or interference in this environment, the only difference between the medical professionals' coding structure and that of what medical schemes was this one code, modifier 0019 for pediatricians when they admit to ICU. And what had happened is Regulation 8 started to be applied, and it was this issue where providers felt they were entitled to Regulation 8, which is at cost, and there were lots of appeals that took place. The 2 important ones that led to further development on the current interpretation is the Cara Gems case, and the first one, which was the Putterman Samu Med case. The interpretation of the Samu Med case was pay at cost. not interpreted, the ruling in that appeal case was pay at cost. And this is what the Council of Medical Scheme drove into the industry. The James Putterman case came with a different ruling. And in the context of this environment, one would think that the right thing that the regulator would do is to probably go for a third opinion of the Council for Medical Schemes should have gone to the court for a declaratory order. They didn't. They chose to implement the one. And one of the big problems was this code repeatedly was resulting in appeals, lots of debates, lots of lawyers getting involved, and probably the legal cost was far more than the claims itself. And on that reason, BHF met with the pediatricians to resolve this issue of 0019, how it should be built, how it should not be built, etc. And we resolved that. We understand from international coding that for neonates, there is a fee that's higher than the normal ICU. And we agreed that modifier 0019 could apply to the neonatal ICU. One of the things we objected was the application of modifier 0019 for high care. Generally, high care, you need additional nursing, not so much additional doctor input. In an ICU, you need a lot more doctor input than that. And we made it absolutely clear that we cannot support the use of this for high care. With that resolved, there was some reduction in noise in the industry. There was less appeals, etc., for those first few months. But then the Council of Medical Scheme decided, no, BHF is actually colluding with providers and lodged a complaint to the Competition Commission. Competition Commission eventually decided they're not going to take this further, and Council decided they're going to refer it to the tribunal. And at that point, they decided, no, we need to charge SAMA in this case as well, and the pediatricians on board. And that's what led to this whole scenario of some decisions, etc. That's still sitting somewhere in the air. We haven't yet resolved those issues, and hopefully after this hearing gets done, maybe that might kick in. That's the history of modifier 0019 and how Council came to the interpretation of at cost based on the one case, but totally ignoring the other ruling. I know there was a question about caesarean section coming from Prof. Wan. Just to give you a sense, on the right-hand side, the current caesarean section rate is 72%. It obviously gives new meaning to the term normal delivery. But critical to that, Chair, I'm of the view, and if you look at some of the WHO literature on what should be the reasonable percentage of caesarean section, that from a defensive medicine perspective, maybe it's reasonable and acceptable for caesarean section rate to be 35%. The fact that it's 72% indicates that there's been some preference and convenience in this whole equation that has led to it being 72%. And our view is that extra 35% is not clinically indicated. And as I said, it's for preference. Now, I think it's important to know that 35% that's used for convenience. This 35% is adding an extra R500 million being paid to the hospitals because they're doing the caesarean sections and there's theater, there's extra length of stay. I want to now take you on to the left-hand side, which are the testing that's done in pregnant patients during the year, and to give you a sense of the guidelines, how doctors treat guidelines. Hemoglobin is a pathology test that's almost done in every pregnant patient. The result is 83%. From my perspective, it's very high and quite good. But if you look at the testing of HIV in pregnant women, it's sitting at 38%. Now, it could be turned around and said funders are not paying, but we're paying for hemoglobin. Why would we not pay for HIV that we recognize is a big problem? This is an indication that is not really tested out there in the private sector. Now, if the fact is true, 38%, that means 60% of antenatal patients aren't being treated according to guidelines. And you have this range between 35% not treated according to guidelines over the years to 60%. In obstetrics, things can go wrong. And if something happens to a patient and it goes wrong and the doctor gets sued, you've got no leg to stand on if you're not practicing according to guidelines. And if documentation is bad, as has been described, then the likelihood is what we're seeing is a lot of these cases settle out of court, and the only time we hear about it is when the premiums come out for the professional indemnity. And that explains why the obstetricians have a premium of close to R500 million. And I want to raise certain things on that issue, because the obstetricians have come around to funders asking for more money because of the indemnity insurance that's sitting high. The current relative value units is in red here on the right-hand side, 282 for the first code and 262 for the second. I think second one's caesarean section. The proposal by SAMA is that that be increased to 462, and in the next one, 447. This is what last week they talked about, the scientific method and description aligned to CPT and relative value units, etc. But the disingenuous thing, Chair, is that after delivery, there's a 6-week period, what we call the puerperium period, where the female anatomy and physiology come back to normal. In the old tariff structure, it was up to 6 weeks. Everything up to 6 weeks is included in this costing study. What the professions have done is to change the wording to 4 weeks. What that means now, not only are they taking an 80% increase, they can now charge for their follow-up visit after that, effectively giving them a 100% increase. Now, I have no problems. You have R500,000 insurance. We need to come and work on a solution around that. But don't play games with coding. Don't try. The coding should describe scope of practice. You shouldn't be gaming the system in this way. And this is the whole issue about information asymmetry, Chair. To members of the panel, this may not be understood, but I'm an Indian. I can pick up these things very quickly and understand. You know, Indians can make 1 + 1 = 3. So, anyway, Chair. In the 2 weeks ago, the issue was raised about mental health, and I changed the presentation to include this to give you a sense of what's actually happening in the mental health environment. The first line in that is the depression-related hospital admission, and you will notice the trend is actually going up. Now, I'm not sure if this is because the burden of disease is going up or this is supply-induced demand, largely because most schemes only offer what is in the PMB as a benefit, and that is that 21 days hospital or 15 consultation treatments, and in the CDLs, which is for bipolar disease. And I think it's important, but the next 2 lines, Chair, gives you a sense of the quality of care that's out there. After a patient is discharged, just 2% of patients are seen by the psychiatrist after that. Now, in this case, we're making the assumption that a psychiatrist will charge a consultation code if he sees a patient. He's not going to lose out on the opportunity to charge. We do understand that maybe some of them are good guys. They charge us the therapy and not the consultation code. And perhaps what we're seeing here is 2% of claims coming with a consultation code after 10 days. After 30 days, this is just 5%. And it gives you the sense that even people admitted to hospital, post-hospitalization, there isn't adequate follow-up in this context. This is an important one to my heart, that I believe that funders can actually do something, and I'll talk to you about this, administrators and schemes in this context. Chair, because there's inadequate health governance throughout the value chain, you end up seeing this pattern here. It's 20 years since the Constitution has come into being, which promotes access to care. It's about 13 years since chronic disease list was put into place. This describes the access to medicines. In the case of the statins for ischemic heart disease, you can see it sitting at about 60%. For type 1 and type 2 diabetes, the statins is the cholesterol-lowering agent. It's just under 40%. And for cardiac failure, the ACE inhibitor and angiotensin receptor blocker sitting at 60%. My evaluation in this whole thing, Chair, particularly for diabetes and cardiac failure, was that we found that often doctors don't prescribe this on the script. From the funding side, the funders are too focused on the script in front of them, not looking at the full GUR function that says what's supposed to be, what this patient should be on, and what's actually been prescribed. They look at the script and they try to cost manage that script in this current environment. From the medical scheme side, there isn't sufficient health governance in place. If there was, they would make the managed care companies more accountable. What this shows is that patients out there, if you have a PMB and the doctors don't prescribe, funders are not necessarily promoting increased access. And it's an indication of the type of quality that we have. If we change the business on health, these loops would be closed a long time ago. But I developed a training program and tried to pilot it with one of the managed care companies. At the end of the training session, one of the comments of the middle manager was, which is not, I don't think it's probably the views of the director, was, this is very controversial what I'm promoting here because this would lead to increased costs. And schemes don't want to incur the increased costs, they want to see cost saving. I don't believe that trustees exist to deny access to benefits that are legitimate and what's prescribed. Chair, I also want to give you a good story to show you that there's pockets of excellence in the environment. I'm not sure if you're familiar with this group, the Center for Diabetes and Endocrinology, which is a center of excellence for diabetes care. If one looks at the lower limb amputation rate in diabetes, Chair, the fee-for-service patients' amputation rates in diabetic patients is 11 times higher than in the Center for Excellence, the patients managed in this capitated program. If we look at the high sugar-related admissions, it is 33 times higher in the fee-for-service environment than it is in this capitated environment. Here, I'll understand why it is such, because the doctors are actually capitated in that costing, that they will be responsible to pay for that admission if those patients do get admitted for high sugar-related events. And maybe this is an indication that in the fee-for-service environment, the threshold for admitting patients is very low. Just some concluding remarks, Chair. There is some pockets of excellence out there, but in response to this term, high utilizations, I actually want to say that there's underspending and underutilization of essential healthcare services. There's overspending on adverse health outcomes and some wasteful events, as I described. There's an urgent need for stewardship to promote the business of health in medical scheme environment. Importantly, we need to transform our thinking about what the business of medical scheme is from a finance-centric finance vehicle to one that looks after medical schemes, members' health. And lastly, there's an urgent need to reform the Medical Schemes Act and regulations, Chair. And I think that's it.
Yes, thank you, Chairman. And Dr. Zoff, is there anything that you want to add to what has been said? On the record. Yes.
Chair, as I said earlier, we're not condoning any behavior that was unpleasant, that was experienced by medical scheme members. We actually believe in the opposite, that they should be treated with dignity and have access to whatever. We are concerned with what is currently happening, where there is money in the kitty for healthcare services, but somehow access to those services the quality thereof is questionable. And then, of course, payment for those services is made in some instances, but does not translate to good healthcare outcomes. The 8.8 million lives that are in the medical scheme environment now, we are overgrazing them because we keep on increasing their contributions at a level that is higher than CPI on one side. Their benefit structure is shrinking, and they're faced with co-payments, and they're faced with high influence. And on the other side, the medical schemes in total are faced with deficits. And clearly, in terms of the graphs, those deficits, the main contributor is two sectors. It's the private hospitals and the specialists linked to those private hospitals. And if you look at that deeper, they can do so because there's absolutely no regulatory reform that controls what they do.
Thank you. We're going to put some questions to you just to clarify some of the issues that you have raised today. Thank you.
Thank you, Judge. Thank you for your presentation and for presenting me with this file. As the judge said, we also read your file, so if you allow me, I have some questions on the file. The presentation was very clear to me, and I think the more qualitative aspects of what you just presented are already, to some extent, captured in what you sent us before. But we will also deal with more quantitative aspects in the competitive dynamics sessions where you will be invited as well. Just to start off with a brief question, what percentage of beneficiaries and of schemes are represented by BHF?
Right now, we're more than 70% in terms of representing the medical schemes.
70%?
More than 70%.
Yes, yes.
And that is out of the 8.8 million lives in terms of the belly buttons, you're looking at more than 7% of that.
70?
70, yes.
Yes.
And then within that environment of BHF, we have also the administrators. And then the administrators in South Africa is the three big ones, your Discovery and MedScheme and Metropolitan.
Yes.
Now, Discovery is not in our stable.
Yes.
As a scheme and as administrator, not on our stable. But MedScheme is on our stable as the second big administrator, yes. And Metropolitan the third administrator. And then, of course, we have 3 and 4 other administrators that are in our stable.
Yes.
And then we also have managed care organization.
Yes.
The big one that we have in our stable is EOH. And we have also the managed care organizations that are linked to the administrators.
Yes.
So by far in South Africa, we represent the greatest percentage of the funding industry in the private sector.
Yes. Thank you very much. Hopefully we can touch upon this briefly. It's an important subject. In your submission, you describe how the introduction of social healthcare insurance went on in what is it, I think around 2000, is it, with PMBs and open enrollment and community rating. But then you mentioned the 2 other topics that were left out, so mandatory membership and risk equalization. And you have a view on that, isn't it? I do think, and I gather from your evidence, that you are supporting the introduction of mandatory membership for everybody employed in South Africa, and also risk equalization. You are, of course, also an important lobby organization with government and other institutions. Can you tell us briefly why you think that is important for the system, and how you went about lobbying this issue?
I think the important thing of mandatory membership is a very easy one. Right now, people can voluntarily decide not to belong to a medical scheme and come onto the schemes when there's a necessity. So there's a huge component of young people that totally avoids it. And if you look at the demographic profile of medical schemes, the age 20 to 30 is often when they jump off medical schemes, where they no longer depend, or should I say, they're not kept on as a dependent of medical schemes, out of it when they're advanced and potentially come back onto the scheme when they need benefits. I think the issue of risk equalization is a come see, come saw. There's membership within the BHF that are for it, and many that are against it. Now, I'm neither for it or against it. One of the big problems is you need to ask yourself a question: why is it there's not a single formal report published since risk equalization research has been done? There has been some reports that sort of describe it in high levels. Some people are going to have 5%, some 10%, etc. But there is nothing published in terms of this scheme will contribute this much extra. One of the big reasons why we keep asking the question is, what is the impact of risk equalization? Is that the analysis I've conducted is that over the year 2000s, we tried to promote lower income members who were predominantly blue collar workers to try and attract them into the scheme environment. And our view was, because they're young, healthy, potentially the schemes they belong to would end up becoming net payers in the risk equalization system. And we didn't think that would be progressive, that schemes that attract low-income members, blue-collar workers, become net payers into the system without having corresponding income protection, the so-called tax reforms, etc., that were supposed to come in. Unfortunately, that lagged a lot. Right now, we do have income protection in the form of tax credits, but I don't think it's enough. The government only contributes in terms of the tax credits to a value of 16 billion rands compared to about 150 billion rands we're going to be collecting in contributions at this point in time.
Thank you. So actually what you say is, in terms of the risk equalization issue, you're not an effective lobbyer because you're split in yourself. There's no real hard point of view that you represent as BHF on this issue.
I think there is a view that we need it, but I'm of the view that we need to do a lot more research in it. Right now, although we got the tax credits in place, I'm not sure there's sufficient research done whether the tax credits is sufficient to implement it. And I think we need to do a lot more research in that regard.
Thank you.
Yes, can I add to that? What also kind of was a game changer is government coming up with national health insurance in 2009. Because that trajectory of REF and mandatory contribution, had we followed on it, the assumption is that we will arrive at something else. Now, the government leapfrogging it to an NHI dragged us as BHF and membership to focus on how this NHI is going to address some of these issues. And as you mentioned, the lobby part of it was then to engage government at various times on what our views are on this NHI and how this NHI We then begin to address some of the issues that maybe mandated cover would address and REF would address.
I understand. Thank you. I'm rushing because I want to give my colleagues the time to ask as well. You just confronted us with a well-functioning capitation system, isn't it? A capitation system that works the way it should work. It splits risks, but also it incentivizes the partners to do their best and do their utmost in. Now, Dr. Patel, you were present when the small dental organization presented their case. They presented the case also with an alleged capitation system, but the capitation system didn't function between the providers, being the small dentists that were working in rural areas and in suburbs, in poor areas. But the capitation system worked between dentists, the information system, or the network in this case, and Bonitas, in the sense that Bonitas was, just for the audience, Bonitas was granting 28% cost of administrating a network to dentists, and on top of that, everything that dentists would be able to recoup from the 300 million rand that were reserved for giving dental services. On top of that, so what they could cut back on that 300, they could also keep. Now I'm being informed that that is actually not the way the Medical Schemes Act works. This mechanism is not a proper capitation system, but it works as a sort of reinsurance mechanism. Now I learned from your submission that Dennis is one of your partners in your, and it's a very difficult name, in your healthcare forensic management unit. Dennis is a member of that. The healthcare forensic management unit tries to find out where coding, for example, is being done in a fraudulent way, or where mismanagement or misconduct can be sorted out. Does this also, if the system, and you heard about the system, and you were there, Dr. Patel, does this forensic unit also look at the conduct of members?
That's a deficiency of that unit. Yes, we mentioned it in our submission in terms of HFMU. We're reviewing the functioning of that unit totally because it's one of the issues that's deficient. Coming up to the Dennis issue, yes, they follow up fraudulent issues. In fact, towards the end of last year, one of the persons who was working for Dennis and as part of the HMU presented data where they followed up the various practices of dentists and the various fraudulent claims that were associated with it, and went on to even interview the people that were on the receiving end of some of those procedures, and found significant fraudulent activity related to that.
Maybe I'm not, you forgive me, I'm from a faraway country using a different language. Did you say that you are investigating what the contract that Dennis entered into with Bonitas and how it works out in relation to the MSA?
No, we don't.
You know.
We don't get involved in interviewing and investigating various contracts between various organizations
of
and
your own
games. Yes, no. We are at the very periphery end where we just on the receiving end of the events that occur, but not the actual contract.
But you would not apparently be happy if your members would enter into contracts that are in contravention with the Act.
In fact, we would like to go in there. That's one of the things that we want to review, that right. HFU, the activities thereof must be lifted to look into that.
All right. Thank you very much. Dr. Patel.
I think if I can answer that question, I read through their submission. They, I think, made it on Thursday, and they gave me the submission. I read through it over the weekend, and yes, to some extent I'm concerned because it looks like the margin that's made in there seems quite significant. And obviously the question that needs to be asked is how is this costing determined, etc. One of the important things is we heard one side of it. I haven't yet spoken to Bonitas to get their views about it and to look into this a lot more deeper.
Right.
One of the things that was asked is, what type of arrangement is this? Is capitation or not? This is actually one of those that are described as a risk transfer arrangement.
That's right.
So you determine what your risk in dental is and you pass that on to someone else, and that person take on the responsibility. If they manage the excess, etc., and the surpluses, it remains with them. But the important thing that needs to come back to is, do medical schemes have adequate governance to make sure that the access to healthcare actually takes place?
You do understand that the panel would be very, it would be good for the panel to hear what your investigation found. Now, of course, we're not in itself interested in a particular case. We're interested in the fact that these cases might occur within the South African system and not being dealt with. I have just one, to my mind, a very important issue to deal with, and that is, in your submission, you went into great length, maybe you remember it's a year ago, where you wrote about the HPCSA ethical rule forbidding doctors to be employed either by hospitals or by schemes or administrators. On the hospital side, there's some understanding on your side where you say hospitals are for profit and might compromise the conduct of doctors. On the other hand, schemes are not for profit, and there's not such a strong case in those ethical rules to forbid for the HPCSA to forbid doctors to be employed by. Why is it important? Is it also not the word forbid. I try to find. I can try and use the Afrikaans word because I'm Dutch. But it also doesn't allow for health maintenance organizations to start developing in South Africa. As we know, in the United States, this development took place when government stepped in, also broke actually resistance of doctors and ethical rules of doctors, the AMA in the United States, which eventually after years of struggling and battle, resulted in, I think now at the moment, HMAs covering 80 million, roughly 80 million members, and introducing a real new competitive dynamic in the industry, especially within the hospital. Kaiser Permanente, obviously a very famous example. And actually, I sort of answered my own question, I think, because I thought I'd recap it for you because it's a long time ago. Can you go into that subject and tell us what the position of BHF on the subject is? And secondly, would there be, do you have any clues or indications that there would be serious investments by schemes in health maintenance organization type initiatives in South Africa if the ethical rules of HPCSA would be set apart?
Chair, let me start with it. I'm very passionate about this concept that you're talking about. I'll look at it from the perspective that not-for-profit entities that provide service always do it for a good reason and consider healthcare service as a public good. Certainly in for-profit environments, there could be certain influences to bear, and I know currently medical schemes have a negative perception, and maybe there's a view that might not necessarily provide care. I think medical schemes exist to actually do good for their members, and what I actually hinted in my presentation, that the description of medical scheme allows medical schemes to employ health service providers. This is a legislative member. Now, I'm not a lawyer, but my understanding is there's a hierarchy of laws, starting with the Constitution, legislation, regulations, and ethical rules. Now, in terms of that hierarchy, the Medical Schemes Act, empowered from the Parliament, says medical schemes can actually employ service providers and provide services. The ethical rule is sort of 2 levels below from HPCSA. And in this context, I'm saying ethical rule doesn't really apply. Medical schemes want to go ahead, they can go ahead, they've got statutory power. It would be a nice courteous thing to actually tell the HPCSA what you want to do, why you want to do it, how you're going to go about it, and actually invite them to come and see how you're going to be running your operations, etc., so that their concerns about potential perverse practices and perverse influence of the service providers is allayed, their concerns are allayed. I'm totally supportive of this because then you take away that middle profit component kind of thing that the current service providers get. You take that out of the system. There's monies available. Currently in reserves, we have 47 billion rand sitting there and actually earning less interest than this medical CPI. So every year that money is sitting there, it's actually being eroded. I would like to see a lot of that reserves either given back to the members in the form of review of the 25% reserving levels. Alternatively, take that money and become service providers yourself. And translate whatever efficiencies you can extract from the system and pass that on to the members. And I would like to see that system actually working. It can work very well in the South African environment in local settings. For example, the Sasol medical scheme, the Mercedes-Benz medical scheme that's linked more to in East London, Secunda area for Sasol Med, etc. I think it can work. I know that there are 2 medical schemes that are involved in some form of service delivery, such as Samu Med, and we heard from the Optometry Society that Platinum Health or something like that is involved in optometry care. I'd like to see a lot more of this taking place in the environment.
My second question was, and I'll stop then, is do you have, apart from these 2 sort of minor initiatives, is there really serious intention by schemes to do that? And if that, why haven't they gone to court and challenged the legal issues around it?
I'm not sure which gone to court issue you're referring to.
Well, if the CMA supersedes or trumps the ethical rules,
okay.
Then it would be a simple case for a lawyer for a judge to have a look at that. But then, of course, there has to be someone that is interested in the outcome of this case, and there must be a larger scheme interested in starting up an initiative like this.
I hear what you're saying, and I think that will be valuable. I think the major thing here that we must not downplay is the absence of the cap. Because let's say, for instance, a scheme, I decide to go that route. So what's the end point? I'll have all of that in place and what have you, but I'm still chasing what the providers are charging. I may have internal constraints and controls in terms of how I control but I can't control what they're doing. Whereas if there was a cap in terms of what they can charge, then I move backwards and see how I can control issues internally, but there's a certainty in terms of the cap.
Sorry, and then I'll stop there. But if you employ doctors, the cap doesn't apply anymore, is it? You have an employment situation with your doctors and you deal with the salaries.
I think, yes, you might be able to employ doctors, etc., but can you own hospitals? And right now, there's a lot of hospitals out there. There's perhaps overcapacity in many of those areas. And the question is, yes, you can employ doctors to provide that primary care service, maybe some specialists in your network, etc. Those that are not in your network, you can have some kind of contractual relationship in that. The question is, when they need hospital care, can we afford to have sufficient hospitals in that environment that we own and control and bring in the efficiencies? And I think some years back, one of the big suggestions I had made is that maybe we need to take some of this money and actually plow it in the quaternary level and tertiary level of the public sector, where we use our reserves to actually beef up the public sector, the infrastructure, the services, etc., and we then make the public sector a better competitor to the existing medical scheme environment, and we use our reserves for that purpose.
In fact, may I add, even if I were allowed to employ doctors, doctors may decide we don't want to be employed by you. It's the same thing that we're experiencing with the designated service providers. The DSP arrangement is not obligated by law. So yes, for schemes to mitigate their PMB Regulation 8 issue, they can go into DSPs, but there's no enforcement of DSPs. In fact, you heard from the presentation of Sama and the cardiologists that it's better for them not to be part of a DSP, because on their own, they can charge what they want to charge and the medical aid has to pay. So there's no incentive for me to be part of this. Similarly, there may be no incentive for me to allow you to employ me, because I can be on my own and I charge what I want to charge and then you have to pay me.
You saw the solution the American government found for this. And they, well, Dr. Patel can tell you, is that they obliged employers, big employers, to also put on their list and health maintenance organizations. So they sort of indirectly regulated for that. But thank you. I'm done, Judge.
Thank you.
Thank you, Dr. Zakufa and Dr. Patel. I have 2 questions. One is on information asymmetries, and the other one is on CMS. My first question is on your written submission. You do acknowledge that there are considerable information asymmetries between medical scheme members and the medical schemes, and you attribute this to the existence of PMBs as well as lengthy benefit packages. I'd like to know, given that you represent medical schemes, what initiatives have you introduced as BHF to help medical schemes help their members understand what they are signing up for? Because I note that on Dr. Patel's last remarks was that trustees exist not to deny members of benefits. I don't know if I should ask my second question on CMS now, or you want to address that first?
The answer to your question is that we haven't done enough there in terms of that. And I think we need to do more when it comes to that.
Could you give us examples of how you've...
We haven't done much there.
Oh,
we haven't done much there because our obsession and mindset has been looking at healthcare costs to 90% of the way, rather than looking at exactly what you're talking about, which is important. So admittedly, we haven't done much there.
The area of quality of care I'm very passionate about. And to me, one of the things why I am putting emphasis on quality of care here is I want the public to know exactly what they're buying. And not just to assume that when they go to a private sector, everything is hunky-dory and you're going to get the best of service. What they need to understand that there's problems of quality in the private sector. Yes, the Minister has admitted that there is in the public sector. And actually start interrogating what value they are getting out from the medical schemes as well as from the service provider. And it is for that reason that BHF will on an ongoing basis try to promote this whole thing of understanding what is the value that you're actually buying with medical scheme contributions. One of the things that BHF does in its trustee training is a presentation that I do, and it's called Assessing the Value of Medical Scheme Contributions, where I try to ensure that medical schemes start understanding that you collect, in this case, 140 billion rand. Do you go to your AGM, where you not just rubber stamp the financials and do the elections? Do you use that as an opportunity to present to your members what you bought with that contributions? What value have you added to that? Do you go to the employers who plow in billions of rands in subsidy? And the employers are for-profit entities, yet they're putting billions of rands in healthcare. Do we go to them and show them what value the employer is getting out of the billions of rands? And this is some of the exercises that we are doing, but as Humphrey said, maybe not enough, when we need to do a lot more of it. And maybe work not just on our own, but more with other stakeholders that have similar intent and try and actually maximize this.
Okay, thank you. Again, in your written submission, you talked about the important role that CMS plays in terms of determining medical scheme benefits, income and expenditure. However, it appeared as if you were of the view that it does considerably interferes with medical schemes business, as you stated it. So, for instance, you stated that it regulates by circulars. So, I would just like to get more from you on that.
Yes. We have various meetings with the CMS on various issues. From our side, the first concern we had with CMS is when we're following up the PMB Regulation 8 issue, the communication maybe was not good enough to understand where we're coming from. Because the PMB Regulation 8 is a problem and still is a problem until it's solved. It's saying pay for PMBs in full. The circular from the CMS is saying that payment in full means on invoice, whatever the provider charges. We then say that can't be right. That will be reckless spending of membership money. And the Board of Trustees are not there to recklessly spend membership money, where I pay the provider in full whatever the provider charges. So we're not against paying for PMBs in full, and that was the interpretation, that we're against paying for PMBs in full. We're not against that. What we're against is to pay whatever the provider charges. Therefore, CMS, together with us, must insist on there being a regulatory framework that will inform the provider how much he or she should charge which then obligates the medical scheme to pay in full. So there we didn't see each other well. And then when we pursued this thing in court, then they threatened our membership not to support us financially to pursue this thing. And again, there was a mistake there. When we went to court, we were seeking a declaratory order. We're not taking CMS to court. We're not taking healthcare providers to court. All we're doing was saying the interpretation of Regulation 8 by the regulator is that you pay the provider in full whatever the provider charges. To us, this is a problem. And there were also other interpretations of Regulation 8 from other senior counsels which were different to the CMS interpretation. So we said we will then go to court to find out what the correct interpretation should be, that declaratory order. That's why we went to court. And then we went to the minister first and said, Minister, well, and then Minister said, go to court. I would like to get that interpretation myself so that if I have to amend the regulation, I'd find out. So we were surprised when we went to court. We found that the regulator is there fighting our case instead of supporting us to get some kind of explanation when it comes to this, because I thought that would be easy. But unfortunately, as you know, in terms of events, we didn't get that explanation. So it's on that basis that we feel that at times the relationships between ourselves and the regulator are not supposed to be what they are, and maybe it's attributed to not communicating some of those things correctly.
Dr. Patel, Dr. Zakufa, thank you very much. I have 4 questions. The first one relates to the data that you presented on costs over time and the decrease in costs related to medicines after the SEP. Is that data from claims?
Yes, the way the data is put together with the medicines, it's the reduction in the claims when it comes to medicines, but outside of the medicines used in hospital.
So what I'm concerned about is what we do know is that there's been a lot of transfer to patients in terms of out-of-pocket payments. And so it's all very well saying from the claims data that that medicines have decreased. But my question is, do we know that in fact simply there's been a transfer to patients and there's in fact medicine expenditure has not decreased, but rather it's being paid out of a different pocket, not out of the medical scheme pocket? And if that is the case, then we have seen a failure of the SEP in terms of bringing down costs. And then the question comes, will regulating the others see a similar transfer of costs to greater out-of-pocket payments? So how are we so confident that price regulation is going to work? That's my first question.
We do not have data that clearly indicate that transfer, and it possibly exists. I think one has to look at it deeper. When we look at that. If that is happening, that then makes us even wiser to say you can get the water bed effect, which is basically what happened here. So the water bed effect in terms of the data that I showed, it showed the increase in hospital costs, increase in specialist costs, and it might also lead to exactly what you're talking about. So while we're saying there has to be regulation, that's the first domino to fall. But associated with that, we need to have all these other interventions to prevent the water bed effect. And that, to me, is the lesson coming out of the medicine pricing regulations. We cannot deny that based prima facie, in terms of what we see, there is a drop. What we may not be sure about is like what we're talking about, that it popped up somewhere else. And in fact, to support what you're saying, overall during that period, the healthcare cost didn't come down. Yeah.
My second question is trying to understand better what BHF does and how you manage it. And to try to explain what I'm struggling with is you stand up in front of us and say to us, it's a misrepresentation to say that costs are driven by demographics and disease profile. Yet, I can't tell you how many of your members have presented us with exactly those reasons. And so I think to myself, okay, so there's this organization that represents people, they say X, the others say Y. There's another issue that's come up, is that in your membership you have both HMOs and administrators and schemes. And Dr. Patel, you explained, or Zakufa, I can't remember who said it, that HMOs and administrators were agents for schemes. But it seems to me that we've had a lot of evidence put forward to us around principal-agent conflict. Questions, the Bonitas example is one of them, about quite where any of the potential advantages that you have from an administrator, potentially economies of scale, or an HMO in terms of cost saving. Where have we seen the feedback to schemes, but particularly to members? We have not once, over the period of time, seen membership fees going down. So if these are agents that are supposed to be managing things, either there has to be efficiency and better quality care. Well, if we take the information we had from members and the breakdown of trust between members and their schemes, it doesn't seem there's efficiency. It doesn't seem there's been better quality care. Of course, these are anecdotal. We don't have the total story. But then there hasn't been that. And we haven't seen prices coming down. So how do you, as an organization, do something that addresses what appears to be a principal agent problem in relation to these people? And there are other examples of that. The complexity of the offerings that they provide. You know, I'm not clear. Are you representing schemes? Are you representing the scheme's members? So, for example, well, I think I've given enough examples to try to explain, what do you do? How do you manage that? And who are you? And what are you doing?
I'll answer the second question, and Rajesh will answer the first question. BHF before 2009 was an organization that only represented medical schemes. So administrators and managed care organizations could be part of the organization, but as associate members, not just full members. What became clear in 2009 into 2010 was that maybe we're looking at one side of the coin and we're looking at the other side in terms of addressing the issues that the private healthcare funding industry is faced with. The feeling was then we need to change the Articles of Association to include the other players as well who are involved in the private healthcare funding. What was very common there was medical schemes within the BHF, when they were only members, they would raise various issues that they have with regards to various issues with healthcare costs and the rest. And the arguments would take the shape of saying, well, that's the administrator and we need to deal with the administrator. So, okay, fine, why don't we bring the administrator on the table as well to be a member? Why don't we bring the managed care organizations on the table? So in 2010, 2011, the BHF environment then became that one where the players of medical scheme, administrators, managed care are there. Together, in terms of what we are, is to then look at the issues that are affecting the funding industry from all sides. If I'm a scheme and I've engaged you as an administrator, what are the issues that have to be at play? And I'm engaged in managed care, what are the issues at play? And then if we have to address a particular issue with the regulator, address a particular issue with the government, address particular issues with the various stakeholders, how do we together begin to address that issue? Not only from a perspective of the scheme, but from the perspective of all the players that are there. Now, that has only been in place since 2011. This is now 2015, so it's a trial period of about 4 or 5 years or so going through that. And I hope that with time it will become more consolidated and maybe find more convergence and maybe traction. But that's the thinking and that's the model. So BHF is that organization which is housing all these people in one environment with the view of addressing the private healthcare funding issues as a collective with various stakeholders.
I think the first question that you asked about BHF talking the demographics is not a major driver of costs. I think I can blame Christoph for that. And CMS's ITAP committee. Council for Medical Schemes established a ITAP committee, which is an advisory committee to the Council of Scheme made up of people with technical expertise. And one of the major functions is to do a lot of research in that environment and then share that between the stakeholders with the Council for Medical Scheme. One of the subcommittees actually looked at what the drivers of inflation actually are in the healthcare environment. And besides just the tariff component, we look at some of the additional things that contribute to the cost. The demographics was about 1.4%, and Christoph is going to be presenting with BestMed in the next round. We can actually ask him to elaborate a lot more. And that is the basis that we're actually saying, that demographics, yes, it is a component, but it only contributes a very small percentage of the big driver of costs. The biggest driver of cost is actually the base cost of services that are being charged. And yes, everyone focuses on that inflation component. And they're saying, demographics contribute a lot, etc. Just describing the inflation. Very few people talk about what is the base cost and is that the right level of cost. The issue of medical schemes and managed care as agents of the scheme, I think goes back to the definition of what is the business of medical scheme. And as I said, it's a very financing vehicle, which essentially says collect money, pay money, in between save money. So one of the biggest mandates, obviously, to the administrator and particularly to managed care is I give you R1 million, make sure I get my £2 million in savings. And inevitably, what does happen is some administrative hurdles are put in place to make sure that the patients access the absolute benefit they are entitled to. And yes, it might be through pre-auth case management. I'm going to use a typical example. 3-4 weeks ago, I was twice admitted in hospital. One of the pre-authorization was done with a code that describes thromboembolic disease unspecified, which is a I-80.9. The claim came with the actual ICD-10 code that related to the disease, I-80.2. Irrespective, the I-80 shows it's a PMB. But because there was this discrepancy between I-80.2 and I-80.9, for 3 weeks the claims were being rejected and not considered. The answer we were given, there's incompatibility between the two. And it took me 3 weeks before I could appeal to the CEO of the organization and say, hey, we need to solve this problem. Before the afternoon I was told the claim is going to be paid. So to some extent, in the quest to try and minimize abuse of benefits or making sure that patients get the right benefits, to some extent, administrators managed care introduce certain rules to ensure that the patients access the benefits that they're entitled to. And unfortunately, some of these rules do limit the access to those benefits. And that is to some extent why medical schemes are seen in a bad light. It's not the intention of schemes to deny benefit. If there is a benefit that's created, members should be able to access it. But the agents often, in trying to mitigate unnecessary risk, introduce certain rules that do hamper access. And some of the noise that comes out is a consequence of that.
It does seem to be very complex and does raise the question of whether trustees are doing their jobs. The other point in your presentation that I was interested in was your notion of the breadth of benefit being as wide as possible and the depth being related to affordability. So there are a few questions around that. There are many ways to interpret that. Poor people get less, rich people get more. Who decides? What do you mean by that, and how do you imagine that working?
Simple. The countries, if we look at the National Health Act and look at what Mr. Mandela did on, I think, 1st of June 1994, ensured that primary care access to all children, reproductive health is available. That got included in the National Health Act to some extent. However, the government policies promote primary care. And that's essentially what I'm talking about. When people get ill, one of the important imperatives is to ensure they have access to the first-line care, irrespective of the diagnosis they have. And then once you look at them, provide them the consultation, the investigations, the essential drugs, etc., if there is complexity, then you can look at what can we afford and how much of benefit can we offer them. At the end of the day, in the scheme environment, if affordability is an issue, there's still the public sector where we could refer to if we need to, etc. But it's more talking about primary care should be the base of the prescribed minimum benefits. It's like in any context, the best analogy I often use of describing this prescribed minimum benefits is you get a house, it's made of 3 walls, maybe mud, you'll get a roof that's 3/4 with tiled roof, but it doesn't have any foundation. And that essentially is what I would describe this current PMB as. Whereas what we need to do is to ensure that that base of primary care is there and ensure that there's some referred benefits, and how we structure it is a bit complex, but the base primary care must be there. And then we look at how we can afford access beyond that.
That's what I don't get about what you do. With the schemes, part of the problem that's driving the costs is hospitalization. Those same schemes are designing benefit packages that promote hospitalization. So what do you talk about when you get together if you aren't discussing restructuring the benefit packages? It's within the scheme's powers to do this.
I think the important thing is to look at the prescribed minimum benefits, and that is why in the one slide I talked about how expensive it's actually getting. And the fact that it's hospice-centric, if you look at various marketing studies that are done out there, what do the members want? They want hospital care, oncology, and spectacles. Those are the major benefits, and specialized dentistry. They're not interested in primary care, etc. And as I said, from 1991, when the Melamed inquiry came out, the emphasis was about catastrophic cover. That's what must be funded. Day to day is discretionary expenditure, but how do you have discretionary expenditure when there's so much of information asymmetry out there? Part of the thing that BHF has been doing is promoting in the whole process, right from the day I joined BHF, that was around 2005, I've been rattling the noise to say the current PMB benefits is actually nonsensical and shouldn't exist. We need to change it to one that's actually primary care, that's aligned to government efforts, where you address the basics of healthcare. Because if you keep providing hospital care and you don't do the basics that I showed you, like what happens in high blood pressure, inevitably you're going to be caught chasing your tail all the time. We need to get the basics right and make sure the foundation that's laid is a solid one. And on that we can then build on what we need to do. Because if you provide proper primary care, the admissions are going to be less. In any medical scheme, if you look at the hospital admissions, maternity is at the top of the list. Pneumonia and gastroenteritis is in the top 5. Now, to me, sort out maternity. Why is it sitting at 72%? We need to address with the professionals about the profession. They actually submit that as legitimate medical indications. Pneumonia and gastroenteritis, to me, these are highly preventive and avoidable conditions in this environment. If you look at the flu vaccine in the elderly, it's sitting at about 18%. If you look at the pneumococcal vaccine, it's like maybe those, we talk about it once in a lifetime, it's the elderly. It's absolutely not taken up at all. And if you assume that elderly live 10 years after that, potentially 10% only end up getting that vaccine. So people are not thinking in preventive. In 2010, 2011, BHF developed a preventive care package and recommended to the industry that everyone should cover this, because if you're thinking preventive, you might be mitigating the risk. When the government came out with circumcisions should be encouraged in the elderly, BHF didn't just go and say circumcisions for the elderly. We said, if you're going to pay for circumcisions, pay for it right from birth, irrespective of religious reasons or otherwise. Because if you're doing it for religious reasons, potentially in 20 years' time, you'll end up getting the benefit because of the risk that will be lower, etc. So we have been promoting it. BHF has developed an essential healthcare package that's got the primary care component in. The referred care, it focuses on what I would call the priority conditions in the country type of thing that we must address, and the additional components. Laying on the foundation that, at least in this country, we have the public sector, we will cover that, full stop. And we must pay the public sector money. I'm of the view we should take some of our private sector, pass it on to the public sector, beef it up to the point that even the referred care we can actually send there. Primary care, let's do that well. If you look at all the DSP contracts that we have, there's very few that are linked to performance and quality. Most of the DSP contracts that we currently have, even at the primary care level, are price contracts. And there's, some of those price contracts are promising to pay 400 Rand consultation, 360 Rand consultation, but there is no checks and balance that those GPs deliver the value that you want at the end of the day. And this is why BHF is quite passionate about promoting this quality and passing on the information, even to the practitioners, and sharing with them. We tried the HPCSA, but we haven't been successful even sharing this information with the HPCSA. they haven't been to a single HQA presentation showing the quality of care that's out there. So that gives you a sense of the kind of hurdles we face and uphill we face in trying to address the problems that are out there.
My last point is not a question, it's just a request. In your documentation that you've provided for us, you've discussed rebates on devices, which you say is ongoing. You've discussed people leaving after their benefits, after they've used the benefit for which they've joined. You've discussed the change in hospital price after the introduction of SEP. And really what we require is documentary evidence around this rather than claims. And so if you have that evidence, we really would appreciate having it to hand.
Discussion with some of the people in the technical panel, and in those exchanges we did provide the additional information at that level.
Thank you. There are issues, let's just say quality at hospital level, fragmentation of healthcare. What do you think of hospitals and professionals coming together under one representative association?
The problem here is that, to answer your question, do we really, are we departing from the same point? And I don't think we are. And then are we looking at the same goal line? I don't think we are. Having those professionals in one group and what have you is a good idea, and I would support it. But it has to be within the context of us having our eyes on the same goal line. And that's where the problem is. Is the issue, for instance, is the issue taking good care of this person to the best ability that we can? And in doing so, we adhere to what is generally accepted as good healthcare practice. And in doing so, we don't incur unnecessary costs. And in doing so, we promote the dignity of the person. Is that the approach? Vis-a-vis an approach, this is a case where I can maximally increase my revenue. And I'll behave and I do things in such a way that I get that revenue. And it happens to be a PMB. And then the schemes have got 40 billion rand in reserves. That money is for health care. I must get that money. And this patient has made contributions, and I'm going to treat this patient in such a way that I maximally benefit from that. That's a different goal line. And for me, there has to be a system where we're looking at the same goal line. And unfortunately, with all the statutory councils being there, in terms of the healthcare professional behavior, it is not whipped into looking at it from that perspective. And therein lies the problem.
Yeah, I mean, that's one way of looking at it. But the reason I'm asking is because I just want to go back to the structure of the PHF. And I'm battling to understand how that can be good for industry to have two players at different levels of the healthcare value chain sitting in under one association. I'm talking about medical schemes and medical scheme administrators and managed care. Because as a panel, one of the things we need to look at are market power dynamics, and this is now in general at industry level, but also specifically the power between the medical schemes and administrators. Now, how does BHF play that? Because inevitably, at some point, if you have a client-supplier relationship, the interests at best may not be aligned. At worst, they may be directly in conflict. Now, how does BHF navigate its advice for its members just around that issue?
That's a big challenge for BHF. And I cannot say that BHF is handling that well, but it's a big challenge for BHF. If you were to be a fly on the wall when we have our board meetings and other subcommittee meetings, you will understand what I'm saying. Now, I take a point that maybe what we have as a model is not the ideal model. And that would be for the board of directors really to look at. The thinking behind putting everything in one basket was saying, how do we align our thinking in such a way that we can achieve what is to be achieved rather than sitting in different camps and play the blame game? How do we come into one and do that?
Sorry, Dr. Sokufa. I think the threshold question here is, firstly, is there a potential for a conflict of interest? If the answer to that question is yes, how do you deal with that? I think that's really the essence of the question.
The conflict of interest part of it, I would admittedly say, is not something that primarily is handled at BHF level. It is handled primarily at the level where the medical scheme engages the administrator, and we don't get involved with that process. So it is for the medical scheme, in terms of their SLA or whatever agreements, for them to put it together in such a way that they can have that conflict. The potential conflict that is there is that one party is for profit and the other party is not for profit. Now, what is also not to our purview is the contents of those contracts. Like, for instance, what are the various incentives that the medical schemes would give to the administrator built into the contract? Are those incentives related to good healthcare outcomes, or are those incentives related to cost saving and not necessarily translating to healthcare outcomes? We don't have that peer review. By the time they come to us to be a member of BHF, we assume that that part of it has been cleared at the level of schemes and administrators.
Yeah. Sorry. If I could just comment, one of the advantages of having both under the same umbrella, and yes, while there might be some conflict of interest in what Humphrey has talked about, one of the advantages I found is in the context of self-regulation. When complaints often come to BHF and land at my desk, because we have this association where the administrators or managed care companies are part of our membership, we're in the position where we can actually intervene with them. Whereas if they were part of another organization, maybe less easy or difficult kind of thing to deal with those issues. And over the years, many of those complaints that have come through, we've actually dealt with it. So, it doesn't go through those various type of appeal processes, lawyers, etc., that takes place and going to council, etc. Often internally at BHF, we can solve some of those problems. Like some complaints come through, medical scheme hasn't paid much stuff. I would look into the scheme's benefits. I would look at what the administrators are doing and actually engage with them. Last year, we came across one of the administrators that never paid for the cholesterol for high blood pressure. It took me almost 6 months to intervene with that administrator, but in the end, there was an agreement that this is actually part of the benefits, and that got put into place. So that's just one example of some of the advantages you have, that you're able to access the administrator, managed care company, etc., not just for the intervention, but also for the information that you need. In making the submission to the hearing, by having the administrators, managed care companies as part of the BHF stable, I was able to access some of this information that I could have presented to this inquiry as well.
Okay. But I still think that my concerns are certainly at a much higher level than what can be resolved by the board of directors of BHF. And I think they're slap bang in the middle of competition issues. For example, a lot of submissions say medical schemes have got way too much power. Many as well say administrators have way too much power. Now, doesn't BHF provide that unfortunate forum where this separate, if you like, power by these two separate players is consolidated under the Board of Healthcare Funders? And unfortunately, if that were to be the case, it's obviously consolidated against the providers. That's why I started by asking, would you be comfortable if also the providers came together under one association? And I'm getting a sense, you're giving me answers that are not different, that are not the same, depending if I'm asking on the funding side or on the provision side.
I think Dr. Bengu, you're right, that potential exists. I can't defend that position, and it's something that we have to look at. I will also add that the other players are also under one roof. The private hospital grouping is under one roof, all of them, and some of the specialists are under one roof, as it is. So if the argument is too much power concentrating in one area from the funding side, and potentially there being a lot of power because of that, I would argue it's happening even in other areas. And if that is a problem for that to be solved, I'm not the one to say I will not support that.
But at least we agree that there's reason to look into it at least.
Yep.
Now, what were the reasons for the schemes needing to be designated non-profit entities?
I don't know. I guess I don't know whether Dr. Patel knows. Maybe the CMS regulator may answer that question and give you benefit answers. All I can say is that the way medical schemes are, as prescribed in the Medical Schemes Act, and what the regulator should do, emanates from government policy, not corporate entrepreneurial ideas. So,
but is it reasonable that it may have been along the lines of the mutuals, as insurance used to be, that it belongs to the members? Now, does this BHF arrangement not then negate that intention, where now BHF literally treats these non-profit entities the same it treats for-profit managed care and administration companies? Surely there must be something that's getting lost in that type of relationship.
I can answer that. The history of not-for-profit is actually a historical one, which goes over a century since medical schemes first started. Essentially, you need to look at medical schemes as stokvels. That it was employers that started to set it up, collect money, and make sure that you use that money to pay for healthcare expenditure, etc. And that over time continued and translated into the legislative and what Humphrey talked about. It's government policy that they continue to be as not-for-profit entities. When you look at these entities, originally BHF membership was not-for-profit members, and then the administrators, etc., came in and provision was made for them to come in. Critical in the operations is not so much where you sit with the administrators and act collusively to be anti-competitive against providers or whatever. In fact, often you find it's more difficult to deal with the administrators collectively. And one of the key things we talk about is let's identify the non-competitive issues. Example, I kept talking about medical schemes need to be seen as healthcare delivery vehicles, should be seen as one interested in health. So something like, let's draw up a health status report. It's a non-competitive issue. You produce financial reports, so let's draw up health system reports, etc. Even getting them to get to that point of agreeing is difficult because they look at it as, it's my competitive advantage if I produce these reports versus not producing those type of reports. So there is, within the administrators, even at the level under BHF umbrella, there is a lot of competitive issues, but we try to identify what is competitive in terms of your business and profits, what is not competitive in the interest of medical schemes as well, that we need to often look at. And those are the components at BHF we try to work on.
Obviously, probably at some point, the question should be whether, if it's so difficult to get the parties together, if there are conflicts, as you indicate, probably at some point the question should all of these parties be under one roof. Now, two more questions. Is it too far-fetched or is it unfair to ask that when BHF challenges Regulation 8 in court, it's a situation where you take premiums from a member, which obviously get to BHF in the form of subscriptions by a scheme, to actually fight to reduce benefits of the same member? Is it too far a stretch?
It is too far a stretch.
Why?
the approach to the courts was an interpretation of Regulation 8. Is it correct to say that when it comes to PMB, you pay in full on invoice of the provider? Linked to that, the expectation was that if we have to pay in full, linked to the invoice of the provider, what mechanisms are there in place to make sure that what the provider charges is within a particular regulated framework? So our expectation, therefore, when we went to court, was that the court will highlight that deficiency, because that was our concern. So the court would say, for instance, yes, medical scheme, you must pay in full on invoice. No problem. You tick that box. But then the court says, but the Department of Health, now the ministry, must make sure what the provider charges is regulated and reasonable. Those are the two things we expected from the courts. And in fact, that's what the minister was wanting to do. But he said, I may do this, and the providers will challenge it, and it'll end up being in endless cases. So go to court and get an interpretation so that then I can begin to operate it in a better way.
Okay.
Yeah.
No, thank you. The last question here, I just want to refer to your response to submissions, where you expressed concern about a low response rate from some industry players. Others have since responded. James is here. CMS has responded. Some provincial departments have. But I would just like to understand, because there's a very strong statement here that basically says this, non-participation of some players raises some worrying questions concerning the validity of the findings of the inquiry. Of course, we've got to be concerned. We don't want to spend 3 years and come up with invalid findings. Now, of the players that you listed here, I would like to know what the inquiry would stand to benefit from IPASA, the Independent Pharmaceutical Association, and the National Association of Pharmaceutical Manufacturers. I would like to know what we would be missing from not engaging Medicredit and Medisco. So please be very specific in sort of saying, this is what we would be missing and how those parties would help us. Thank you.
I think part of the reasons, even in some of we talked about various funding components kind of thing. Humphrey talked about this issue of Regulation 8, which is problem pervasive through all the medical schemes that complain about it. It would have been nice to see a lot more medical schemes highlighting with their actual costs, etc., what the problem is with Regulation 8, what the experiences are, etc. In the context of medicine, I think the question was raised earlier about whether the regulations on SCP dispensing fee has actually translated into a savings with members, or was it cost shifted, etc. And this is why, and Humphrey also talked about certain regulations weren't fully implemented. And that is why it would be nice to look at what Medicredit and Medisco, etc., who do a lot of this switching, including the hospital claims, can assist in the process of, did you see a cost shifting going into hospitals on medicines, yes or no, etc. And this is why we talked about it would be nice if a lot more players had come forward and presented information that could be actually valuable. And I think at that point in time, bear in mind, we didn't know how this process was going to unfold. Now that you might look at specific areas that you would drill down in, I'm hoping that those players will come on board or get someone to come present information or advise and present more information to be able to understand the problems.
Now, would that also clarify the issue Professor Von raised regarding the rebates? We would get more from that. Okay.
Yes, Dr. Benga, I would say that. Added to what Dr. Patel is saying, we're saying also that in the context of there being bold statements made that we need no regulatory framework in this environment. We need to allow the free market to prevail. and all that goes with it, and questioning whether an intervention from the regulatory perspective would dictate the price. Now, IPASA, NAPM, your medical credit abuse score are very much dealing with pharmaceuticals. And serious engagements with them when the SCP was introduced and the dispensing was introduced and what the experience has been and what the resultant effect is, for them to share that at this level so as to build the case that there is merit in intervening the same way when it comes to other services. And basically begin to challenge the fact that you want to float this along the lines of free market and all that goes with it. In fact, one would even argue we have the problem we have now because we have that very same free market, and we need to solve that.
Thank you. Yeah. Can I raise with you the question that I raised earlier on, and that is the various players on the funding side. You've got the medical schemes. I understand what they do. Then you have the administrators. Then you have the brokers, the managed healthcare organizations, the trustees, the designated service providers. Now, how do these interact with one another? I guess the question really is, why do medical schemes need brokers, need administrators, need managed care?
Thanks for that question, Justice. Yeah. If one looks at the medical scheme, firstly, the scheme has to come up with benefit options, etc., etc., etc. Linked to that, they have to collect money and manage the money. Linked to that, they have to honor those benefits whenever there are claims, etc., etc. In my view, all those activities can be done by the medical scheme. In fact, there are self-administered medical schemes who do just that. Your Discovery medical scheme is a self-administered scheme. SummerMed is a self-administered scheme. Managed as a self-administered. So there is no obligation for a medical scheme not to do the administrative part of it and outsource it. But some schemes choose to outsource it. When it comes to managed care organizations, it's an activity that is looking at the merits in terms of whatever, and that's allowed in terms of the Medical Schemes Act. That also can be an internal situation. So I can argue that when it comes to managed care, administrative, and medical scheme, that can all fall under one. Separate to that would then be your brokers. Now, this is a contentious issue within the BHF environment. We are of the view that we don't see the benefit of brokers. In fact, if one looks at the amount of money the brokers have been getting over the last 5 years or so, it cannot be justified in terms of what they've delivered, because the number of medical schemes in terms of belly buttons has not increased significantly if you align it to the amount of money that they've been receiving. So that involvement of brokers to us is not acceptable, but we don't have the powers to tell the scheme, you can't have brokers and whatever.
You do have schemes who are members of your organizations, right? Now, have you raised this issue with them?
Yes.
And what is their attitude?
It's here and there. It's non-committal, it's just here and there.
I don't understand.
What I understand is, with some schemes, it is to their benefit to have brokers, because that's how they can grow the scheme. And to those schemes, when you begin to challenge the issue of brokers, it's like standoff.
Yeah.
In some schemes, it is not in their interest, really, to whatever view, and therefore they have a different view. So you have a situation where within the BHF stable, you'll have different views around this, depending on where your interests lie.
Yeah. Now, as I understand it, these entities, whether brokers, administrators, managed care, they're all paid from the contributions that members make. Yes. I mean, does that diminish the amount of benefits, the amount of money that can be directed towards the benefits?
Yes, Justice, it does. And as I mentioned earlier, that falls within the category of non-healthcare costs. And the regulator is very sticky when it comes to that. When they review the financials of various medical schemes, they would raise their concern once that goes above 10% and begin to say this, we need to reduce this to at least to below 10%.
The trustees, now, whose interest do they represent?
The members of the medical schemes.
How do they do that? Do we know?
I wouldn't know the details around that,
yeah.
Justice, really.
I mean, do they go out, consult with members, raise those issues? How precisely do they do this?
No idea, Justice, except just to know that there will be nominations and there will be votings, and how that occurs within different schemes and the rest, I don't know. Yeah. And then, of course, there are various qualifications they have to have, and I do know that the Council Medical Scheme, in the amended version of the Medical Schemes Act, which has not yet been processed by Parliament, they try to strengthen that part where the bona fides of a trustee, in terms of what kind of a person you need to have.
I mean, do members of the scheme have access to these individuals? And if so, how?
No idea.
Yes. Okay. Now,
I can answer that question if you. One of the things in the Medical Schemes Act and even in the Code of Conduct, it's absolutely clear that the members of medical schemes there must be information shared with them, what the appeal processes are for any disputes. And that includes going within the administrator, within the scheme, before it ends up with the regulator and the appeals processes, etc. And from the complaints that have come through to the inquiry, it seems that it possibly not being done as well as it potentially should have been done. Just the question when you asked about the relationship between schemes, administrators, managed care, brokers, etc., it's important to look at the history of medical scheme environment. In the 1980s, there were no brokers in this environment at all. One of the things that came in is when administrators were actually carrying out the services of the broker that we talk about. In the 1990s, the brokers from the insurance side started to do some consulting within the medical scheme environment, and part of that function that administrators were hired off to the brokers, that you will engage at the member level and do the information sharing, etc. That's what happened at the broker level. I think also important at the open scheme level, if you look at the history, many open schemes were established by administrators for collection of small to medium companies to get together in an open scheme environment. Historically, it was mainly closed schemes with an administrator doing that work. Then open schemes were established for small to medium companies that cannot set up their own medical schemes. And that's when open schemes came into being.
Now, all these individuals, that is the administrators, the brokers, the managed care organization, then this for profit, right?
They're all for profit.
Okay. So the more money they make, the better for them.
Absolutely.
Yeah.
That's the for-profit motive environment here.
Yes. Now, the designated service providers, how do medical schemes decide who to approach for this?
There's quite a few guidelines that have been issued out there. Initially, there was selective allocation of who could be participating in that environment. And then between Council of Medical Schemes, health profession councils started to issue guidelines. And the recommendation that was there is that you must make contracts openly available to any willing person who wants to participate in that.
But what happens in practice? I mean, is this open to every service provider? Is there a general invitation that's addressed to all the service provider, or is it an invitation? Or is it a closed invitation?
From the limited knowledge I have, Chair, is that at like primary care level specialists, a general invitation is sent to everyone to participate in the TSP arrangement. And obviously, as I mentioned earlier, most of these are actually price setting type of arrangements, and providers are asked to participate in that. And obviously, that's where the willingness on the provider takes place as to whether they do or do not want to contract to the scheme. There have been other contracts in the past, which was, for example, the chronic medicine supply side, where there was a single entity appointed to distribute medicine. Over the years, that has sort of reduced, and it opened up to the community pharmacists to participate to the extent that they do agree with the terms and the pricing that's been agreed to with the courier pharmacies, etc. And I think that has come out in the ICPA's presentation, that the open networks are fine. Their concern is with some of the closed networks. And yes, those closed networks to some extent is not necessarily accepted by even the Council for Medical Scheme or other regulatory bodies that are out there.
Now, you were here last week when Dr. Twala told us about an entity called Dennis, I think it was, where the medical schemes give a percentage to these managed care organizations, which can be as high as 28%. Is that right? That's what he said.
I understand what he said. As I said, at this point in time, I don't know the full details of that contract.
I'm just
giving an example. Yeah.
No, not giving an example, relating to you what he told us on the occasion when he was here. Now, and that they will be given this percentage. In addition to that, they will be told, this is what you have to pay. If there is any surplus from there, you keep it. You had that. Now, is that how this system works? Is this how the system works, where from the contributions of members, some of them are struggling to make ends meet, and then you give the managed care company a percentage for their work, which can be as high as 28% from what we were told. And then in addition to that, you say, well, this is what I expect to pay this year. If there is a surplus, whatever it is, you keep it. You keep the change. Is that how it works?
I think the example that was presented, if those things are factual, and as I said, I haven't looked into that, there's some concern about the margins that the managed care company was making.
Yeah.
I think the context here, we need to understand that this company, Dennis, is actually a registered managed care company. And the EOH has a number of these managed care companies that they do own. The important thing is those are regulated by a Council for Medical Schemes. And I think that's a discussion we should have with them. And they're going to be presenting next week with specific examples if they can look into this component.
No,
are these regulated,
yeah,
yes, no, etc.
I understand that. But I'm raising this issue because you do represent, among other things, medical schemes, don't you?
Sure.
You also represent administrators.
And managed care companies.
You also represent these companies as well, managed care organizations. Now, if what Dr. Twala told us is an accurate description of what happened, what mechanisms, if any, can be put in place to ensure that that kind of behavior simply doesn't occur?
Chair, the first thing I'll say, admittedly, some of these activities that are happening at that level don't come to us. We don't get to know about them. I was also shocked by the Dr. Twala admission and what he was saying. And not only that, I was shocked with the other issues as well that came out in the last 2 weeks. In terms of the mechanism that have to be in place, I want to believe that if the accounting measures of how the finances move are not robust enough to track that money that is being used that way, then there has to be an introduction of such robust mechanisms. I do know that maybe the council, when they present here, that they do get quarterly returns from the schemes that speaks to the financial transactions and all that goes with it. Now, I don't know whether they do pick that up or not in that, and if they don't, then maybe the proposal that would come from me humbly is that maybe we need to have more robust ways of tracking the money.
Yeah. Now, you make much, I think it is, of the provisions of the Constitution, in particular that healthcare services are human rights. Now, what are the implications of that for how we should approach healthcare services within the context of competition law and policy?
I think, Chair, that section of the Constitution, as you know, is giving that mandate to government in many ways. And I think government here has to up the ante when it comes to healthcare services. So far, that has not been very significant. From our side, we have raised a lot of the issues that are our concern. And I must be thankful to the Minister of Health, because it is also through us raising these issues that led to the establishment of this inquiry. So there's a lot that I think the government has to do. The problem here is that there may be an inadequate understanding of the various nuances and permutations of what's happening in the private sector, and very complex. And government may want to intervene, but doesn't know exactly what the entry points are and how to intervene. At least that was the explanation given to us by the Minister of Health, and said, establish a commission inquiry, which you're chairing, to begin to unearth that, so that when we come up with any kind of intervention, it's from an informed position. So that's commendable. The concern I have is then the noise that comes from the interested parties when you begin to do this kind of work. Because now that unearths some of the things that have got direct interest in. And who knows, your findings may actually interfere with that and begin to drift this thing in a direction that they may not appreciate, and therefore make a huge noise and make also statements that are misleading the public and also threatening in many ways, and say some of these interventions are going to deny healthcare, some of these interventions are going to destroy the private healthcare sector, and none of that is obtaining. So the question is whose interest are you really serving? Because in my view, if the interests about the health care of people in South Africa linked to the finances that are there, in terms of what we have identified as problems and need to be solved and solved by government, the establishment of this inquiry is the right thing to do. And if you mean well, you will then come to this inquiry and begin to share everything that you know about the industry, so that the right solution should be there. And less noise in misleading the South Africans when it comes to these interventions.
One of the issues that you have recommended to us, and I think you've repeated that, it is the need to regulate the prices, within the private healthcare sector. Now, how does one strike this delicate balance between, on the one hand, the need to ensure that those who are in the business of providing healthcare services receive a reasonable reward for their services, and on the other hand, ensuring that access to healthcare services, which is not only a constitutional right, but it is also an international human right, is not undermined. How does one strike that delicate balance?
In attempting to answer your question, Justice, I think we need to take a leaf out of other interventions. The petrol price in South Africa is regulated. Now, that's in the private sector. And it goes up and down depending on what is there. Now, the rationale to be able to regulate the petrol price and still keep those who own filling stations in business for them to realize a profit and the rest, one should look at that model to begin with. The second thing is water and electricity. That's regulated in this country. The same reasons for regulating that apply to healthcare. In fact, healthcare is even more important. It's number one, the hierarchy of needs of Maslow. So in this country, you regulate water, electricity, you regulate petrol price. And then...
I thought you would refer me to the obvious example that you were involved in, and that is...
I'm coming to that one.
The appropriate dispensing fee.
Yes. And then, of course, the example of the medicines. As you know, during that time, this was my portfolio in the Department of Health, spent many hours with the manufacturing industry, indicating to us in the Department of Health that coming up with the SCP and everything else here will lead to disinvestment, will lead to business closing, and it will lead to medicines not being available to the ordinary South African public. None of that has happened. And we've come with the regulation. And on the dispensing side, as you know, Justice, the case of the retail pharmacists. They said if you regulate dispensing fee and the rest, many pharmacies will be closing down here and there'll be no access. What has happened? The number of pharmacies has increased. In fact, right now, there's a shortage of pharmacists to run certain pharmacies that are open in certain areas. None of that has happened. And the net effect was that 19% of the medicine prices has come down. Yes, there are still issues that are not on top of in terms of regulation, what have you, but in the main, that has happened. So a leaf has to be taken out of that government intervention when it comes to the prices of medicine, and how you would then begin to intervene with radiology, intervene with pathology, intervene with surgical intervention, your tonsillectomy, cesarean section, bed rate in the NICU, in the high, what does it cost? Surgical fees. As a surgeon, if I'm going to perform this operation, what does it mean in terms of cost? And then I would add, Judge, that you need an overarching body that, like the NICE in the UK or your CTICC in Canada, that would objectively set the standards and norms and say, this is what you have to adhere to. And then you also need another body that has done very sophisticated costing, call it activity-based costing, whatever costing you say, to say when this intervention is done in this area, this is a reasonable tariff associated with it. And based on those two pieces of information, you regulate that and put that into place.
But the National Health Act, Section 90, addresses those issues, doesn't it?
To an extent, Judge, except the regulatory framework.
The only exception is the issue of whether or not it is mandatory. But save for that, it does call for development of norms and standards, doesn't it? Yes. Now, you referred to what you described in your submission as bulldog tactics. This is now where one hospital group threatened a medical scheme with double-digit price increase unless that medical scheme made them a designated service provider for the scheme. And then you went on to say you can confirm that another medical scheme had a 13% increase for 2014 by this particular hospital group, and that this was reversed after the designated service provider arrangement was signed.
Chair, that's absolutely correct.
Now, can we have more than this? Can we have the names? Can we have...
I'll be quite later. I'll get permission from the medical scheme to share that information with the technical team.
Yes, it would be helpful indeed to get to the bottom of some of these issues that you raised here. Now, one of the concerns, and you were here the very first week of these hearings, were the delays in the payment of doctors who complained, disputes over whether or not this particular condition is provided for in the PMB. Now, I understand that medical scheme might have an interest in making sure that whatever treatment is given by physicians is appropriate and that is necessary. But how does one strike the balance between ensuring that patients get the right treatment, which is cost effective, but at the same time ensuring that members get access to healthcare services without delay? How does one strike the balance between these two?
Chair, this is one of the biggest problems with the prescribed minimum benefits. All it does, it describes the conditions that must be covered, and it says it's medical or surgical care. And that's where it stops. And this is one of the biggest problems with this prescribed minimum benefit, is that once you leave it like that and you don't put more definitive components of exactly what you mean by what they're entitled to, is when you start getting the various interpretations of what is included, what is not included, what is cost effective, what is not cost effective, etc. And this is where BHF's view is that the benefits must be defined in terms of services, and that those services become available to any patient as long as it's appropriately prescribed. A typical example, if I've got a headache, I can take a paracetamol. You define that a paracetamol is an essential drug. I can have a headache, I can take the paracetamol. If I have a fever, I can take the paracetamol. If I have something like a cluster headache, I can take paracetamol for a week. If I have osteoarthritis, I can take that paracetamol for a month or on an ongoing basis, etc. And I think this is one of the biggest problems, is that, and I talked about it's poorly structured, poorly defined, etc. And that is the most important thing. Attempts have been made by funders to develop this benefit guides, etc. But unfortunately, if you speak to the industry, they talk of some of those components as this is our competitive advantage. We've done research in this technology, we've applied health economists, etc., and therefore this information of this cost effectiveness is our competitive advantage. One of the biggest things we've tried to punt is the more standardization you have, the less interpretation problems you're going to have, and the more certainty there will be in terms of what patients can access. And this is one of the things that we've talked about. In a revised PMB, it's not just the essential drug list, it's also the standard treatment guidelines that are developed and published by the Department of Health. Department of Health at the moment has initiated the health technology assessment and has called on the funding industry, instead of every one of you doing your own health technology assessment and coming up with different interpretations, let's use your resources at a central level at government, where you can do the one, you do another, the third person do another, and that information becomes pooled in a database and becomes available to everyone. This is the way, the more you standardize, the better you can assure that there's access to those interventions and not subjected to interpretations.
Now, within your organization, how much time, if any, is devoted towards exploring ways and means of enhancing access to healthcare services and improving the quality of healthcare services?
Admittedly, Justice, having joined this organization in 2005, not much has happened in that regard. Also, maybe to add to the response that I just gave to your piercing question, the unfortunate part or the fortunate part is that what has to be achieved in terms of what you said cannot be achieved if inadequate resources are not available to make sure that certain things are in place. For instance, if I am a doctor and I'm operating in a particular area, it is going to be, it's an interference of some kind. If in the process of me trying to treat the patient the best way I know and can, that is influenced by how much money I can make out of this thing or how much money I will not be paid out of this thing. In my view, the system must take that out of the risk in terms of the doctor's mind of looking at that patient. That must be sorted. That when it comes to this case, just concentrate on treating this patient well. Don't worry about anything else is sorted. And then secondly, when it comes to, there are 5 or 6 options that I can embark on as a provider to treat this patient. Let there be a system that clearly tells me, based on evidence and based on research, the best option for you to do is this one. So no trial and error, no playing games here. Just go for that one. And when you go for that one, don't worry about the costs associated with it. That is going to be sorted. Unfortunately, in South Africa, that's not in place. And then, of course, the other part of it, Justice, is to what extent is all of that having been sorted in different ways to create a space for you as a clinician to look at the patient? To what extent is that all protected and controlled and enforced in such a way that people don't play games with that? And for me, this is how I see the regulatory framework operating, to protect that, to create the space for the clinician, to be a clinician. And then the statutory bodies to whom the clinician also come in, to make sure that that clinician adheres to what has to be done. And the clinician doesn't have the excuse of saying, I can't do that the way I do because I've got problems with payments. I've got problems with delays in payments. I've got uncertainty whether I'll be paid or not.
Yeah. I suppose the next question is, how does all of this impact on competition in the private healthcare sector? And this is the issue that we will then look more deeply in the next round when we meet again.
My response to that, in terms of establishing that, competition doesn't play a role. In terms of establishing that, what plays a role there is standards of quality that has to be done, how to create a space and environment, and how that's protected. Beneath that, you can then begin to see how competition can work. For instance, if I can adhere to good quality practice, and that attracts a fee of about 3,000, but I'm so good at it, I can do it for 2,500. That's where the competition comes in. And also the front end of it. If there are 2 or 3 clinicians and I want to make a choice to whom I should go, a lot may depend on the soft issues in terms of how I'm received, the dignity and whatever, and competition plays itself there. But when it comes to what actually has to be done, that's adequately protected, and competition plays a minimum role there, in my view.
Chair, if I could just add to this point.
On that note that you are raising now, we will come to an end after you.
Chair, on the issue of competition, our view is that price shouldn't be the basis on which people compete in the funding environment, in the private health environment. What they should compete on is the quality of care delivered at the different levels, kind of thing. That's where at the scheme level, at the provider level, etc., that's where what must become competitive, not necessarily the price of service. There must be certainty on the component of price of service delivered.
Okay, gentlemen, we've come to the end of your presentation. Is there anything else that you would like to draw to our attention that has not been addressed in the course of this debate that we've just heard? Yeah. Well, on that note then, thank you very much indeed for coming to share with us your experience. And I know that we probably detained you, for more than you would have thought necessary. But these issues are quite important. You will understand that, hopefully. And I did warn you, though, didn't I, this morning? Yes, very well. Thank you. Thank you. Yeah. Okay. The next presentation will be made by, is it Best Med? Yes? Okay. Now, Would it be convenient at this stage to take just a 10 minutes break and then we can come back? Okay. The time now is almost 12:25. Can we come back what time? 22? Can you come back at 20 to 1? Thank you. Okay, very well. Can we resume? Yes, we are ready for. If you would just indicate, just for the record, who you are and who you represent. Thank you.
Chair, I'm Greta Engelbrecht. I'm an advocate of the Johannesburg Bar, and I'm instructed by Adams & Adams and attorneys on behalf of BestMed. I will make some introductory remarks, and then I am assisted here, greatly assisted, by Mr. Christoph Rath, who is from Eggensight Actuaries and Consultants. He consults to BestMed, and he will make submissions to you in line with certain slides that have been presented beforehand that will hopefully illustrate some of the points made in my introductory remarks.
Very well, you may proceed.
Chair, you have had the benefit of hearings over a period of time. And if the press is to be believed, and I think in this case they definitely are, medical schemes are seen as great culprits, and medical schemes are seen as contributing significantly to the woes of those seeking healthcare. Now, BestMed is, of course, a medical scheme. It is an open medical scheme in the sense that its membership is not restricted.
So, excuse me, sir. Excuse me. We have started. Yes, go ahead.
So it is an open medical scheme. It is not restricted to particular employers. So any person who wishes to acquire medical health membership of a medical scheme can be a member of BestMed. It is also, and I will return to this, a self-administered scheme. It is an important quality, as it were, of BestMed that must inform the discussion about its presentation here today. The reason why medical schemes are seen as the great culprits, we suggest, is that those who seek healthcare go to a medical scheme, become a member, pay a fee, and we admit that fee is quite a significant fee. The reason why people do this is that ultimately when they seek healthcare is that they can gain access to it without having out-of-pocket expenses. So they don't generally see the cost of healthcare. It's not a concern of the patient in a general sense to shop around for the cheapest doctor. In fact, it might be the concern of the patient to shop around for the most expensive doctor on the basis that the best doctor must be the most expensive one. There is no interest in the person seeking healthcare to keeping costs down for as long as they are not the ones that are actually paying for the service. And then, if the medical scheme, which is the party that is supposed to cover these costs, then does not cover the benefit in full, they do not get cross with the service provider for charging such a high fee that the medical scheme doesn't pay at all. They get cross with the medical scheme for not covering that cost of their health care in full. The public perception indeed the public narrative that has been also seen in this inquiry is that medical schemes are the perpetual bad guys. They are out to make money by putting up their subscriptions every year, and they are getting stickier and stickier when it comes to payouts. But of course, this perception is one that does not quite tally with the truth. The truth is what happens within the scheme of regulation. Now, the first and most important part about regulation of medical schemes is that they are not for profit. So the notion that medical schemes are putting up fees year upon year upon year because they want to make more money is simply a falsehood. Medical schemes have to put up subscriptions year on year. Why? Because the costs that they are incurring go up every year.
Well, when you refer to cost, Ms. Yangerbroek, you're referring to the amount that they have to pay the managed healthcare organizations, they have to pay the brokers, that they have to pay the administrators.
Well, Justice, there the first important part is, and this is why I highlighted at the beginning that BestMed is a self-administered scheme. BestMed made an assessment for the benefit of its members.
No, I understand that, but what you are doing, you're making a general proposition. So I'm merely responding to that general proposition as opposed to the specific situation of those that you represent now, which is a different matter altogether, because as I understand the position, they administer themselves. Is that right?
That is correct.
Right.
So I'm using the general proposition to lead into the more specific. But the point is this: yes, there are increasing costs related to administration, there might be increasing costs related to payment of brokers, etc. But there are also, and very significantly, and this Mr. Rath will show you in due course, significant increases in costs in that which is paid to the service providers, the healthcare providers. And so medical schemes must make plans about how to curtail their costs. And that is where I get to the example of BestMed. It has made a specific assessment that it is in the best interest of its members to offer self-administration. In other words, it is not outsourcing the administration of the scheme to a third party that has a profit motive. It is conducting that administration in-house, but that does mean that it employs certain professionals that render the services, because the scheme must still be administered. Even though it's in-house, there are certain costs associated with providing that particular function. So that's the first point. The second point, and the question came up earlier with the representatives of BHF, what really is the role of brokers? Well, for the self-administered schemes such as BestMed, the broker role is rather important, because unlike those schemes that have administrators, the brokers are really the people that can be relied upon to bring new members into the scheme. They are a contact point and a marketing agent, as it were, to bring new members in. And I'll return to the cost of that service, but it is important that administered schemes particularly, so when there is an administrator that is separate, and that separate administrator isn't subject to the regulation that there not be a profit motive, various schemes and loyalty programs and such like can be employed to try and get and attract younger and healthier members to a scheme. When you are self-administered, you cannot do that. You cannot have loyalty programs. You cannot have all sorts of schemes within the self-administered scheme to attract those members. So now you start relying on the broker to bring you the custom of the healthy and the young members. Why I keep on repeating the term young and healthy members is a point that Mr. Rath once again will elaborate on. But the point is that ultimately there is a scheme where everybody pays the same amount if you're on the same option. It doesn't depend on how healthy you are. It doesn't depend on how much you will claim or how much you claimed last year, as it is in the case of insurance. Everybody pays the same. And the scheme hopes to attract young, healthy members who, in their young and early years, pay a significant contribution but claim less, so that later, when they get to their old age and they claim much more than what they put in every year, that imbalance is offset. But as you heard also from the representatives of the Board of Healthcare Funders, it is so that people elect against having medical scheme membership in their younger years, and it is only when, for example, they make the decision to have children and they expect that there will be costs related to childbirth, or when they get somewhat older, that they think that they will get a benefit from medical schemes, and it is only then when they join. So they would rather in the younger years make use of alternative healthcare insurance options, hospital plans and the like. Which brings me back to just emphasize the point about brokers. When you are a self-administered scheme, as BaseMed is, and when you can't use, and you've elected, I must admit, you've elected not to use the funds of your members to engage in marketing activities, you do need brokers to bring you members so that for the benefit of all, you've got greater contributions that ultimately drive down. So if you've got a better balance of younger members, it means you can overall have lower contributions. But if the percentage of the people claiming the highest amounts is a very high percentage of your membership, then ultimately your subscriptions will also rise. So what is it that BestMed is saying in a general sense? It is saying that we accept that there must be a scheme of appropriate regulation in the healthcare market. BestMed doesn't challenge the principle of regulation. It does suggest that it might be that the market can operate properly without regulation, but it's not advocating no regulation. What it then says is what is appropriate regulation in the circumstances? And it says what we have is not appropriate regulation. And I'm sure you're very well familiar with this theme now, but a big problem is the fact that there is an imbalance between the regulation of medical schemes and the regulation of the service providers and the fees that they can charge. And as always, the theme comes back to Regulation 8 of the medical scheme regulations and the fact that there is a list, and quite an extensive list, of prescribed minimum benefits. And as you know, the medical schemes must reimburse the service providers at cost, with no co-payments, with on invoice, as it was put earlier. Once there is that obligation on the scheme to make payment of that amount, the question is, well, what is the amount? How is that the appropriateness of that amount determined? One would have thought that if there is an obligation on schemes to pay at cost, that there would be concomitant regulation of what the appropriate level of cost that the scheme must bear must be. But there is not. As we see, there is some provision legislatively for setting certain standards, but there are no standards in place. There is no regulation in place. So at present, healthcare providers are free to charge as they like to medical schemes. The answer, and Mr. Rath will elaborate on this, the answer always seems to be, but you can enter into contracts with the healthcare providers, and so you can agree to lower those costs with them, and you can control those costs. It is a simple answer, but unfortunately, it doesn't help that very much. The problem is the doctor, the hospital whoever the healthcare service provider is, comes to the negotiating table, if it comes at all, it comes in the knowledge that it doesn't have to agree to any particular rate. Because if no agreement is reached, they can charge whatever they like, and the scheme must pay at invoice cost. So the incentive for them to bargain with the medical scheme is very low. So that's the first problem. And that's also assuming, for example, that the contract, once reached, will be there indefinitely, a matter on which Mr. Raad will also touch. So the point is that although there appear to be certain solutions to keep down the cost at which services can be acquired, these aren't complete answers. And it is still so, as we will show through the data that's being collected, it is still so that the cost of the provision of PMBs is going up. It is going up because there is no control over it. One is not in a situation where, for example, Chair, you asked the question earlier, how does one find the balance between the interests of the service providers to make a reasonable living and then the interest in controlling the healthcare cost? Now, for example, if there were to be a fee that was suggested as the appropriate level that strikes that balance, it could be that a doctor would still be allowed, or a hospital, or whoever the service provider is, would still be allowed to charge a higher fee, but that the medical scheme would only be required to reimburse that service provider at the guideline fee. That would mean, first, that the service providers would be more inclined to come to an agreement with the medical schemes about the fee that they would be willing to pay. But it would also mean that the patients would make intelligent choices about which doctors they would like to go to. Those where maybe they would have to pay more because that doctor did not want to limit him or herself to a particular fee, or does the patient want to go to the option where the full cost will be covered? So there are means to strike the appropriate balance.
I think the balance that I talked about was striking a balance between ensuring that those who provide healthcare services get a fair remuneration or reward, if you will, for their services on the one hand. On the other hand, ensuring that the public has access to healthcare services as provided for in the Constitution. I mean, that's the balance that I'm talking about.
And it is a very appropriate question, particularly in the context of where we are. I wanted to say this last, but I think it's an appropriate moment to deal with it now. We are in a situation right now where we've got an NHI white paper. We know what the intention from a policy perspective is of government, which is to move towards a national health insurance. What is less clear is what the particular role of medical schemes would be within such within this environment. There are some suggestions that they might have only a complementary role, that they might have a top-up role, etc. Whatever the role of medical schemes is to be in this environment, what we must understand that is if the government wishes to adopt the NHI in any form, the most important part of that equation would be for government to be able to control the rate at which it will be able to access healthcare services. And the suggestion that we leave with you today is that at the moment, because there is no striking of the balance between the interests of the service providers and the interests of the public, or maybe even just the interests of the service providers versus the schemes as funders, because there's no balance being struck, the expectations of service providers on the levels at which they can be remunerated are increased year on year. And so that ultimately, when it comes for government to the moment where it needs to engage with service providers, either as employees of government ultimately, or as service providers at a fee for service, that the government will be met with significant expectations about the levels of income that these service providers can get. So we suggest that the proper regulation of price, taking into account all interests, so both the interests in a proper income for service providers and the public interest, but that the regulation that takes into account that balance would be a good precursor to the adoption of the NHI if it is to follow. And we don't know when and we don't know how, but we do say that there are concerns if there is no regulation now of price, that we may not be able to have a successful transition to NHI.
We'll probably know on Thursday next week.
Yes, Chair, we wait with great interest. Then I focused a lot on Regulation 8, and I focused somewhat on Section 26, which is the fact that a medical scheme such as BaseMed that is self-administered is constrained by this requirement that it can only engage in that which is the business of a medical scheme, and so that it cannot make all these additional payments, make profits, and thereby gain more members. I'm not going to elaborate much more on that. But if one asks about what contributes to the increased costs of medical schemes, so the subscription costs, we say there are two other very important matters. The one is Section 33(2)(b), which says that every option offered by a medical scheme must be self-supporting. So that means that the cheap option and the expensive option, we can't use contributions from the expensive option to cross-subsidize that which is offered in the cheap option. And because that is so, because that cross-subsidization is not allowed, so that's the one aspect, and on the other hand, as we know, every single option must offer all the PMBs it costs. So there's a minimum cost that is associated with offering that lowest option. The lowest cost option is already expensive because there is a significant list of prescribed minimum benefits. So there's a floor below which the medical scheme cannot go in its subscriptions in order to ensure that that low cost option can offer all of those prescribed minimum benefits and yet be self-sustaining. So that, we say, is an important matter that needs some attention. We do suggest that if it were possible to cross-subsidize between cheaper and more expensive options, that there would be more room for medical schemes and BaseMed itself to attract members at the lower levels, lower income levels, through the subsidization by the more expensive option. So that's the one aspect. And then another aspect that we say also contributes significantly to subscription costs is the requirement in Regulation 29, which is that a medical scheme must have 25% of its gross annual contribution turnover in reserve. It is a significant burden upon medical schemes to keep this percentage in reserve. And you will know from our written submissions that this was historically not a requirement. It was a new requirement that was put in place. BaseMed at the time had quite a difficulty building up that reserve in a very short period of time. The point is simply this, that there is a cost associated with keeping that reserve. And sometimes one wonders about what that arbitrary and very significant reserve adds to the ability of medical schemes to keep their subscription costs low or to have a lesser increase in particular in particular years. These are the main matters that we raise for present purposes, which we see as a context-setting exercise. So it is not everything, as you know from the submissions, but these are the main matters that we wish to raise. We wish to make this one more point. Those who can afford medical scheme contributions expect that their contribution will entitle them to the best healthcare that money can buy. And that is right. One pays this money and one expects to get good healthcare. But unfortunately, that also means that the buyers are not price sensitive, and they also fail to recognize that sometimes the most expensive option is not the best option. They don't want to be restricted. They don't want to be told that you can only go to Dr. X, Dr. Y, or Dr. Z. They want to have the full option of going to any doctor of their choosing. If that is Dr. Smith, who's looked after mummy for 45 years, and that's the only doctor that they trust, they don't want to be told, but he's not part of the designated service provider group. So that ultimately we sit with the difficulty of regulation that is incomplete, expectations from a paying public, and a medical scheme that is not there to make a profit, but that is trying desperately to keep costs down so that in the next round they don't have to put up their subscriptions. And what they have is they've got members who don't understand that when they use the most expensive options, that ultimately that translates into next year's greater contribution because the scheme has had to pay out more than was necessary.
Does BestMed take issue with the principle of reserve?
Not with the principle of the reserve. It is with the amount of the reserve, and it says that there was no proper research done that underlies coming out at the 25% percentage marker. It is really a question of the level, which it says is arbitrarily determined and doesn't bear a relation to what is necessarily required.
Yeah. BestMed has been around for some time, hasn't it? And when the Medical Scheme Act was promulgated in 1998, I think it is, they had been around for some time, weren't they?
Yes.
Yeah. Now, did they participate in the public hearings leading up to the enactment of the statute? And if so, did they raise these issues?
I will have to take full instructions. As far as I can recall, they did participate in the process. But if you require it, we can make written submissions in addition on that question.
No. I just need an answer. So it's just a straight yes or no. That's
my understanding is yes, they did participate.
Well, are there any officials from BestMed here?
There are.
Yes. Okay.
Having made these introductory remarks, I'm going to now hand over to Mr. Raad, and he can elucidate more. And then if there are any questions, of course, we are available to answer them.
Thank you, Mr. Arnold-Brown. Yes.
Thank you, Chair. And let me just see. The comments that BestMed asked me to make today focuses predominantly on the regulatory environment, with some focus on Regulation 8, but also a bit of a wider context than that. So, Chair, I'm cognizant of the context of today, which aims to be at a high level, and although the topics that I address are quite deep and quite complex, I may gloss over the slides relatively quickly. I'm quite happy to come back in more detail if there are questions.
You will bear in mind that one of the public hearings, later on, will be devoted to the issue of the regulatory framework and the impact of that on competition issues. Because what we were hoping to hear from PESPET today is how it interacts with its members, trustees, brokers, other stakeholders. I mean, Mr. Engelbrecht makes the submission that because of the inadequate regulatory framework, medical schemes have to pay what service providers demand. Now, on the contrary, we were told last week and the week before by medical practitioners that they are being dictated to, not just in terms of the treatment that they must give, but also in terms of what they should charge by the medical schemes. So that's what we were told. And I was hoping that perhaps somebody from PESMET, in order to substantiate your submission, that somebody will tell us how that plays out. That's what we're expecting to hear from them. Yes, go ahead.
So, Chair, there are some contextual remarks about regulation to deal with specifically the relationship between BestMed and providers and the way it manifests or does not manifest in DSPs, which I think talks to that context. And I'll try to go through the slides relatively quickly to guide you through that. I'll make only one overarching introductory remark with regards to regulation on this slide, and that is that the ANC white paper dating back to the early 90s contemplated a number of social health reforms in what was then termed social health insurance as a stepping stone towards national health insurance. And in the Medical Schemes Act in 1998, the reform trajectory was very quick to implement guaranteed benefits and open enrollment and community rating, all of which are reforms that are aimed at improving access and equity. However, the same ANC white paper also emphasized the need for measures pertaining to sustainability, such as risk equalization and such as mandatory participation. Now, for good or for bad reasons, those measures were not implemented. And I think that's a fairly common theme in a lot of the submissions that have been made during this process. And I will talk to the manner in which this tension that this manifests has, that this tension has manifested in the way that medical schemes have to approach the reimbursement of providers. Now, first off, it's important to realize that each of those social protection elements come at a cost. Guaranteed benefits come at a cost. Community rating come at a cost, and open enrollment come at a cost. The latter two in the form of potential anti-selection. And I want to show this slide, which plots the beneficiaries of a medical scheme, in this case BestMed. The blue line shows the loss ratio of the lowest claiming BestMed member on the left and the highest claiming BestMed member on the right. So loss ratio meaning claims divided by contributions, such as a loss ratio of 100% implies that the member contributed as much as the member claimed. And the red line at the bottom shows the break-even level where members would pay as much as they claim. And the perhaps startling observation, which I believe has been made in a number of submissions, is that in any medical scheme that we look at Insight, and that includes BestMed, approximately 80% of members get back less in any year than they pay into the medical scheme. In fact, we've investigated a number of schemes, and the percentages that we see literally are 79% or 80% or 81%. Now, the important is that because of the absence of risk equalization, medical schemes are absolutely dependent on its ability to attract young and healthy members. On the left-hand side of this graph, medical schemes make surpluses, but on the right-hand side of the graph, medical schemes make losses. So medical schemes require a sufficient number of young and healthy members to be able to fund the losses on the right-hand side. And I think an important theme in this graph is not the structure, but the shape. This cross-subsidy is perhaps more severe than one would intuitively expect. If we look at the angle of this blue line and the severe extent to which it angles upwards towards the right, and considering that if you look at the space between the red and the blue line on the left of the graph, that surplus must be equal to or more than the space between the red and the blue lines on the right of the graph. Now, the needs, or rather the wants expressed by young and healthy members or low-claiming members on the left of the graph does not mesh with the catastrophic nature of, for example, prescribed minimum benefits. Most consumers suffer from what the Time magazine 2 years ago called an optimism bias. Most people believe that I will probably not suffer a catastrophe, I will probably not be diagnosed with a dread disease. And as such, if you interrogate brokers on the needs of the young and healthy members out there, the kinds of answers that are typically given tend to be in the domain of optometry or dentistry or acute medication, etc., which is technically uninsurable, but also doesn't talk to the real needs of the population, which is protection against catastrophic cover. And the tension that presents itself during benefit design is that medical schemes need to come up with compelling designs and products that are attractive to the young and healthy. And this is exacerbated by the absence of something like risk equalization, so that the scheme can maintain a cross-subsidy from the one to the other. I think it is important to emphasize that the need of an open scheme to attract members and young and healthy members is not a simple matter of furthering competition or market share against others. It is actually a matter of survival, in the sense that it is mortally dangerous for any medical scheme to see.
Can I ask you this question? What's the rationale for attracting people who are young and who are healthy?
Chair, is the question, what is the rationale for attracting young and healthy
Because
members?
I've read your submission. One of the points that you make is the fact that you are prevented from pursuing young and healthy members.
So the point that I'm making here is that medical schemes, because of community rating and because of open enrollment, do not have a choice but to attract young and healthy members.
Yeah.
The existing membership of a scheme will become older and sicker over time.
Yeah.
And unless the scheme can keep on attracting a young and healthy population to maintain the cross-subsidy from young to old, the scheme will topple over and find itself unsustainable.
So you want to attract people who are young, who are not sick, so that you don't have to pay any claims.
Chair, so that you are capable...
That's the bottom line, isn't it?
Can I answer the question? So that you are capable of paying the very catastrophic claims on the right-hand side of this graph. Does that make sense?
By using the contributions made by those who don't get sick.
Exactly. So the social solidarity principle...
So what you really are looking for is somebody to pay for the sick.
So, Chair, let me go back to the social solidarity principle underpinning the medical scheme regulation as contemplated in the Medical Schemes Act. The social solidarity principle requires two kinds of cross-subsidies, and this is explicit and intentional by policymakers, is a risk-based cross-subsidy from healthy to unhealthy, and an income-based cross-subsidy from the wealthy to the poor. And social solidarity explicitly requires this. That is arguably the very function of medical schemes, is to pool the risks of the healthy and the unhealthy together, or the low claiming and the high claiming. And I need to emphasize, healthy oversimplifies the matter. I would want to view myself as a healthy person, but I could be involved in trauma, or I could be diagnosed in a dread disease tomorrow. That pooling element is what medical schemes need to do. Now, community rating requires schemes to charge the same premium to all members, regardless of state of health. And it follows immediately that if a scheme's average state of health starts deteriorating, that this premium will need to increase in a commensurate effect. So, whereas one would want schemes to compete on the ability to provide proper service, to purchase healthcare efficiently, the reality today is, and an unfortunate reality today, is that open schemes compete on the ability to attract young and healthy members, because that translates directly into a more affordable premium and the ability to fund catastrophic claims when they occur through the surpluses that are generated by the 80% on this slide. So I'm a little bit perplexed by the question, but I want to check whether you're satisfied that I've answered the question before I proceed.
There are many perplexing things in this inquiry. Proceed.
Thank you, Chair. That is comforting. Now, I want to move on to prescribed minimum benefits and Regulation 8. And the context that I've given you thus far is absolutely vital for what I want to show. Now, I quote on this slide verbatim the words often used by Professor Alex van der Heever as to the purpose of prescribed minimum benefits. And prescribed minimum benefits is a necessary part of any healthcare regulatory framework. The first bullet shows that clearly you need to mandate a minimum level of cover, and clearly the intention of prescribed minimum benefits is to locate the liability for catastrophic cover with the medical scheme. But there's a second and perhaps more subtle intention behind prescribed minimum benefits, and that's to incentivize medical schemes to take principal responsibility for the purchasing role in healthcare. In the triangle that I show in this visual aid, this tension is well known, that a member interacts directly with a provider, but that healthcare is a very complex commodity to purchase. And the intention is for the funder to step in and assume some of the negotiation, other roles that removes that complexity and allows consumers to access high quality and affordable healthcare. So I want to hover on this intention to encourage schemes to take principal responsibility for the purchasing of healthcare. The way this is intended to be done is envisaged in Regulation 8. So we often criticize and hear complaints about the at-cost wording. I think that has been heard many times. It's worthwhile to briefly point out that at the time Regulation 8 was drafted, there was a collective bargaining structure in place. I don't think the legislature ever envisaged an environment where there wouldn't be a guideline or a reference or a benchmark or an ethical tariff of sorts when the words at cost was written into this regulation. Now, we often hear that medical schemes complain about the fact that they are faced with this limitless or proverbial blank check liability. But the reality is that the regulation does give schemes a mechanism to mitigate this liability. And that is also in the next subsection of Regulation 8, which basically says that a medical scheme needs to reimburse at cost unless a designated service provider network is in place, and if a member or a beneficiary voluntarily moves outside of the enforced designated service provider network, then a scheme does not need to reimburse at cost. And the theme that I want to hover on is the red bullet at the bottom to ask whether these DSP provisions provide schemes with sufficient means to manage the costs and take principal responsibility for healthcare purchasing. In order to do that, I want to share some trends, and I'm going to go through this quite briefly because the purpose is to set context. I'm happy to respond to questions, but I want to share the way in which these costs have manifested since 2007 till at the slides at the end of 2014. Before I go into these slides, I want to make 4 brief comments. The first comment that I want to make is that these slides include BestMed data but are not limited to BestMed data. The second comment that I want to make, which is vital for the interpretation, is what I'm plotting here are claims made by providers, not the benefits paid by the scheme. This is absolutely important. At the risk of repeating myself, what this shows us is the behavior of providers. And I'll come to the extent to which these claims have been reimbursed by schemes. But we're looking at the billing behavior of specialists in this slide. We're also looking at in-hospital data only. So we are concerned here with the DTPs rather than the CDLs of prescribed minimum benefits. The final point, and I think it's just an important qualification, Chair, is that I'm showing anesthesiologists in this slide. The only reason I do so is as an example. I could have looked at any discipline, and perhaps anesthesiologists have the unfortunate privilege of finding themselves at the beginning of the alphabet, which is why I've used them in these slides, but I'm not trying to point fingers to any specific speciality. A similar trend emerges if I look at any speciality that performs PMB work, and I'll come back to that in a second. Now, in the slide, we plot the per life per month costs of PMBs versus non-PMBs over this 4-year period. And we've indexed both at 100 in 2007. And it's clear that the costs of PMBs have increased at a higher pace than non-PMBs. I'm going to go through this quickly, but we can break this down into incidence and unit costs. And a health economist would typically want to know what are the causes of this. On this slide, I show that the incidence or the frequency of PMB claims have increased, and the incidence or frequency of non-PMB claims have decreased with a commensurate amount. On the next slide, I then consider the unit cost of these claims. In other words, regardless of the number of these claims that emerged, what was the cost per event, or in this case, the cost per claim line? And you will notice that still sticking to the anesthesiologists, the unit cost per claim has increased higher for PMBs than non-PMBs. And this is a peculiar observation, Chair. In the case of anesthesiologists, one would expect that the activity performed by the anesthesiologist is not necessarily influenced by whether the claim is a PMB or a non-PMB. So we want to understand better why would we systematically and over time see the unit cost per event increase at a higher rate. Now, I've unpacked this slide in a little bit more detail, and I've annualized these increases to give you a sense of the unit cost increase from one year to another in this slide. So what this shows, if I can just hover on it very briefly, there we go, is that the increase from 2007 to 2008, the unit cost or tariff increase amounted to 6%, both for PMBs and non-PMBs. The unit cost increase in 2009 amounted to 13%, which was close to inflation at that time. However, this gap between the PMB unit cost and the non-PMB unit cost emerged apparently in 2010. Now, I'm quite cognizant that analysis of this nature does not prove causality. Correlation never proves causality. But it is perhaps a remarkable coincidence that the unit costs of the services contemplated here increased at the exact same time that a High Court ruling rendered the RPL obsolete, at least from 2006 onwards. So it's conceivable that at the time that the interpretation of at cost could only be interpreted as such that whatever the provider has to charge, that we've seen this cost increasing as shown on this slide. Now, to come back to my earlier qualification, Chair, I'm quite cognizant of the fact that I'm focusing on anaesthetists, and that's not my intention. Here you can look at physicians, at radiology, at surgeons, pathology, and also at all specialists combined. And similar trends emerge. This is vital, especially and fascinatingly, I think, when you look at pathology and radiology. So a pathologist or a radiologist does not have any control over the claims that are referred to them. Yet we have also seen these increases emerging in the space of pathology and radiology. And to my mind, that reinforces the idea that the system as a whole contributed to this. It's not necessarily worthwhile to point fingers at any individual provider, but given the manner in which PMBs have been regulated, these incentives have yielded results. I'm reminded of the subtitle of one of the free economics books, which said people respond to incentives. And the at cost arguably created an incentive which is clearly manifest in these slides. Now, just on the question as to whether prescribed minimum benefits have caused increases, you'll recall that I said earlier that we're looking at claims data. In this slide, we explore both claims data and paid data. In the blue, I look at PMBs. The solid line looks at amounts billed by providers, and the dotted line looks at amounts reimbursed by medical schemes. And you'll see that the two lines follow each other quite closely. It's important for me to show this because there is a view that increases in PMB costs have been the result of compliance of medical schemes. In other words, saying that medical schemes 4 or 5 years ago did not fully comply with PMB regulations, and they've since started complying, and hence the increase that you see, which is why I felt it is important to show the solid line and the dotted line, that there's not a significant difference over time as to the proportion or the paid amounts compared to claimed amounts. Equally important is the green line. And I show in the green line non-PMB benefits, again claimed in a solid line and paid in the dotted line. So when we look at this, a common criticism against these kinds of analysis is that medical schemes might have cut non-PMB benefits during the course of the investigation period. They might have just reduced non-PMB entitlements, which then represent or manifest as an observed increase in PMBs over non-PMBs. And what I'm trying to show here, by showing the claimed amounts and the benefit amounts or the paid amounts separately, is that that has not been the case, or at least definitely not to a significant extent. I also briefly want to linger on the idea of catastrophic PMBs. There are some prescribed minimum benefits that are arguably not catastrophic, Chair, and one of them might be gallstones. In this graph, we look at the trend for gallstones in general surgeons compared to PMBs and non-PMBs separately, and perhaps curiously, the gallstones, which we could argue are not catastrophic, followed a similar trend. In the interest of time, I didn't bring the slide, but we also did a similar analysis for cataracts. And we might want to argue that cataract surgery is not a catastrophe, yet cataract surgery followed the exact same PMB trend if we look at ophthalmologist expenditure.
Have you ever had a gallstone attack?
It's an excellent question. The answer is no, I haven't.
I think if you'd had one, you might consider it catastrophic.
So, thank you for the comment, and I appreciate it. But when we talk about catastrophes, and this is very tricky in healthcare, is if we plot from a heart attack to a cancer diagnosis to a gallstone to perhaps a tonsillectomy, it's difficult to attribute the catastrophic nature of that to this. Now, when I mention cataracts as an example, a cataract is an important part of healthcare, but it is essentially an elective procedure in the sense that your healthcare provider will say to you, sir, you need to remove your cataract, but you might choose to do it next month or in 6 months' time or in a year's time. And in that sense, a cataract is not a catastrophic trend. So I wanted to point out that these trends are manifest and observed even in spaces that are probably not catastrophic in nature. Now, BestMed also asked me to touch very briefly on potential examples of abusive or exploitative billing behavior. And I will share a few of these examples with the panel. I want to emphasize that exploitative or abusive behavior by providers, from the data that we can see, it does happen. It happens on the fringes. It is not prevalent. It's a small percentage of providers that engage in exploitative behavior, but it is real and it is a cost driver for medical schemes. In this particular case, during the course of last year, BestMed was confronted with a GP that submitted a claim during the beginning of the year in April and resubmitted the same claim 4 months later. The same claim for the same patient and the same procedure. When the claim was resubmitted, we're not sure why. Presumably it could have been resubmitted after the provider realized that this claim was a PMB, the same claim was resubmitted at exactly twice the original price. So what I show here is that 150% tariff was resubmitted at 300%, 150 at 300, and another 100% tariff at 200%. It's very difficult to conceive as to why, and I'm not purporting that this was absolutely done to exploit prescribed minimum benefits, but it touches on the narrative that providers could specifically bill more when they're confronted with a PMB for the same patient, for the same procedure. I think to BestMed's frustration, and they asked me to share this, they did contact the HPCSA about the possibility of providers charging more for PMB tariffs than for non-PMB tariffs, even if these are the exact same.
The slides that you showed us previously of the examples of billing, this one, was the matter taken up with the service provider concerned?
My understanding is yes.
And what was his or her response?
My understanding, Chair, is that the response was that it is a PMB and it needs to be paid. But I speak under correction. I'm sure BestMed can refer.
I beg your pardon?
I said this is my understanding, is that the provider insisted on being paid under PMB regulation. But my recollection is, this is my recollection, BestMed can probably give them more details if necessary.
Who will provide the detail? Who can provide us details about this?
I'm not sure if someone is here right now who can provide the detail. Alternatively, I'm sure BestMed can come back.
No. I mean, can we not have that information?
What normally happens, we contact each and every provider in cases like that. When we contact them, they just state it's a PMB, you have to pay in full in accordance with the prescriptions of the Act.
Perhaps once they've done, you should come forward so that we can hear about these matters.
Chair, in this particular case, the HPCSA was contacted and BestMed asked me to share this, that the response was that there's no particular rule regarding the practice outlined. I also want to share some examples of so-called upcoding. And I think a lot has been said about upcoding. The upcoding is an important question because it also talks to the extent that we can understand demographic deterioration. The narrative that I've outlined on this slide seems to veer towards the anecdotal, but this is a narrative that is encountered virtually in every call center that deals with chronic authorizations. And if you will indulge me, I'll very quickly go through the narrative and the 6 steps that I've outlined here. This pertains to the chronic disease list, or CDLs, which is chronic medication, and specifically to the fact that bipolar mood disorder is a CDL, whereas depression is not a CDL. So the narrative plays out as follows. First, a medical scheme receives an application from a member for chronic medication for depression with the ICD-10 code for major depression as shown here. Now, if this member belongs to a lower cost or a PMB only option, that major depression would not be covered, and because it's not one of the benefits, the application would be denied. The scheme then, on the following day, receives a new application from the same patient with the ICD-10 code changed, with 1 digit change from 32 to 31, which indicates bipolar mood disorder, but with the same medication as before. The scheme again denies on the basis that for bipolar mood disorder, a mood stabilizer is required and the same drugs are probably not warranted. So the scheme then receives the same application for a 3rd time, this time adding a mood stabilizer to the application, at which point the scheme doesn't have an option other than to approve the application for chronic medication. And once this is approved, the patient proceeds to claim for the antidepressant, but not for the mood stabilizer. So this kind of narrative, which quite often presents itself, does certainly suggest that the codes and the motivation were simply upcoded or tweaked in such a manner so as to allow the claim or the application to qualify for PMBs. I can perhaps show another example, and this is in the domain of diagnosis treatment pairs or DTPs, which also form part of the PMBs. Now, an ulcer which doesn't have hemorrhage or perforation is not a DTP and can be managed on an outpatient basis. These two ICD-10 codes, K25.7 and K25.3. And also with hemorrhage or perforation is a DTP and is more serious and requires hospitalization and qualifies as a PMB. And if we investigate these specific codes, we again see a similar trend, that for some reason, ulcers with hemorrhage or perforation has increased. And it shows the exact same trends that I've shared with you previously, that they appear to have become more prevalent, and they also appear to have become more costly over time. We have similar other examples, but I think the point of upcoding is just the point that I want to make for now. On top of this, there's the phenomenon of code unbundling, or code farming is a term that's often used. And we've heard submissions, I think last week, of the need for new codes to emerge from time to time, and certainly those submissions are not unwarranted, especially if a new technology emerges, a new treatment emerges, and a new code is required. But what medical schemes have experienced is also that providers have, apparently at their sole discretion, started adding codes to certain procedures. We can produce several examples. There's a popular example that a quadruple heart bypass is often billed as 4 single heart bypasses, which is more expensive than a quadruple heart bypass. In this slide, I show a hip replacement for orthopedic surgeons. Now, hip replacements are not PMBs, but the example illustrates the point that there is a code 0637 for hip replacement. But since the court ruling in 2010, in the absence of billing guidelines around this, some additional codes are added for cutting through the muscle, for separating the joints, etc., etc. Now, we are told that in BestMed's engagement with providers, it is one thing to agree on price. But code farming of this nature demonstrates to us that it is a completely different animal altogether to agree on which prices, because codes appear to be added into a contractual regime, resulting in increased prices over time. Now, these examples, which admittedly veer towards the anecdotal, are important just to give the panel a sense of the risk of upcoding or manipulation or exploitation and the way this could manifest in PMB. So I want to come back.
Could you just go back to the previous slide, the code farming? Now, the code, the two figures that are on the right, the first figure, what does that stand for?
Those are the units, and then according to the relative value units, that translate in a rand amount, which is the amount that you see in the right hand.
That 11,000.
That's correct.
Yeah. And then the one below that, the one for the surgeons?
12,000 rand, which is a higher price for the same procedure because of the manner in which additional codes have been added. Thank you. So I'll go back to the question, is contracting the solution? The regulation does provide designated service provider networks as a mechanism for schemes to protect themselves from this notion that they are exposed to at-cost billing. I think the BestMed submission asks if you can picture the negotiation table with, let's say, a specialist and a scheme. Now, unless the scheme is willing to enforce a DSP in such a manner that would limit the freedom of choice of its members, unless the scheme is willing to do that, the specialist knows that the default position, if we do not make a deal, is that I'm entitled to being reimbursed at cost. Now, the question that emanates from this is, what is the nature of that negotiation? Does that reflect a free or a fair or an equitable negotiation where a price would be reached based on the normal commercial imperatives? Now, BestMed has made some progress in signing specialists, as have many medical schemes. But arguably, the price point at which these contracts have been signed are different and perhaps higher than it would have been if it wasn't for the at-cost backdrop or default position sitting behind the negotiation process. So if we asked whether contracting is the solution, specifically looking at contracting the specialists and providers, not for smaller schemes. It is difficult, administratively complex and arduous for providers to contract with every medical scheme out there. Even where contracts exist, the unbundling or code farming that I've tried to show still manifests. So the contract often only deals with the price matter, but it's very difficult within a contracted regime to address the question as to which codes should be billed. Contracts can be terminated. I think to some degree it's a fallacy to believe that the mere existence of a contract protects schemes against these dynamics. So especially against the backdrop of the at-cost context, and especially if a scheme is reluctant to enforce these fees and restrict freedom of choice because of the need to appease to the needs of younger and healthier members, contractual arrangements are arguably fragile and could be renegotiated on a regular basis because of the at-cost default. So we are arguing that the rates that schemes have to offer given this at-cost alternative are higher than it would have been in a fair or a normal negotiating environment. So, Chair, my penultimate slide. Recently, there was a proposed change to Regulation 8, and the proposed change read that the scheme's PMB obligation would be discharged once the medical scheme has reimbursed at the 2006 RPR plus inflation. Now, there were a number of conflicting interpretations of what the proposed changes to Regulation 8 really intended to achieve. But I quickly want to talk to the potential market dynamics that could unfold if a scheme's PMB obligation is limited to a floor rather than to a ceiling or an infinite ceiling in the case of at cost. And if we consider the possibility as contemplated in one interpretation of that regulation that a scheme's PMB obligation would be discharged once 2006 RPR plus inflation is reached, but that a scheme is welcome to offer more than that, I think part of the market dynamics that unfold could be painted as such. Schemes have a desire to see that benefits are paid in full. Benefit sufficiency can be measured. It's possible for a regulator, it's possible for brokers, it's possible for actuaries to measure the extent to which hospital events are paid in full. One could conceive of a dispensation where the benefit sufficiency of various schemes are published and available to consumers or their advisors, so that you know that by going to BestMed I can expect 90% of hospital claims to be paid in full on average. Schemes certainly have a desire to ensure that out-of-pocket payments are minimized. And I think it would be desirable for schemes to compete on the basis of their ability to pay in full or not to leave members destitute with big co-payments. I argue that this does provide an incentive for a medical scheme to offer more than 100% or more than scheme tariff or more than 2006 RPR plus inflation to providers. Similarly, on the other side of the coin, specialists or healthcare professionals do not have a desire to charge cash up front when a patient walks into the rooms. We also are led to believe that they incur significant write-off costs or debt collection costs, which could bring them to the negotiation table to offer less than 300% or whatever the number is that's being bandied about. So in this proposed change to Regulation 8, or at least this interpretation thereof, there could perhaps be a narrative or an argument to say that it could have resulted in a healthy negotiation environment that would have prompted both sides of the funder-provider divide to come to the negotiation table and agree on a tariff. This is one potential solution for the PMB dilemma. Another solution might be to cap. Another solution might be to regulate. I think these are all ways that could be considered, but I wanted to offer this dynamic as part of the BestMed submission today. Chair, I'm going to summarize. First, we say that open schemes compete for healthy members and are reluctant to limit freedom of choice through the use of enforced designated service provider networks, where members are forced to use some providers and not others. And we also say that in the absence of an enforced designated service provider networks, the non-contracted healthcare providers have to be reimbursed at cost for prescribed minimum benefits. Thirdly, we say the negotiation between schemes and the potential DSP member is held within the context of a guaranteed at-cost reimbursement if no deal is reached. So we want to hover and think about the dynamics of that negotiation where the absence of a deal results in an at-cost entitlement. Fourthly, we want to submit that this encumbers the scheme's ability to take principal responsibility for healthcare purchasing as envisaged by prescribed minimum benefit regulation. And there are a whole number of themes around quality, around access, around reimbursement models that one could explore in there. Fifth, where these contracts are signed, the agreed price that it's signed on is arguably higher than it would have been in a normal or a free and fair negotiation environment where the default of at cost did not apply. 6, where contracts are not signed, healthcare professionals remain free to charge and use codes as they see fit. And some providers exploit this. I'm not saying all providers do, not by a long way, but the exploitation does happen. And finally, in the previous slide, we talked about the dynamics that might ensue in a capped obligation or a minimum floor reimbursement level as contemplated in the proposed changes to Regulation 8. So, Chair, these are the regulatory and specifically being cognizant of the relationship between BestMed and providers in the context of designated service provider network arrangements, and also cognizant of some of the comments and submissions that have been heard during the course of last week. These were the comments that BestMed asked me to share with the panel, and this concludes my presentation. I'm happy to take questions.
Thank you, Mr. Rath and Ms. Engelbrecht.
Thank you, Chair. I've got two questions. Yeah, I have to put it away. Mr. Rath, we met before, and I heard some of the interesting correlations you bring to our attention on pricing of PMBs and non-PMBs, and some narratives about coding, breaking codes, coding, etc. And I'm sure this is an element that might contribute to costs in the industry. But as you said, as a sort of sideline, you said these are correlations, these are not causalities. Now, I know that in the present company you're working in, there's a number of intelligent people thinking about these subjects. Have you ever thought about how do we get from correlations to causalities, to do an analysis where we can almost prove that these things are going on?
We think about the question quite a lot. I'm reminded of the story, if you'll indulge me, Chair, of two students who had a conversation, and one student said to the other that I always thought that correlation implies causation, and then I took a class in statistics, and now I don't think so anymore. And the second student says, so do you think the class helped? And the first student said, well, maybe. Perhaps a useful example is clinical trials in medication. Really, correlation point to a suspicion or a possibility. But to prove causality, you normally need to do an experiment. You often need to, to use the absurd example, you would want to split the South African regulatory framework in two and run the one dispensation on the one side and the one on the other and see how these evolve over time. We probably do not have the luxury to even think about those kinds of things. So unfortunately, the way the scientific method then interrogates this very difficult question is to say, well, we have correlation that points towards the possibility of. We supplement this with anecdotal examples and observations, we note certain coincidences such that this price differentiation appeared to emerge right at the same point in time where the High Court ruling emerged. And by gathering this evidence, you get to a point where it becomes plausible or reasonable to conclude that there's a causal inference. But I have to emphasize, and having thought about it for a long time and read about it a lot, statistics or analysis as a tool in the absence of experimentation cannot breach the gap between correlation and causation. You do need the observations around or potentially an experiment, and that is unfortunately just one of the restrictions that we are dealing with.
It's not good enough, Mr. Raad, but I'll take your answer for now. Maybe we should. We ourselves, of course, are also entering this stage of doing some quantitative research, and maybe we must come back to that, but we have to get closer to the heart of what is really happening, I think. But we'll leave it for here. Mrs. Engelbrecht, your submission somewhat confused me. Because, and of course, much of what you said we heard before, and that you said it yourself. That's very good. But part of your presentation was about the role of brokers in the industry, and you sort of halfway your story, I thought, is Mrs. Engelbrecht now representing brokers, or is she representing BestMed? You held a warm plea for the role of brokers. You said we need brokers because we need new lives, we need new people, young people, attractive people. The judge has talked about it as well. And in principle, yes, you're right. Of course, that is the heart of what is going on. Later in the afternoon, we'll hear Cape Medical Plan, I think 5 of you, explaining us why we don't need brokers. So that will be interesting. But also in the submission I read before and of the delegation of BestMed, there and I hope you read the submission. Yes, there's quite BestMed goes to quite a bit of effort to explain to us that the broker system doesn't work, and there's no evidence that, well, there is, and I think even your colleague on the right hand side, Mr. Raad, has analyzed the fact that new members come into the industry. If they come in the industry, they are at GEMS and to a much minor degree at Discovery's scheme, but not at BestMed. So now I don't understand your story anymore. Can I? So because what I see is there's a sort of constant membership over time, and that the new ones come in are GEMS and Discoveries, not BestMed. And what I would like to understand is that why then do you think brokers are so important for your client, as they are?
Chair, the important point, well, first maybe the point of distinction with Cape Medical might well be the fact that it is not a self-administered scheme, as BestMed is. And that's...
I think that is not correct.
Is it not true?
That's not correct.
Well, my apologies then for misunderstanding the factual situation. I heard also earlier that Discovery was called a self-administered scheme. Them, I do know that they are not self-administered. And maybe then that is simply a choice that is made. The point that BestMed makes in the submissions is that because of limitations that are placed on it in respect of its engagement with brokers and the type of remuneration that it can offer to brokers, it does not work effectively for it as effectively for it as it would hope that it could work. It is reliant, it explained in the beginning of the submission that it uses what it calls a mixed model of marketing. So some of the marketing is done through the, as it were, in-house administration, and it seeks to gain new members through that system. But it seeks also, obviously, to use the brokers to gain the new membership.
Now,
Sorry, and I'll ask. I think Mr. Rath indicated to me that he'd like to add to that. Did I misunderstand?
Let me just add that the role of brokers would not necessarily just be evident in this table membership. I think Bestmed did show some membership increase, but even if it didn't, schemes constantly lose members. There's natural attrition, there's death, and schemes need to replace exiting members with young and healthy members. And it does so in a competitive marketplace where the brokers are there, and we could argue whether the broker should be there or not, but if they are there, the broker needs to bring the member either to this scheme or to another scheme, and that creates this tension. I think that's being articulated here.
Yeah, I'm familiar with that. But I refer to the contribution earlier received from Bestmed, where I quote now that creative products have been developed in respect of loyalty programs, training services, etc., to ensure membership growth through broker services, but the remuneration payable does not fall under, etc., etc. What Bestmed referred to is that the game has changed in the brokerage industry. And it is not, and maybe we should ask Bestmed themselves, but it's not so much about the changing the brokerage fees itself, but the game itself changed by large administrators using loyalty programs to attract young and healthy clients. So I still don't really fully understand how brokers for Bestmed could again be, re-stimulated or re-incentivized to do their job and attract young, attractive people in this environment, in this how the game is being played now.
The short answer really is that brokers are a way to market, a means to gain access to potential members. People who go to brokers, because this is not your typical situation of the person who is employed and there is already an existing relationship where that employer is, for example, covered by Bestmed. It is ultimately about gaining new membership. So where either an employer or individuals go to brokers to seek comparative access to medical schemes, it is there that a scheme such as Bestmed that doesn't have an administrator is very much reliant on the broker that is able to offer it as an option and a viable option to the market.
But do you have evidence that Bestmed succeeds in that, or that the brokers that Bestmed employ succeed in that?
Well, Chair, I can ask the Bestmed representatives to come and address you on that, but it is a perceived need of Bestmed, which I take to be based on evidence that it requires access to brokers in order to get route to market.
I wonder if we could have the gentleman from Bestmed to come and take a seat in front so that he may be in a position to deal with some of those questions that those who've made the presentation are unable to do. Yes.
Thank you very much, Chairperson.
Yes, if you could just place your name on record.
My name is Dries Legrandsie. I am the CEO of Bestmed.
Yes, thank you.
Unfortunately, we didn't prepare for something else than the broad outline of the context today, so we will share what we have with you, but we're willing to share on that one because we've discussed it very comprehensively. As you know, there's a difference between how a medical scheme is treated under the Medical Schemes Act and a private company under the Companies Act. And what we are saying is that there's not a level playing field there. Once you have the money inside the medical scheme, they can pay the administrator. In the administrator's fees, there's profits, etc. That falls outside the parameters of the Medical Schemes Act then. And they are treated differently. They're not regulated in the same way than the money inside the medical scheme is regulated.
Yeah, I fully appreciate it. I appreciate you're on the table there as well. I appreciate that problem. So, and that's part of the issue, isn't it? So part of the way, and we'll talk about competitive dynamics in our fourth set of hearings, and hopefully you will be attending that one as well. But that defines sort of the dynamics in the industry, isn't it? The way new members are being attracted into the industry. And that, of course, is being acknowledged by all the schemes. That's your sort of lifeline. And then there's some players that manage to, outside the reach of the CMS and the Medical Schemes Act, to still manage to attract the young and beautiful into the industry. So I was, and we're aware of that, and of course we will investigate how that precisely is working. And so I was surprised. I read your presentation, of course, earlier, which was, and I love that sentence that you said we didn't hire economists or whoever outside people. We just asked our own staff what were the issues in the industry, and that's what you wrote down in your presentation. But I saw you warning for this phenomenon that outside the scope of the MSA, a lot of things are going on, and actually people prevent you from doing that, precisely attract these young and healthy people.
What we're striving for is just the even playing field.
Say again?
What we're striving for is
That's
just
right.
the even playing field.
That's right, and the playing field is not level now.
That's right.
Thank you very much. I understand. Yes.
Thank you. My first question follows on the issue raised by my colleague Case on correlation and causality. I appreciate your answer, but what is often done in certain cases when you can't do experimental designs is to look at possible confounders that could explain the observations that you have. You've done it once when you look at the court ruling and that possible, so you looked at what could have resulted in the observed outcome. So I'd like to know if you've thought about possible confounders that have resulted in the trends that we've observed.
Certainly, yes. And what I meant with the limitations of statistical analysis is just that the analytical method in itself cannot breach the gap in the absence of an experiment. So this is where you look to data points or features that might explain the observation. I've mentioned a couple. I've mentioned that we observe narratives and anecdotes similar to the ones that I've shared with you. But the proverbial elephant in the middle of the room is that I've often said that I find it perplexing that we're even asking for analysis to be done. If a participant in the marketplace is entitled to an at-cost reimbursement, why are people surprised if a cost increase emanates over time? There is an academic or structural debate as to whether DSPs afford sufficient protection and whether schemes have made use of those mechanisms sufficiently. And on that basis, you could argue that perhaps the fact that DSPs have not been sufficiently utilized is to blame rather than the cost increases. But if I can put that aside, the overarching narrative here is that there is a participant in the marketplace that could determine his or her own rate of reimbursement. BestMed has examples of providers that have charged not 300%, but in some cases 1,000%, and those can be shared. And we're paid in full because those were PMBs and there wasn't a DSP in place. So the question that I would raise is, wouldn't just that dynamic in itself be a glaring possible explanation for the trends that we're seeing over and above the other data points that I have shown?
I don't understand what you're saying, sir. Are you saying that it was not necessary for you to do the kind of analysis that my colleague is suggesting to you, or you didn't have time to do that, or it's not necessary in the context of this inquiry to do that because there's sufficient information to support what you're saying?
Chair, I have done the analysis and I have presented the analysis. I'm saying I find it surprising that it was deemed necessary for me to do the analysis.
What do you find surprising?
So let me show as a simple example. I'm an actuary and I render services, consulting services. I've often said, and only half jokingly so, that if there was a regulatory provision that said that actuaries should be paid in full at whichever rate actuaries choose to charge, then I would probably start charging more. It would seem a reasonable response, or a predictable, or even an inevitable response to that kind of dynamic. So the question, and I'll come back to the complexity of these Ps and the mitigating factors that schemes could employ. The question is just that since the Competition Commissioner ruling in 2003 that removed the possibility of centralized bargaining, and specifically since the 2010 court ruling that removed any semblance of an ethical or a reference or a guideline tariff, after that, the manner in which Regulation 8 was implemented was that unless a DSP is in place and enforced, providers are entitled to be paid in full at whichever cost the provider chooses to put on the bill. If we now see costs increasing, it does seem to me like a very simple explanation. And I was initially perplexed as to whether it's even necessary to go through all of the steps of showing that these data and trends possibly point towards the fact that some of these prices have been systemically inflated, or that the incidence of PMBs have increased over time. So the question from Lungi, from the panel member, specifically asking as to whether there are other conflating factors or third or hidden variables that could explain this. And I'm saying there's a proverbial elephant in the room as well that explains all of these things, in addition to the more nuanced factors that I've covered in the presentation.
I think what you must understand, Mr. Rath, is that you've come here to make a presentation, right? Now, you have provided us with statistics and the analysis, and my colleagues are perfectly entitled to ask questions pertaining to what you have done. Do you understand that? Your nodding is not going to be recorded.
So, Chair,
do you understand?
I apologize if I misunderstood. This is my response to the question.
Yeah.
I was asked whether there's a possible explanation, and my response is yes, there is a very, very big one. That is the response.
Thank you. My final question had to do with the unequal playing field that you've explained being a self-administered medical scheme. And I wanted to be clear on what is your proposition then. What is BestMed arguing for? Because you explained that the other schemes that are administered by third parties have the advantage of using the loyalty programs. So do you want to have the same benefit? So so I understand what the limitation is, but what do you want?
Thank you very much. What we want is one of two things. It's either for the same regulations to be applied in the cases where that money is taken out of the medical scheme towards the administrator, or a deregulation on the self-administered medical scheme in order to allow us the same sort of flexibility than they do on the other side. So it's either one of the two.
Would it help perhaps to address the issue of what at cost means?
I beg your Chairperson, I didn't follow the last part of your question. Can you just rephrase?
One of the concerns that's been raised in the submission is the issue of no yardstick to determine what at cost means. So what I'm asking is, would it help if there is a price reference list or some tariff? Would that cure the concern you have in relation to Regulation 8?
I think it will certainly address the fact that there's no guideline opens it up for the at cost. So what we proposed at the end there was a guideline that we don't want a ceiling. We want certain things absolutely as a minimum, and on top of that minimum, we argued that yes, members or the provider can still charge above that, but then there will be co-payments for the member, and the member will have to make the choice, informed choice at that point in time, whether they're prepared to pay the additional funding for that.
I understand.
Thank you. I have, I think, also 4 questions, but I just wanted to make a point in your submission on page 42, your paragraph 48, that you speak about under apartheid, the public healthcare sector focused exclusively on indigent and those without medical scheme cover. I think that's not correct. The public healthcare system under apartheid provided extensive services for people as long as they were white, and much minimal services if they were black. I don't think it had to do with being indigent or not. So I think that's just a factual error in your submission. There are outstanding services in the public sector for white people under apartheid. My questions are trying to understand 4 different things. The one is in relation to the cross-subsidization between different options within a scheme. My understanding, and please correct me if I'm wrong, is that you can in fact apply for exemption and you can cross-subsidize between schemes, and if I'm not right, please correct me. It also seems to me that you have 10 options, and I suppose one of the information asymmetries that happen in this market is that it's really hard to choose a scheme. And then once you've chosen a scheme, it's really hard to choose an option. And are 10 schemes really necessary? And is it feasible in the process of this inquiry that we should have fewer schemes, fewer options within schemes? Sorry, not fewer schemes. And if you can't cross-subsidize, aren't you shooting yourself in the foot by having so many different schemes? So explain that to me.
So these are very important issues, and Section 33(2)(b in the Medical Schemes Act requires that options should be self-sustaining, and it does seem like a fairly obvious or innocent requirement that a product should sustain itself. The first point in response to your question as to whether schemes can apply for exemption, Section 8H of the Act does allow schemes to apply for any kind of exemption, but there hasn't been a precedent that I'm aware of any scheme applying for exemption from 33(2)(b. What does play out in practice is that I think it would be fair to say that the regulator has, to a limited extent, tolerated cross-subsidy between options. It has certainly not endorsed or openly allowed it, but there's been, under a degree of resistance, there has been some tolerance for loss-making options. And there's a very specific reason for that. We've said earlier that social solidarity requires both risk and income cross-subsidies. And risk cross-subsidies take place on the very comprehensive options of schemes. So what we've realized, I guess, since the Medical Schemes Act came out, is that sicker or higher claiming members tend to select the more comprehensive options, and healthier members tend to select the less comprehensive options. And if we can't cross-subsidize between options, this results in a fair degree of indirect discrimination.
I understand the cross-subsidy issue. What I'm asking you is, why do you need 10? Do you need 10?
Okay.
And
let me proceed right to that question then, is that the conflict or the dilemma faced during product design, that any reduction in the number of options will by necessity result in cost increases to the lowest cost options and cost decreases to the highest. So the range of options will start diminishing over time. And that's met with a significant amount of resistance, of course, from the broker fraternity, I guess, who want to sell these products. And in the broking environment, there's a common narrative that the more products I have to sell, the better, and then I can find a product that suits the need of the consumer, etc. But also a social dilemma in that the reduction in options quite often results in cost increases to the lowest cost end of the spectrum.
Then, sure.
Also, this is due to market pressure, I would say, because healthcare needs is quite diverse. Some people are interested in certain benefits because they have, let's say, eyesight problem. Other ones is interested in other things. So the needs is not addressed generally in all of the options. So some of them have specific benefits for certain, I would say, medical needs, and other ones for other needs, and people opt for that.
Thank you. The other thing, and you were at pains to start off your presentation on this, is that schemes seems to be in this funny position. On the one hand, you are there to support your members, and that's who you're interested in. How do I do the best for my member? And yet you seem to argue against their interests, or their short-term interests. And how is it that it's so hard for schemes to explain to members that what you're protecting is their long-term interest? So quite clearly you don't want to have people over-consuming because they're going to eat up all the reserves. I mean, I understand how the system works. But why is it so hard for your members to understand that you're in their best interests? What's happening? How come there's this breakdown of trust between members and schemes, and that they feel that they are not being served by you, that you're withholding things? And what should we be doing to improve that situation? Or are they legitimately furious and feeling that you're not there for them? I mean, what happens in that environment, and how do we address that and make it better?
It's a difficult behavioral question, in the sense that people behave differently. They perceive medical schemes as a short-term type of insurance. And you usually see towards the end of the year, it's a use it or lose it mentality. And unfortunately, we have done a lot of educational programs over a number of years. We haven't as yet succeeded, I think, in pushing that, I would say, issue to such an extent that everybody knows exactly that this is just a combination or a pool of money that we all put money into, and we must carefully look after this money because it must be there in the long term for us as well. But to answer your question, I think it is educational on the one hand side, and secondly, I think we have to address the issue that there must be some penalties if people overutilize.
Okay. And then the last area that I'm interested in is on the PMB analysis. So you did say to us it was not exclusively best med data, but might include some others. And one of the things that we heard in the first set of hearings was that it seems that, at least in part of the industry, PMBs are not flagged. So you couldn't actually go into a data set and say, here are the PMBs. And certainly something we've discovered, that actually you can't go into a data set and say this is a PMB and this isn't. So I'm curious to know quite how long it took you to do this analysis, and what went into that. And how sure you are that those PMBs are PMBs. And I suppose part of the question also goes to PMBs might be different and more costly than non-PMBs. They're different activities, and so how we deal with that. And then you said, well, some people exploit it, but not everyone, mostly not everyone. And the question is, actually, we do need to know how many people exploit it, because if it's a small amount, it won't, because you're pushing costs. It has to be a significant number for it to be pushing costs. And then you showed us in your second or third graph just quite how the cross-subsidy isn't working, and how, according to that graph, BestMed must be running at a terrible loss. But on the other hand, we also know that every single medical aid have managed, in spite of these terrible reserves they have to hold, to have those reserves. So how do all these things come together? Only a few people do it, but it's also driving costs, and we don't have the right distribution in demographics between sick and healthy and cross-subsidization, so we're losing money, but we've also got our 25% plus reserve. How does all that make sense?
Chair, several questions, so let me start with the first three, but I need some clarity on the fourth question. The issue of identification of PMBs is a very tricky one and a very relevant one, and I would not be surprised if you say that you're struggling with a similar element on your own analyses. It talks directly to the fact that Annex A of Regulation 8 lists these diagnosis treatment pairs, but there's not a proper codification of how this can slot into ICD-10 or CCSA or tariff codes. And when you talk to clinical and coding expert, it becomes a very arduous, very complex matter to determine whether something is a PMB or not. It also talks to some other subtleties like emergencies of PMBs. There's a definition in the regulation of what an emergency is, and it talks to life-threatening situation that needs to be addressed in a very short space of time. You cannot, by looking at a claim, determine whether this was an emergency and life-threatening, etc. There's also the question as to the application of voluntary usage of non-DSPs. You cannot in the claim see whether the member voluntarily went outside of the DSP or whether the member happened to be outside of a 50-kilometer radius, etc. Our view is, at Insight, our view is that there is no elegant solution for the identification of PMBs from a coding point of view. You can confirm that by considering the fact that on the Council for Medical Schemes website, there's a list of ICD-10 codes that are published. There's a list of ICD-10s that are definitely PMBs, and there's a list of ICD-10s that are definitely not PMBs, but there's a murky list of ICD-10s in the middle that could or could not be PMBs depending on the circumstances. And this should be expected because the PMBs, in this case, are diagnosis treatment pairs, so diagnosis gives you only one half of this. The only way to accurately deal with PMB identification is, in the case of DTPs, is at the point of authorization. And quite often, the medical scheme administrator requires someone with a fair degree of clinical expertise to look at and think about the authorization request and potentially even ask questions if necessary and get more clinical information and then flag the event as a PMB or not. And we've tried to limit our analysis to medical schemes where this activity does take place. Admittedly, our ability to audit the rigor of this is limited, but we've tried to limit our analysis to schemes where we believe that this kind of activity takes place to flag.
So let me just interrupt you there, and maybe just to ask BestMed, how do you assess, I mean, who is it? I'm curious. I mean, I phoned up my medical scheme because I needed something and someone was talking to me. And I'm a professor of medicine, so I was interested in the conversation. And I wondered what training, like who are the people who answer the phones? Who are the people who give the authorization? How are they trained? How does that work in your medical scheme?
Yeah, we use a lot of professional people like trained pharmacists, trained nurses in the process of the identification as well as the management of PMBs. In other words, if you would call in this application process that you go through, unless we can identify that automatically by means of our ICD-10 code on the hospitalization side. During the hospitalization, then there's an admission date and a discharge date, and everything in between will also be considered to be part of that PMB process. But it is a difficult thing to manage. It's not the easiest because of the uncertainty that Mr. Raad has alluded to.
Okay, I'm still responding to your first three questions, so let me continue with that. Is that this identification is very nuanced, as I've pointed out, and it's probably the result of the manner in which the regulation defines PMBs. It's not conducive to a meshing with any coding system out there. There are some additional complexities, and I'll go through them very quickly. In reality, I would argue that a scheme actually needs to reassess upon discharge whether this hospital event was a PMB, because quite often something might happen in hospital that might be additional to or related to and can change, and the discharge diagnostic information might add to that. And I don't think that happens in practice in many medical schemes because of the complexity that you can imagine. In addition to that, we've heard from the Council of Medical Schemes, and it does make sense, that diagnosis treatment pairs need not take place in hospital. If you look at the definition and take a DTP, many of them could ostensibly be performed in the rooms of a specialist. And I think very few medical schemes have the capacity to administratively deal with this. It is a very real and I think frequently articulated issue in terms of the identification of PMBs. So back to the question as to the analysis. We used schemes where we were comfortable that there's a fairly rigorous process of identifying and flagging hospital cases upon authorization with some clinical interrogation at that time. What that does give you is, in the trends that I've shown, it's fair to say that the scheme and the provider and the patient probably agreed at the time of the procedure that this was a PMB or that this wasn't a PMB. It's not a perfect distinction, but it does give you some sense. So perhaps to the extent that all of the parties involved dealt with this case as a PMB, you would get a sense of the behavioral patterns that emerge during a PMB. Your second question was whether we wouldn't expect differences in costs given that the PMBs are different. And the answer to that is definitely yes. We would expect differences in cost. What is not clear to me is whether we would expect different increases in cost year on year. So why would the one become more expensive at a higher rate than the other? And I think that was what I tried to outline. In my slides, I've always indexed these at 100, so they might appear as if they cost the same at the beginning, and it's not the case. But we are interested in the changes over time in response to that question.
Both went up.
Yeah, the one went up faster than the other, and that's the question that we raised. Okay. Your third question was about exploitation and the comments about and the fringes of the market, etc. And there's a nuanced point. There are severe degrees of exploitation. There are very rare instances of providers charging exorbitant amounts for PMBs and insisting to be paid, etc. And certainly those are limited to the fringes of the market. And I think that's what I tried to say in that comment. I'm not for a moment trying to suggest that providers are willy-nilly charging 1,000% for every PMB that they see, etc. And I wanted to qualify that context. Your fourth question about how schemes survived, I do want to ask you to repeat the question because I think I understood, but I just want to make sure before I respond.
Well, it just seems that people complain about the reserves and they explain that their demographics are, well, you say that, your demographics are under stress, you don't have enough cross-subsidization across the scheme as a whole, but we know that all schemes have managed, in fact, to get their reserves up. In fact, their reserves, on average, are more than they need.
Yeah. So the response to that is, first off, that many schemes did not survive, and we're down to, I think, 91 schemes at the moment. Many schemes that amalgamated with other schemes did so because they became unsustainable. It's very rare, if ever, that a healthy, sustainable scheme approaches another one and requests to amalgamate. So part of what you see is that perhaps schemes didn't survive. The second part of the question is that those that did survive did so through invoking all kinds of very unpopular mitigating factors like increasing contributions and reducing benefits where possible, which is clearly evident in some of the submissions that you received and the experiences that consumers experienced on the street as a result. In the maybe since Raj was so kind to blame me earlier today for demographics or lack of demographics, I'll just briefly mention the results of the ITAB Inflation and Utilization Subcommittee at the Council of Medical Schemes ITAB subcommittee, which I chair, where we try to measure utilization escalation, so non-tariff inflation. And in the most recent analysis, which was actually included in today, but I removed the slide in the interest of time, we showed that demographics, in the way that we've measured it there, contributed to 2.38% of increases of claims experienced by schemes between 2013 and 2014. And that means that due to demographics, and we can argue, have a technical conversation as to what demographics is, but the contribution increases that schemes had to pass on to their members was 2.4% higher than it would have been if it were not for the deterioration of demographics. So,
I suppose what's not helpful about that is what you really want is a count out of 100 and then say, okay, what's the distribution of 100% that demographics gives, not how much did it push up.
So to give the context very shortly, and we have engaged with one of the Competition Commissioner officials on the methodology in that analysis, but we arrived at the conclusion that utilization escalation in total was 4.5%, so the non-tariff, over and above tariff in this study amounted to 4.5%, of which 2.4 was attributed to demographics, if that gives you a little bit more of that kind of context. Okay.
No, thank you. I don't know if I heard it right. Did you say the loyalty programs are, cannot have loyalty programs? Is it within self-administered schemes? Is that what you were saying?
Sorry, I didn't hear the last part of your sentence.
I'm not sure if I heard you right, but was there a statement like cannot have loyalty programs within self-administered schemes? What was the statement?
The point is that you can't, because the point is that you have a medical scheme that has a bank account into which money flows, which are contributions, and from which money flows, which is the costs and the expenditures related to the provision of healthcare. It is not other cost incentivizing and profit-making mechanisms that can be funded through the funds that come into a medical scheme, which operates the business of a medical scheme. Yeah. So that is the answer. I don't know if Mr. Lagransi wants to add, but he says I put it correctly, and that is the real concern. No, it's not a concern, but it is one of the aspects that makes, again, the playing field unequal between those that are administered outside of the scheme and where there is self-administration.
All right. No, that's fine. I wasn't sure if I had heard right. Now, we've received a lot of submissions, basically, where a lot of industry players indicate that the current broker commission regime, it does not really offer incentives, sufficient incentive, and others are probably leaving industry. But we heard you sort of indicate that this is effective in terms of growing your scheme. Is it within the same regulatory regime? Yeah.
What we are saying from BestMed perspective, and I apologize for creating confusion, is that for BestMed, as a self-administered scheme, brokers are an effective means of getting to market, or it is a means of getting to market. In a world where BestMed were better able to incentivize brokers, it would possibly be able to gain greater membership. But it is constrained at the moment because the manner in which it reaches market, which is through brokers, is one that is constrained precisely because of the regulatory regime. So BestMed likes brokers, but it isn't able to fully utilize the services of brokers as it would like to because of constraints on on the sort of incentives that it can offer to brokers.
So what is the scheme left with to attract members? You can't do loyalty programs. The brokers are not quite helpful. What is the scheme left with? That's a main driver of its new business.
The main driver still is basically the individual brokers, but we also have our own division that sells directly to the public. But this is a very costly exercise. You can imagine for them to drive off to long distances just to conclude the business. So it's not a feasible on a big scale to get big growth. It's there for good retention, a little bit of growth, but I don't think it's feasible to do it on a large scale.
Okay. Thank you. The quick one. Bestmed's submission was unique in one way, at least as far as I can remember, where it says Bestmed is not in a position to support risk equalization. That's almost, I can't think of any other scheme that doesn't. This is paragraph 73. I think it's your page 57. It's not Bestmed's position that REF needs to be introduced. But it's also listed as a missing link in the regulations.
You are absolutely correct, so that we listed that as one of the outstanding issues. When we debated the benefits, the advantages and disadvantages of the risk equalization fund, we came to the conclusion that it will not be in the long-term interest. But since then, a lot of things has changed, and perhaps we should just revise that position of ours, and we will again submit information if we need to submit more information on it.
What's changed?
Of course, the demographics of schemes changes, the way that the scheme operates, the way it competes in the market changes. So there's a lot of things that changes over a period of time. So our first position on that was around about 2003, 2004, and the exact statistics has never been provided. In other words, are we a net payer, are we a net contributor, or are we a net receiver? All that things will play a major role in the stance that you take towards it.
Thank you. Last one, really. I mean, I'm interested in the proposed solution here regarding publicizing benefit sufficiency. How is that different from working on the basis of medical loss ratios? Is it a sharper way of looking at this? Can one use medical loss ratios in the short term to arrive at a similar?
So Chair, that's actually very different. So let me first give the formula, perhaps. A loss ratio is claims divided by contributions, or let me be more specific. A loss ratio is benefits paid divided by contributions. Benefits efficiency would be benefits paid divided by claims received. And benefits efficiency is actually a fairly straightforward analysis. There would be some complexity in terms of risk adjustment and grouping and case mix, which is fairly straightforward to deal with, but would need to be addressed. But I believe it's more than plausible to envisage a world where the regulator or a rating agency or some entity publish what should you expect your out-of-pocket experience to look like if you were to go to a hospital in this scheme as opposed to that scheme. Now, I raised it because if we say that the intention of prescribed minimum benefit legislation is to encourage schemes to take principal responsibility for the purchasing of health care, then I think providing consumers or their financial advisors with that sort of information would also reinforce the encouragement of schemes to ensure that members are not left with co-payments when they come out of hospital.
Okay. So, okay, no, it's fine. That's a good answer. In relation to the out-of-pocket payments, again, publicizing that, how do we deal with the gap? Because clearly we know that it's just difficult to work out what level of out-of-pocket payments. Now, if we were to look at publishing that with all the issues of split billing and all of that, how would we close that gap such that it's reliable information that's put out there?
Yeah, there are two things that make that very complex. As I'm sure you're aware, split billing is one, and ideally split billing should be prevented through contractual engagements. I guess part of what we're submitting is that the necessary features to gain traction in that engagement to incentivize both parties to sign a contract is part of what I've tried to deal with today. Also, members or beneficiaries that do not submit claims, and you can never get past, it's very tricky to get past that, I'm sure, with some of your data requests. This inquiry might be able to prod the mystery of the unsubmitted claims a little bit better than it has ever been submitted or analysed in the past in South Africa. Within the domain of a scheme, it is possible, though, to look at what was billed versus what was paid. And there is a wealth of information in there that, if interpreted correctly, could certainly help the system to function better.
Yes. Now, you say your position on risk equalization has changed.
Initially, we asked that that be put into the submission. I think listening to my colleagues today and listening previously to other arguments, I think it has changed a bit. I think there is a place for risk equalization.
Yes. Yeah. But when you say it has, a lot has happened since then, you mean from the period, the end of October to today? Because that's the time frame that we're talking about. That is the date.
That's the date of
that's
submission.
The date when you made the submission. Yeah.
I think it's more my view. Perhaps it has changed,
Yeah.
and then a lot of the demographics perhaps has changed, and it always changes over time.
Yeah.
But my view on it is perhaps there is a place for it. I was very strict against it, and I'll state it for a record why. At that stage, there was a lot of uncertainty. We did certain work overseas in the Netherlands at one stage. We did some work in Australia, in Ireland, and in France. And nowhere did we come to the conclusion that this was a workable solution in any of those countries. A lot of it took many years before it was implemented. A lot of legal cases, especially in Ireland, where there's only two medical schemes, so the one would be a receiver and the other one would be a payer. So there was a lot of practical issues that wasn't addressed properly. And that is my conclusion why we initially put it in, and I think I've changed my mind.
Well, perhaps I must have misunderstood your position in it, because what you're saying now, it is not entirely on all fours with the paragraph preceding paragraph 73, because you do indicate in paragraph 72 what would be the benefits of introducing the risk equalization. And I had understood, what you say in 73 as no more than suggesting that, look here, it's not necessary to do so, as opposed to something that you did against. Is that a fair reading of what you're saying here? You don't have to go to it, but that's my understanding.
Chair, the real point, as it was set out there in the submission, and I think you understand it exactly, is that there may be benefits to risk equalization, but through these submissions, BestMed wasn't advocating that the outcome of this process should be that there should be a risk equalization fund. That's really the gist of the submission.
That's what I thought, not that there's been any change in the position. The position still remains the same. Now, are you able to tell us how many members you have?
We have approximately 94,500 principal members and just over 200,000 beneficiaries.
Yes. Now, what was the primary motivation that led you to decide against outsourcing, administrative work?
were always self-administered, and at one stage we moved over to outsourced administration model. During that period of time, I saw cost increases. I saw a decrease in the service levels, and as a result of that, it meant that each year the members were paying more for the same. At the end of that tenure, we decided to go back to the self-administration. And the reason for that is I believe in it as a model that adds the most value to the members.
I think one of the point you make, you give the example of 14% VAT and the savings that flow from that. Do you have the original submission that you made to us? Yeah. If you could go to paragraph 128, that's at page 89.
That's correct. We have it. Normally, when you have an administration fee payable to a third-party administrator, you pay VAT on that fee. But not everything that you do is VATable. In other words, it's more or less the remuneration part of it that you cannot claim back. So that, therefore, we stated the 40%, which represent about 40% of the total administration cost payable to the third party.
So are you suggesting in this paragraph that you saved about 40%?
That is what the medical scheme saved on behalf of its members, yes.
Yes. Now, what then was the motivation, given that background, what then was the motivation for nevertheless retaining the brokers?
The brokers, in both instances, they played a role. At the one end, we saw the opportunity, as I said, when we moved to outsourced administration, to grow the business through the administration business. When we moved back, of course, you forfeit that as a benefit, and you have to set up your own distribution channels, and you have to market through the brokers. So the benefit for the scheme is such is that if you're standing alone, you don't have any big brother, you don't have any corporate as a sort of a supporting basis. You must do things on your own, and then you must be able to put everything into place to ensure that there will be growth.
Now, a paragraph after that, that's 129. You raise a concern about what you see as being a regulatory environment that is not conducive to self-administered schemes, and that's in the context of section 26.4. Is that right?
That's right, Chairperson. Yeah. That's exactly what I alluded to in my answer to the first questions, that we think there's not a level playing field there because of the way that the medical scheme protects the money that flows into a medical scheme, but it doesn't protect the interest of the same member money that flows out of the medical scheme to the administrator.
Yeah. Now, in the course of the presentation, Mr. Rath referred to slides which are one of the examples of the billing behavior. Now, what happened here, the first claim that was submitted was at 150% by this general practitioner. Is that right?
That's correct.
Yeah. And then when the same claim was resubmitted, it was resubmitted at 300%.
So what happened in this case? GP submitted a claim for a patient for a particular procedure on a particular day. A few months later, the GP resubmitted the same claim for the same patient, for the same procedure, for the same day, but at twice the original price level.
Why would they do that?
I
mean,
guess
was the first claim a mistake, or an error?
on the slide, I used the word presumably at the top because I also do not know, but we suggested that a possible explanation could have been that the GP realized after the event this was a PMB and I could have gotten more if I asked for more and then submitted the claim twice. I cannot say that, I'm saying presumably it's possible that has happened.
You want to comment on this?
Chairperson, I cannot really add to that discussion. Yes. What we see in practice is sometimes they resubmit, and the only reason why they resubmit is because they now define it as a PMB. Yeah. So we have to make the sort of conclusion, or come to the conclusion that it's to gain a higher fee, or to claim a higher fee.
Yeah. Now, as a medical scheme, we had during the first and second week of this hearing concerns about the delays in paying the claims and sometimes disputing the claims and eventually paying the claims. We also had doctors who were complaining that what medical schemes virtually do, they dictate to the physicians what treatment they must give and what they must charge. What do you say to those?
Chairperson, we regularly check how often or how quickly we pay our claims, and we're very proud of that history. We pay 99.5% of claims within 14 days. In accordance with the Act, you have to pay it within 30 days. So nothing that goes beyond 30 days is tagged in the system. You can easily see what is outstanding. So I don't think we are ones that will take longer than a normal 30 days. Instead, we pay every week. And as I said, 99.5% of all claims is paid within 14 days, 15 days after they're received. As far as the second question is concerned, we can never prescribe to any provider how he must treat the patient. We don't have the patient in front of us. We're not in possession of all the clinical information that they have. So he deals with the clinical side. We deal with the financial payment side. And that is our responsibility and our role.
Do you have designated service providers?
We are now, for the first time, really trying to set it up again because of the effect of the PMBs. We have been unsuccessful so far to have a very good and a big group of people that were able, especially on the specialist side, that would contact with us as DSPs.
And how do you identify this? Do you just issue a general invitation to every specialist or to selected specialist?
As indicated previously, there is a sort of guidance in this regard. You must have an open invitation to all providers, but of course your own member distribution will play a big role in this. You must look where your own members are, and you must ensure that there are sufficient providers in that specific areas to service them. So that also plays a major role.
Thank you. Now, we have regrettably come to the end of your session. Now, is there anything that you'd like to add before we release you?
Chairperson, no, thank you very much for the opportunity for us to present this to the inquiry. Yeah. We appreciate it, and we really hope that we can contribute something that will make private health in this country something to be proud of.
Okay. Yes. Yeah.
Chair, two small comments. The first is just by way of example. In the resubmitted claim that is on the slide, you can see the date of the claim and the payment date. It is 11 days apart, so it's entirely consistent, at least that one example, with the 14-day period that Mr. Lagranzi talks about. And then just one small comment about the distrust. There was a question about the general distrust that people have in medical schemes. And the submission on that is that when people go to their healthcare provider, they go to the proverbial man or woman in the white coat who they believe have their health interests at heart and who will prescribe the best treatment for them. The bad guy in the story is the one that doesn't want to pay sometimes. And there may be good reason for not paying in a particular instance. For example, a procedure that would be so expensive that it would not be reasonable for the community of that medical scheme to carry the burden of that particular payment. The reality is that people distrust medical schemes because they hold the purse strings. And it's not necessarily because they behave badly, but sometimes because they behave in the interests of the general membership, which sometimes means that the individual member doesn't get precisely what that member wants. Thanks.
But you do have trustees, don't you? What do you see as their role?
The role and responsibilities of the Board of Trustees are quite defined in the Medical Schemes Act, and secondly is defined in the corporate governance of King. So their role is mostly governance. The role of management is to ensure that the right information get in front of them so that they can check whether we are doing the right things as management that are in the interest of members.
Is that all? Yes, I understand. Yeah. But as a matter of interest, the script that you're referring to, did you pay the first or the second one?
Unfortunately, we have to pay the second one. We always ask questions, but when they stand on their point and they say it's a PMB, we have to prove differently, and unfortunately, we can't prove differently, so we have to pay the last one.
If you had quickly paid the first one, you would have. Anyway.
They say we did pay the first one, but of course there must be a top-up payment then for the second one.
I understand. Thank you. Yes. Thank you so much for coming to share your experience with us, in particular from the perspective of a medical scheme which is self-administered. And we're terribly sorry that we kept you for longer than you had expected. You know, sometimes these things do get out of control. Thank you very much indeed. Yes. Do we have the representative of GEMS here? Or have they left? Oh, yes, okay. And then do we have the representative of the Cape Medical Plan? Yes. Okay. And then do we have the representative of Emerging Market Healthcare? Okay. Now, we need to have lunch. Late lunch. Now, I'm trying what would make more sense, though, in going forward. I don't see that the time is 3 o'clock in the afternoon. Are there any time constraints for the remaining presenters? Are there others that need to catch a plane back to where they come from? GEMS, yes. Okay. Cape Medical Plan does come from Cape Town. Don't offer. Well, thank you so much for that generosity. And what about emerging market healthcare? I beg your pardon. Do you have any constraint of time having to go back? Yes. Okay, so who will go first? Shall we get James in anyway? That was James in. And can we then take emerging markets thereafter? Would that be okay, Capetonians? Yes, yes, we note your generosity. Okay. Well, the time now is 3:05. It does seem to me that the army is marching on an empty stomach. What time shall we come back? Can we come back at 3:30? Okay. Can we then take a break now and then come back at 3:30? Yes, thank you. I think if the presenters are ready, we can then begin. And if you'd be kind enough just to place yourself on record and indicate who you represent. Thank you.
I'm Dr. Gunvint Kula, and alongside me is Ms. Chini Combrink. Sorry. I'm Dr. Kunvint Kulab. I'm the Principal Officer of GEMS, and alongside me is Ms. Chini Combrink, who's the Executive for Governance and Compliance at GEMS. The easy version of my first name is Guni.
We understand. Yes. Do you could just indicate to us how you propose to make your presentation?
I will do the full presentation.
Okay, thank you very much.
I have got some colleagues here who may assist in taking questions.
Yes. Okay. No, what they can come and sit with you so that, if necessary.
Okay.
Yeah. Okay. But go ahead then.
Okay. Thank you very much. It is indeed a privilege and honor to represent GEMS at this hearing. We hope that through the process that the Health Market Inquiry undertakes, GEMS can make a contribution through its experience and its information that it's built up over its period of existence to inform the inquiry in assisting in taking forward changes in the insured environment in South Africa. What I'm also going to do in the interest of time is skip over some of the slides. I've picked up that the panel reads our documentation extensively and actually makes us quite nervous about the detail that you go into. So the presentation is going to firstly cover the background to GEMS, its inception, its genesis, some outline around how it formulated the benefit options it introduced into its membership base, and then some of the impact GEMS has had, and then lastly touch on some of the challenges, specifically the PMB issues that GEMS has faced, and that's been discussed extensively throughout the day today and in other sessions, and maybe just give a perspective on how we see this could be taken forward. So the background to the creation of GEMS was that the public service, after a number of processes, took a decision that in the benefits that it offers its employees, which cover retirement, housing, and medical, that it wanted to approach a different way to provide the medical benefits to its employees, given that the experience up until that point was that there were multiple medical schemes that were servicing or providing medical scheme cover to its employees, and that there were barriers to access to that in terms of cost and benefit. I'm not going to go into detail in the slide, but essentially the goal was then to try and work towards providing a balance between affordability and comprehensive cover to public service employees. And particularly the part I'm going to emphasize in the presentation is the importance of affordability and how members join or leave schemes, and specifically GEMS, as a result of affordability. And essentially, after a submission was made to Cabinet, the approval was granted to set up GEMS in 2004. The registration occurred in 2005, and then at the beginning of 2006, GEMS was introduced. It operates under the regulatory framework of the Medical Schemes Act, so there's no separate legislation governing GEMS, similar to, for example, the pensions area for public service is different. I think this has been discussed, the role of a medical scheme, but essentially the main area I'm going to highlight in this is that the setup of GEMS was then under the clause of a restricted membership scheme related to the particular type of employer, that is the public service. And I think what you've heard throughout today is that essentially the role of the medical scheme is to collect contributions on behalf of members, design benefit options, which then determine how claims will be paid against those benefit options and entitlements during a particular year. The governance of GEMS, in line with the Medical Schemes Act, has the members and the members through the employee base, and the employer equally being represented on the Board of Trustees, the employer through the Minister of Public Service and Administration appointing the employer-appointed trustees, and the members through an election process. The board has a number of subcommittees, and this is set up in line with the Medical Schemes Act and also in line with King. The responsibility then for the operationalization is the responsibility of the principal officer, supported by scheme officials. GEMS, in its setup, took the decision of having an outsourced multi-administrator model. The key administration services ensuring covering member and claims, member servicing, correspondence and contribution and debt, and then managed care services. So right at the outset of the setup of GEMS, there was a decision based on research that was done at the time, to move to a outsourced multi-administrator model, taking into account through the supply chain model, quality, broad-based black economic empowerment, and price as the three determinants in selecting the service providers, and there's a regular tender cycle with the supply chain policy. Today, GEMS is responsible for collecting contributions to the level of 28.1 billion rand on behalf of its member base. And essentially, we operate on a 3-year planning cycle, and we're coming into this is the third year of the planning cycle, and there's 4 pillars under which GEMS focuses its efforts. Firstly, trying to meet the affordability need of our member base. and I'll share some information around that. The second pillar is around increasingly empowering members to actively take responsibility for their health and live a healthier lifestyle. The third area is that those that do succumb to illness and chronic diseases, that we develop programs to support them to ensure that there's positive health outcomes, very much in line with some of the discussion earlier that was presented by PHF. And that given the location of GEMS and its origins, we have a very large stakeholder environment, and key to that includes a number of the relevant government departments, including the Department of Public Service and Administration. It includes the Department of Health, Treasury, and then also our member base is in an extremely unionized environment, so we have extensive engagements with the union leadership as well. So I think the first piece of information we'd like to share is that the route that GEMS went on the outsourced multi-administrator model using its supply chain policy is that one of the results of that is that it's achieved amongst the lowest non-healthcare costs in the industry. And this is from council data of 2014. And you see on the first bar, the open scheme average at 13%, closed schemes excluding GEMS at 8.7%, GEMS at 7.4%, and then the rest of the industry excluding GEMS at 11.8%. And that differential between the last two represents a value of about 1.2 billion. And from a GEMS perspective, then that can be redistributed towards paying healthcare claims, and this just gives an indication of what that could cover. For example, the total cost of 70,000 beneficiaries of GEMS. This slide just highlights our scheme statistics. This is 2015 data for the year. I want to say it's preliminary information. It is still subject to final audit by our external auditors and approval by the Council for Medical Schemes. We ended the year at just under 675,000 principal members and 1.78 million beneficiaries. As I indicated previously, contributions of 28.1 billion rand, and our claims ratio at 92.6%. And the biggest component of what we pay then is related to hospital costs. If we break that down further, the two biggest payments that we make are firstly to medical specialists at 2.8 billion and private hospitals at 9.6 billion. And the two together are just over 45%. And out of all of the claims that we pay specifically related to PMBs, we've paid an additional 1.8 billion above scheme rate. I think some of this was touched on earlier in the previous presentation, but just giving a different perspective, and this is 2014 data prepared by our actuaries, and it shows that in 2014, 5% of beneficiaries were responsible for just over half of all of the claims in that year. The key point, though, is that 5% changes in each year. It's not the same people. So there is and this again highlights why social solidarity is critical in a medical scheme environment. I'm not going to repeat this. You saw this. The example earlier was at 80%. The GEM-specific one is 79%. We offer 5 plans as GEMS. This has been since the inception of the scheme. Sapphire and Beryl, the first two are more network-driven plans, lower cost options. The middle one, Ruby, is what we call a savings plan. And then Emerald and Onyx are the two more comprehensive plans. Emerald is the one that is the most commonly selected by our members, close on to 70% of them. Onyx has a large proportion of pensioners in that plan, and it's the one plan that currently is loss-making. I think the point I was touching on earlier around affordability, I think this has been a fundamental focus of GEMS since its inception, so that all of the plans that GEMS offers across the 5 plans, there's a contribution that is linked to the income of the member. So in each of the plans, there's bands that separate into low, medium, and high income, and then the contribution is linked to that, which very specifically addresses affordability and access to the appropriate cover. Now, one of the key challenges that we've been facing over the last few years is that since 2011, the employer has not changed the subsidy which assists the member. And therefore, from 2011 up to the end of 2014, the member portion of contributions increased from 35% to just under 50%, so almost 50-50. During the course of last year, the employer and unions, as part of the 3-year cycle of wage negotiations, there was a settlement on the medical aid subsidy, and so this was retrospectively implemented from the beginning of 2015 to correct for some of the non-change in the subsidy for that prevailing 4-year period, and an increase in the subsidy of 28.5%. And the numbers you see, I'm not going to go through them. And going forward, the subsidy to be increased annually in line with medical price index. That change then brought that change from 35% to 48% of the member portion closer back to around 40%. So 60% covered by the subsidy and 40% by the member. Now, this slide highlights the criticality of the subsidy to affordability for our members. So on average, across all of our membership base, their premium contribution represents 20% of their income, whereas after the subsidy, that drops to 8%, and you see the individual numbers by plan. And the Sapphire, which is our lowest plan, is virtually then fully funded. The 8%, just as a guide, they say that if below 10% is a international benchmark that typically people contribute towards health premiums. This is part of our submissions on an annual basis for our plan approvals. Our actuaries also do a comparison of similar plans on the marketplace, and on average, GEMS is 19% more affordable compared to comparable plans. Then coming back to what we were mentioning about how we empower our members, part of the work that we did in improving our benefit design is to make sure that we're offering all of the current available best practice in terms of screening. So listed there are all of the screening tests that are paid out of risk to identify earlier members that could be succumbing to certain chronic conditions. Also, we've introduced various vaccinations, and very specifically the HPV vaccine also we have now started to fund. I think what was also presented by Dr. Rajesh at BHF around the importance of schemes moving towards quality assessments. Since 2014, GEMS has now entered the HQA assessment process, and we're increasingly using it as a tool to measure the performance of our disease management programs. It's still in its early stages, but it's a first step towards this concept of clinical governance. The kinds of disease profile that is common in our membership base from a chronic point of view. Diabetes, just around 90,000 members that have diabetes. Hypertension, over 200,000. We have the largest program on HIV outside of the state at just under 120,000. And then on average across the scheme, about 1 in 5 of our members, 20% of our beneficiaries, have one or more of these chronic conditions. Let's skip that slide. again, just a different way of looking at it, either directly or indirectly, a large portion of our costs are linked to hospital or hospital-related costs, whereas a much smaller percentage towards primary care. In terms of managing those diseases, then we have a number of programs that we currently run. The one I'm going to share some more information is on HIV, and then we do have general programs around back-end diabetes, but this year we're going to introduce a more specific program around the two of them. Just in terms of the HIV area, this shows the similar measures that were shared earlier around process measures around HIV, our enrollment, viral load suppression, all of that in line with what are appropriately considered benchmarks. But what's more important as well is that we've been able to demonstrate reductions in hospitalization related to pneumonia and TB as well. And then, as indicated earlier, we have very important stakeholders, including the Department of Health, as an example. And so in terms of the NHI, we're working closely with the Eastern Cape Province, MEC of Health. The OECD data, which was shared with the Health Market Inquiry, GEMS data was used as part of developing that information. And then we're also working with the Department of Health to supply data around male medical circumcision. So essentially the way that we try and manage the health and health risk of our members, we have two approaches. One is around developing networks. We have a well-established family practitioner network. We've just over the last 2 years started to build up specialist networks. So we have now a pediatric and ONG network, and during the course of this year we're intending to introduce 3 more specialist networks. And then we're working towards the development of a hospital network that will be linked to a plan. And then on the disease management side, we have a number of programs that I've indicated previously. What is the impact GEMS has had into the insured environment in South Africa? I think that we, in the initial period, had a incredibly rapid period of growth. As I indicated, just under around 1.7 million beneficiaries. In the insured environment, GEMS is responsible for 1 in 5 of all insured people in the country. And across both private and public, 1 in every 10 rand that is paid is a rand paid by GEMS. I think the Council for Medical Schemes data shows that the growth in the insured environment since 2005 to 2014 has been mainly in the restricted scheme environment, and that is predominantly as a result of GEMS. The non-healthcare cost I've touched on already, but we believe that was the introduction of GEMS certainly played a role in moving costs down across the industry in terms of non-healthcare costs. I think the last impact that GEMS has had is that throughout its setup, it applied principles that would move towards the goal of universal health coverage. So GEMS, even though it operates on the Medical Schemes Act, chooses not to apply any waiting periods or late joiner penalties. The contribution increases are calculated related to the income of members, and it has one of the broadest definition of beneficiaries. I think this slide was also showed around some of the challenges. Clearly that the hospital and specialist costs in the industry have gone up throughout the period, and GEMS's experience has been similar. And a key underlying reason for that, we believe, is related to the PMB legislation and this issue of paid at cost and pay in full. And the related impacts as a result of that. I'm not going to go into the detail, but in the submission and in a number of slides, and I'm going to just try and go pretty quickly through them, but this shows again the impact of how much of GEMS's payments are related to PMBs. You can see that from 2010 to 2015, it's increased from 61% to 72%. Again, if you look at the GEMS data across by discipline or by disease type, you see a general increase across that period. Again, our sense is that the underlying basis is a result of the PMB issue. Then the graph on the left just shows how much of what we pay above scheme rate, and that trend has been increasing from 2011 to 2015. In 2015, just over 1.8 billion above our scheme rate paid towards PMBs, and cumulatively that figure is over that period just over 6.8 billion rand. And then as a percentage, it goes from 9.2 to 11.4% over the period. And then I think just our perspective on a potential way forward is that we do believe that there needs to be certainty brought into the PMB area around what is constituted as what should be paid for PMBs. And our submission is that there should be a ceiling or cap placed on this so that it's known what is the maximum, so that members have no co-payment exposure above that level. And then below that cap, then competitive forces can result in people playing lower than that. And a good example, and that was touched on a little bit during the BHF presentation, is that there is an example in the health sector related to the SEP introduction, in the way that the SEP is increased is in a transparent and controlled manner. And what you find is that as a result of competition, then below that level, actually none of the manufacturers translate their full increase into that cap. And that could be a model and framework that could be considered. And then I think, again, a message that's been shared by a number of presenters is that the PMBs themselves they are due for review, and they should be looked at to ensure that there's a more primary care element as opposed to a hospice-centric component. Thank you.
Yes, thank you.
Thank you very much. Thank you very much. I'd just like to ask the first question, your comment on the reserve ratio in general and specifically as it applies to GEMS. And yeah, okay, let's take that first. Thank you.
Thank you. So the current legislation requires that one should reach a reserve ratio of 25%. GEMS at the end of December 2015, we were at 9.9%, so significantly below that level. As a result of that, GEMS is classified in what the CMS terms an ICU category, so we have to formally report on a quarterly basis to Council on how we managing that reserve ratio matter. We also provide a 5-year forecast on how we will get to meeting that requirement. But I think the Council has issued a circular where it is investigating moving towards a different methodology. GEMS has made a submission around that, and the indications are that there will be some form of risk capital-based model, and we believe that that would be a more appropriate reflection of how a reserve ratio should be targeted, and based on that, we believe that that would be the way forward on the matter. Okay. Yeah. Thank you.
But in terms of trend, what has happened? Because of course the scheme went through a prolonged period of outstanding growth, but I understand it's starting to plateau.
Yes.
What has the trend been on the reserve ratio side?
No, thanks. So, in fact, in 2015, we actually had a principal member decline. So actually, it was the first year that the scheme experienced a decline. A lot of that was related to that if you look at from 2011 to 2014, with no change in subsidy, the member was being exposed to a double-digit increase for 4 consecutive years. And what we've seen is that immediately that the subsidy was implemented, from that month onwards, we've experienced monthly growth in our membership again, which highlights the issue of affordability and subsidy. What's interesting is that as we've had a decrease in our membership, at a per member level, our reserve actually increased by 1,000 rand, from 3,000 to 4,000 per member. So it shows you that how growth very substantially impacts your reserve ratio.
When you review the premiums, are you specifically looking to sort of improve the ratio, or it's not a major concern owing to the size, owing to the stakeholder you have in government? Is there something that worries the scheme?
No, I think that we operate under the Medical Schemes Act, and so the target is very important for us to work towards. And as part of how we report to the scheme and the plan that we propose, the council monitors it very closely. But what we can say also is that on the assessments done by our actuaries and in the submission that we made, that we can say that from a risk capital point of view, GEMS is well capitalized to meet any of its obligations.
Yeah. Regarding the, I tried to read but got a bit lost at some point. But just to be clear, regarding tariff negotiations, you negotiate with hospitals and
laboratories.
Yes.
Yeah.
But this is obviously part of the point where one wants to understand the market power dynamics. How do you handle tariff negotiations with professionals?
So basically, in terms of setting up, for example, the specialist network, very much in line with what you heard earlier, that we issue a open invitation at a higher rate for individual practitioners to choose to contract at that rate. Okay. So that's how we go about the specialist networks. In terms of increases on the networks that we already have, the rates we firstly consider the Council for Medical Schemes guidelines that are issued. We also look at what our internal experience has been in the preceding year, and we try and make sure that we find a balance between affordability for our members and the tariff increase that we can sustain. In general, we aim for around a CPI-related increase for tariffs across the board for various provider groups. And then we also have to manage the impact of utilization.
The reason why I'm a bit, I said I wasn't sure, is that I do remember reference to the fact that there are too many practitioners, so GEMS basically works on a GEMS rate for those that you cannot negotiate with. I think there's something like that. What was the context compared to the...
Yeah. No, so maybe just to clarify specifically to providers in general, I mean, we will pay any claim, whether a person is contracted to GEMS or not, up to the GEMS rate. So then the member is exposed to a co-payment. In the networks that we have, then what we're asking for is that in return for that rate that we offer in the network, that there's no co-payment or exposure for the member.
Okay. But the GEMS rate is determined unilaterally by yourselves as far as practitioners are concerned.
Yes, it has its genesis in the NHRPL over time, and then it's been increased, relatively speaking, related to CPI. But again, we try and differentiate between our network rate and our non-network rate to attract providers into the network.
Okay. All right. Yeah. Okay, no, I'm fine. Thank you.
So if I want to understand, I'm just carrying on exactly where I left off. If I'm trying to understand as a member of GEMS, the only advantage I get by restricting my choice in terms of provider to your network is I don't pay a co-payment. That's the only guarantee that I get. I don't get any other benefit as an individual, and I don't get a benefit as a collective. You're not saving money if you're paying the same rate.
I think that in terms of the co-payment exposure and what I was relating to affordability, one of the biggest issues our members raise with us over and over is that any additional co-payment exposure is a huge issue for them. So that's a material benefit for our members.
A lot of the preferred provider networks pay their providers more. Do you pay your preferred providers more than you pay the other providers?
So the network rates are higher compared to the non-network rate, correct?
I saw that peculiar. Am I right in I'm trying to understand your slide number. Anyway, it's the slide, Cabinet Mandate 2004, Registration 2005, Funding 28 billion 2015. Do I understand that was funding to GEMS to set up?
No, my apologies. No, that is the contribution that we collected in 2015.
Okay.
Yeah.
All right, so it's not a... and then you're interesting for us because you're different to the others. So the difference is you keep speaking about the subsidy, but should we be understanding that subsidy as equivalent to the employer's contribution in other medical aids? Okay, so I think it's useful to make that point. So it's, in a sense, really, it's a typical closed scheme. It's not a different closed scheme. Okay, good. And then the other difference that you have is you use a gazillion ways of negotiating. So you subcontract out this, and then you subcontract out that to somebody else, and then you do some of your own stuff, but you cost less than everyone else in terms of that. So how come you're so smart and the others aren't so smart? How does that work?
That's a very difficult... the first point is that I'm relatively recently appointed, so a lot of the success of GEMS is related to the hard work that many other people did in thinking through its setup. I think that, just to clarify, there's two ways that GEMS approaches. One is in the administration and the managed care services that it procures, that it follows a supply chain model, and that supply chain model has a tender cycle, and within that there's competition. So people know that there's no guarantee of continuation, and when they tender, they know that they've got to consider quality, PE, and price. So that's how that works. The part that we do ourselves, which is negotiations, that GEMS does conduct its own negotiations with providers. So we do not let our administrator do that. We conduct that ourselves. So those are the two areas.
Then the last question from my side is that in the first series of hearings, we had presentations from the unions, and they didn't have anything nice to say about you. And of course, it's not you personally. So the kinds of things that they were saying was, it's difficult to get what we want, and we can't always have what we need, and the administration's poor, and I don't know what they do. Please don't, I'm not quoting them directly. It was, what do the trustees do, and do you know how much money they earn, and the people who are employed, they earn a huge amount, and they don't think you're doing such a good job, and you've presented to us that you're doing a very good job, better than anyone else could do for them. So how should we understand that difference of opinion?
No, I think that, so firstly, I apologize if I gave the impression that everything that we do is going well. I think we face significant challenges. I think we're in an incredibly complex stakeholder environment. Just to give you one sense that last year we had the highest complaints rate we've ever experienced as a scheme. Part of it was related to the fact that it was in the year where the negotiations were happening. So that also highlights some of the dynamics that were occurring. So our member frustration was very high about the fact that the contribution increases continue and the employer contribution, as you've indicated, remained unchanged. They see that as a reflection on GEMS. The flip side of that is that now that there's been a settlement and the employer contribution has been increased, our members see that it's GEMS having done it, even though it's not us. So I think we do see that the unions, I can tell you that in the first 6 weeks of this year, I've spent meeting 6 of the 9 union leadership that we engage with, because they are a very important stakeholder and they make very clear the expectations from the scheme. And there's many areas that they're not happy with. And part of the settlement was that at the PSCBC, which is the chamber between the employer and the employees, there's an intention to review GEMS and to look at to what extent it's met its original objectives. Yeah.
Can you just give us an example of the kinds of things they're unhappy about? Because it's not so much what's wrong with GEMS, it's what's wrong with the system, and
Yes.
that's what we're interested in.
No, fair enough. So, I mean, during the course of last year, we had close on to 40 stakeholder engagements with ordinary members, branches of unions, and union leadership. And I think some of the issues are general and some of them are specific to GEMS. Some of the general issues that members raise are that, their benefits run out very quickly during the year. Another part is about the complexity of what they're buying, so not understanding, well, that, paying this money, why am I not receiving the consumer benefit related to that? Issues around how does the formulary around generics work? Those are, or why do I have to go to a particular doctor? Those are some of the typical issues that we face. The more specific around GEMS, and I think that's one of the things we've realized in those engagements, is that the model of engagement in servicing of our members has been largely through what we have is a call center or walk-in center and some web-based engagement. And it's my honest assessment that you need face-to-face servicing of our members. We had a pilot project as part of an initiative to support a country goal around employment. And in Gauteng, 3 years ago, we introduced what we call client liaison officers. It was employing unemployed graduates, and we trained them up to service our members. Over the last couple of years, we've taken the decision now to expand that over into the next 3 years nationally, and they will play a key role in educating our members around the benefits that they have. I think it's a key thing, realization, and that's more GEM specific, that we need to have done a lot better. Yeah.
Is beryl a semi-precious stone? Is it? I don't know. Oh.
I'm told yes.
Thank you for your presentation. I have just one question. In your written oral submission on page 523, you talk about that GEMS does not yet have negotiated preferred provider arrangements. That's paragraph 431. Then the paragraph below that, you state that your designated service provider is the state hospitals. And I noticed that in your presentation on the slide that you show all the different options, there's state as the hospital network as a designated provider is only mentioned under Sapphire, your cheapest option. I just wanted to know is the state also a service provider for the other options? And how do members of your medical scheme respond to that? Do they understand what they're opting for when they opt for that lower option that they are designated service provider is the state hospital?
Right. So the state is our designated service provider for PMBs across all of our plans. The Sapphire plan, the public sector is the only option available to the members, so they can't choose anything else. However, for the maternity benefit on Sapphire, we also cover for private hospitalization. Then across the remaining plans, our designated service provider for PMBs is the state, but the member can choose to go to a private facility. And if they do that and it's a voluntary use of a non-GSP, then we pay at scheme rate.
In that case, there would be a co-payment.
That's correct. Yeah.
Last one. No, not the last one. Thank you very much for your presentation. Did I understand correctly that roughly 60% of the contributions are being subsidized? So that is heavily subsidized. You're a heavily subsidized scheme, aren't you? And in that sense, it's not incidental that your plans are on average 19% more affordable. Can I make that combination?
The comparison is at the contribution level.
That's right, but
yeah.
I'm sorry, I wasn't clear. So you're 60% subsidized. Do you have any idea what the average subsidization is on other restricted schemes?
So the next biggest closed scheme in the public sector environment is POLMED, and we've done comparisons on our contribution before subsidy. It's not a straightforward comparison because GEMS has 5 options and POLMED has 2. But if you take Sapphire and Beryl and you compare that to the lower option of POLMED, and you take the Rio options, which are the higher options of GEMS versus the higher option of POLMED, then our contributions on average are lower, not to the extent of the 19% before subsidy, but then after subsidy, given the nature of the difference in the subsidy methodology, the POLMED contributions are lower post subsidy compared to GEMS.
I'm sorry, but that was a public scheme. Your comparison on 90% on average more affordable was across the board, isn't it?
Yes, correct. Open and closed schemes.
And that should be compared then to taking it into account the subsidies that private employers provide for their members. Am I correct to make that meaningful, the 19%? That's Christoph.
I think if I understand the question correctly, it's important to make the point that the GEMS contributions that you see are gross of subsidy. So you should not subtract 60% from the contributions. We're comparing the employer subsidy is covering part of the published contribution of GEMS, but if you look at the GEMS contributions compared to the contributions of other schemes, you are comparing apples and apples.
Yes.
If that was the question.
Yes, that was the question. That's correct. Thank you. Can you, if I look, because I think it's important to understand GEMS' position in the industry. So as an economist, I tend to look at GEMS as a market on its own. Do you consider yourself having competitors in the industry?
I think mainly from a member point of view.
Yeah.
I think and to the earlier question that was asked, one of the frustrations of members is that they feel that in a way they're forced to be on GEMS.
Yes.
So one of their questions always is that would I be better off if I were at another scheme, or if I had the choice to be on another scheme? So in that sense, we do compete in the sense that we've got to constantly demonstrate value to our members.
Yeah, but
in that sense. But I take your point.
The point, yeah.
Yeah.
Yeah, yeah. So we could say that actually you're not, in a full competitive market for yourself. Normally speaking, an open scheme or a competitive scheme would be disciplined by the market. And now, of course, one of the reasons for this inquiry is the question whether that works all 100% in the South African environment. But normally speaking, that would be the case. So in your case, where you are actually representing a captured market, would you agree that the influence of beneficiaries, of members and beneficiaries in the scheme then sort of replaces market competition? Right.
Sorry, I wonder if you could just if we could have your answer on the record, please.
Yes, sorry.
So you agree that in your case, where you represent a more or less captured market, the influence of members and of trustees, of course, would have to replace what competition normally would do in a more open market. Now, I'd like to understand how then the governance framework within your organization works. Actually, we would like to understand how that works in general, because there's a number of question marks we have here. And I think Cape Medical Plan will go into greater length in their presentation, I hope, on how they deal with the interest of the members and representing interest of the members to the management of the scheme. How does that precisely, what is the influence of members? How do they complain? How do they get influence to the management of the scheme? And of course, it's a different. I mean, you're a huge scheme, and Cape Medical Plan is a small scheme. There's differences. And how do trustees? How are they evaluated by schemes? How does the members' interest translate through trustees or directly through committees or whatever to the management of the scheme?
Yeah. So I'll start, but I'll ask Ginny to add. Yes. So we, as I indicated earlier, we operate under the Medical Schemes Act. It prescribes very clearly how you set up, how the board is determined. So it's 50% represented by members and 50% by the employer. The employer appoints them through the Minister of Public Service and Administration. The members through an election process. And we currently work on a 6-year cycle.
Can I just do... So members through... So you have 1.4 million members. How are 6 people arrived at, and who are they? How?
Yeah. So there's a nomination process. So members have to nominate a fellow member for the election process, and then those that meet all of the requirements, the minimum number of signatories,
yes, they
then get placed on that nomination process that is circulated to all of the members, and then there's a voting process that is conducted.
Are these normally people that are politically active already, are known to a broader audience, or just the average scheme member that suddenly starts floating upward? How does that in practice work?
I think it is a combination. There are trustees elected who are, for example, well known because they are employed in the Department for Public Service and Administration. There's also some union mobilization of their members to vote for particular candidates. So, and then there are other members who just believe that they do know a lot of the members. They've got a good profile. Their CVs are published during the time of election, and members can also make an election on that basis.
All right. And then, so that it could be people that have a position within a ministry that can float up. And there's also members, the other 6 are members of the department, of the employers, which are, again, the departments, and who will be elected by the departments to how's it go? Yeah.
The Minister has full prerogative in respect of appointing trustees. They don't need to be public service employees. He can select people from the private sector as well. So at this point in time, I think there is only one of the 6 employer trustees is also DDG at the Department for Public Service and Administration.
That's right. And would you and how's the direct consultation with members going on? How's that? You mentioned stakeholder engagement, but these are more incidental. I gather. You referred to last year, but how is the structural consultation with members?
So as I said, we have firstly a walk-in center where members can be serviced. We also have the call center route, and then as part of our benefit design cycle, what we do is that in a 2-week period before the benefit design, we go out on a engagement exercise with members, and then post the benefit design process, we have a roadshow communicating. Also, I think probably the best example I can give you is that our AGM is well attended compared to any other medical scheme. The scheme is extremely challenged during that process. So out of any other environment, I think the GEMS environment is you would find the most activist kind of stakeholder engagement, either through members directly themselves, forming their own groups, or through the union leadership process.
And then you said that also the function of the trustee is a reflection of that as well. It's a complex environment. So we heard that, and it stuck to my mind, is that the remuneration, I hate that word in English, of trustees of GEMS is even double what is the next closest in a scheme. Can you must be able to explain that. You have probably explained that quite a lot of times. Is that related to the typical work of the trustees in the GEMS environment compared to other trustees?
Yeah. So I think there are some fundamental differences in the operating model of GEMS compared to other medical schemes. So firstly, related to the outsource model, we have tender evaluations. And so one of the requirements of the board is to be the final adjudicator on this tender process. So that's one example. The second one is that we have a far more broader ex gratia process. So we do provide assistance to members that when their benefits run out, and again, part of that, one of the subcommittees of clinical governance and ex gratia, it's a committee that engages on that. In terms of the remuneration, we use a third-party assessment to make a recommendation. As you've correctly pointed out, GEMS has the highest paid trustees currently. The remuneration has been left unchanged for 3 consecutive years. And then the last thing, I think to me that's the main test, is that GEMS has a 10-year unbroken record of unqualified audits. Unqualified audits. And if you just take the environment in the value you would place on that. And you can, when the CMS presents next week about the challenges of putting schemes under curatorship, the figure is less than 0.0 something percent of the contribution. It is an issue, and it's engaged on with the board and at our AGM, etc. I can't make a judgment on whether it's the right amount or not, but what I can tell you is the track record of the scheme in terms of governance.
One last issue I want to raise, and that is, you said that you have amongst the lowest non-healthcare related costs a year. But of course, if you compare prices or costs, you have also to compare what do you get for these. So the service that is provided. I'm not here to defend administrators that represent much higher costs, but what we were confronted with in the last sessions that we saw sometimes also. Obviously, in my mind, I sometimes compare you with Discovery because you're both quite quite big. And we saw a statement of a doctor, he showed it on a screen, where Discovery analyzed its practice actually in one sheet, precisely what this doctor was doing on average, compared to the average in terms of hospitalization, in terms of cost incurred in hospital, in terms of cost of pathology referrals that he did, radiology, etc., etc. So there's a full picture which suggested quite a bit of IT behind the picture that was painted. And of course that must be paid for. Have you ever compared yourself in that sort of terms as well? Not only in terms of absolute number of the absolute figure of non-healthcare costs, but also in terms of what you can analyze, how sophisticated you are in analyzing doctors, hospitals, and contracting, and of course translate that into better position during contracting.
So I think the first comment I would make is that GEMS is relatively a younger scheme compared to some of the other role players, and you mentioned Discovery. So, some of our life cycle of where we are is that we went through the first phase of rapid growth, introduced this multi-administrator model which had an impact on costs, but increasingly we're shifting our attention to the healthcare component, and that's the path we're on currently. In the way that we appoint administrators in managed care, we go through a supply chain process. The biggest component of it is technical capability, and a key part of the technical capability that we expect is the IT capability. I wouldn't want to hesitate to comment on our capability versus Discovery, but suffice to say that we look very closely at a number of areas. I mean, a common issue that's faced in our industry is around fraud, waste, and abuse. We also conduct peer review exercises when we do negotiations with our hospital groups. Our managed care service provider is able to provide detailed quality, cost, and utilization data. I would think comparable with whatever is considered best practice.
Thank you very much.
Thank you, Josh. Just one more question regarding, I just want to know how the scheme manages pharmacy benefit, medicine benefit, both the acute and chronic.
Okay. So in terms of the medicines, we have a formulary process. So it's called, we use the MPL process, and MedScheme is the service provider. So on that, that's the funding model around medicines. There's also an exclusion list based on clinical criteria. And then from a chronic point of view, we meet, there's a separate allocation for funding for chronic versus acute and OTC. So there's three buckets of funding pools.
What is the situation regarding networks? Do you make use of networks for the delivery of?
Yes, so for chronic medication, we have both a courier service, so Medipost is the courier pharmacy provider currently, and then if a member chooses a retail pharmacy, we have an extensive network, I think closer to over 1,500 pharmacies, both corporate and standalone retail, that a member can select to get their chronic medication. And the split roughly currently is 40% at the retail and 60% courier on the chronic side.
Okay. Yeah, but because we had, you will know that we had PSSA, community pharmacies, and the DPA last week. A lot of time was spent actually describing problems with the courier pharmacy side of things. What challenges have you encountered regarding this, and have those problems affected how you want to review this in the future?
I think just maybe the first comment I would make is that compared to some of what the other schemes do, we actually offer far more choice to our members in terms of accessing both retail or courier. That's the first thing. The second thing is that out of all of our service providers, we do surveys with our members. The service provider that gets the highest rating by far is our courier pharmacy.
You mentioned that over the last 10 years you've received a clean audit. Is that right?
Yeah, unqualified.
Unqualified. I'm sorry, unqualified. There is a difference, is there, between a clean and unqualified audit?
I'm not an accounting expert. I know that the term used is unqualified audit.
I understand. It does mean, though, doesn't it, that you are subject to the provisions of the Public Finance Management Act, is it? No? Okay.
No, sir.
No, okay. Now, what's the status of CHAIR? You were established pursuant to a resolution of cabinet, is it right? Now, what's your status? Are you an organ of state, or what are you?
Yeah, no, we are a medical scheme under the Medical Schemes Act, so we're not an organ of state. We're not a public-private partnership. We're not within the scope of a PFMA. So the full regulatory framework, as it applies to medical schemes, also applies to GEMS.
The fact that you operate within the state environment doesn't attract any additional responsibility, does it?
I think that as part of our stakeholder responsibility, we place enormous focus on all of the key stakeholders within the public sector.
And what does that entail?
I think that we ensure that we keep the ministry that represents the employer on GEMS. We have quarterly meetings with them. We provide reports on how the scheme is performing. We have regular engagements with Treasury, CHIPA, with the Department of Health, all in the union. So we regard staying in regular contact and informing them around the activities of the scheme as a key priority.
Is there anything in the Medical Schemes Act which obliges you to do that?
I think to the extent that it's to ensure that we adequately responding to our members, all of these parts of government the employees of government are members of our scheme. So I think, to me, it seems to be the right thing to do.
Yeah, it may be the right thing to do, but does this mean you account to the state?
No, we provide information, and we invite them to our AGM, for example.
And there's nothing which requires you to do that, right?
I think the relationship is also around the subsidy. We must make the employer must be happy that the subsidy that they are paying is well spent. So I think that's a very important part of our reporting to them, because they can decide to change it.
So to that extent, then, every now and then, you have to account to the state on how you're using the subsidy. No, the nodding is not going to be recorded.
Yes.
So their interest is also in how well the scheme is managed, and are the public service employees, are they satisfied in the scheme?
Does this carry a threat that the state might decide to relocate the business to somebody else?
I'm going to try my best to answer the question. No, I think that the medical scheme is there to serve its members, and with the creation of government, and government can choose to the Policy Act to change that. I mean, I think that's not for us to decide.
But am I correct, though, in understanding that the relationship is simply based on the fact that this is a restricted scheme, which where the employer is the state, and therefore it is in your interest and that of the state to make sure that the state is fully informed of what's happening within your scheme.
And the employer is represented through
Yes.
the employee,
Right.
employer-appointed trustees.
Okay. Now, what is the risk that a member has if the member were to decide to consult a doctor who is not contracted?
I think the main issue would be that the member is potentially exposed to a co-payment if their provider chooses to charge above what the scheme is paying.
But you would not penalize the member simply for going on?
No.
Yes. Now, if you go to slide 52415, I think it is. 524.15, I think that's the page number. I don't know whether you have it there, but it is a slide that deals with major utilization cost drivers. Do you have that? Well, let me put this to you. What this document indicates, it indicates that on provincial hospitals, the costs paid are in the region of 101 million. I think the figure is not so much important, but it's the fact that you've got it.
I've
Yes.
got it, yeah.
Now, are you obliged to refer your members to state hospital?
Okay, so on PMB-related conditions, when there's a pre-authorization for a hospital admission, what we would indicate to the member that the DSP arrangement for GEMS is a public hospital. If they choose to proceed with, and often at that point when they're applying for that authorization, they've already indicated that they're planning to be admitted at a private facility. We would indicate to them that if they choose to the private facility, GEMS will pay, if it's a PMB condition, and it is available at the public service, that we would pay at the GEMS scheme rate.
And the only exposure there would be a co-payment?
Yes, it would be the co-payment and mainly related to the specialist costs. So the hospital cost, even in the private sector, to almost over 98% of it is covered. So unless there's some items that are what we call our uncovered items, or the level of care was inappropriate, that would be the only condition. But otherwise, the vast majority of the hospital component is covered. It's the specialists that charge this 200, 300, or 400%. That's the issue that the member is exposed to.
Some of the submissions suggest that the quality of treatment or the quality of service or healthcare services at public institutions is not that one would hope for at these institutions. Are you aware of this sentiment?
Yes, I am.
Does it concern you? Is it what before that? Is it a reality?
I was hoping I wasn't asked this question. No, I think I can only speak as an individual on this matter, so I'm not representing anybody's view but my own. I think that I'm a medical doctor. I'm trained in South Africa.
Yeah.
I had the privilege of being trained in some of our finest institutions. I'll give you the example of in 2000, my daughter, who's now 20 years old, she developed leukemia. We were told that the best facility is, at that time it was called Chobochen, Charlotte Matseke. And I must tell you that we were blessed and privileged for the best care in a public sector environment. I have family members who continue to work in the public sector, but there's no doubt that some of the, let's say, excess challenges in that there are issues in the public sector, but some of the best quality in all of those specialists and doctors that practice in the private sector are trained in our public institutions.
What steps, if any, are being taken to ensure that the quality of healthcare services in the public sector are the kind that one would hope for in this sector?
I think that our Minister of Health has very clearly articulated that there's a number of steps being taken to strengthen to use quality assessments to make sure that certain minimum standards are met, and over time that would be both private and public. And I think that all organizations need to support that initiative. And as GEMS, we're undertaking a number of initiatives working closely in a small way to contribute towards that.
The one case that comes to mind is a case that occurred some years ago of an individual who had all kinds of ailments ranging from kidney failure to heart disease and high blood pressure, who had been going to private institutions, but after the funds had been exhausted, he then went to the public institutions. But when he came there, it turned out to be that the dialysis machine had a long queue, resulting in the hospital authorities developing a policy on who gets first. Because in the best judgment of those who were making these decisions, the dialysis would not have made that kind of any difference in him. He was not prioritized because of a shortage of these machines. A machine which was, according to the facts of that case, served 2 provinces. I don't know whether that's the situation now or whether that has changed.
I don't know the details, but I know the case you're referring to. I think the doctor was Dr. Sarala Naika who treated the patient. Yeah.
It's a case that came to the Constitutional Court many years ago.
Yeah. Now, I think that, you know, it's very clear, and I think, again, apologize, I'm paraphrasing our health minister, but I think it's been shown consistently across many countries that the right direction is to move towards some form of universal health system. And in the South African context, we call it NHI. It's the right thing to do because it takes away the issues that you're raising. You know, access to care should be based on need and not on income. Yeah.
Thank you. Now, is there anything else that you wanted to add? Yes. Yes.
I'd just like to understand the nature of your relationship with the managed care that you outsource. I'm interested in the form of the contract. How does it work?
So we specify through a terms of reference process what our expectations are. Based on that, then we have bids for that. Whoever we then contract, we contract on SLA requirements that need to be delivered. We do not enter into any risk sharing or risk transfer arrangements.
So you pay them a per capita fee?
We pay them a per member fee.
Per member fee, yeah. How do you know that you get value for money? What kind of reporting do you get?
As I said, there's detailed SLAs that have to be reported on. We have oversight over those contracts, and then we also have independent auditing of that. What we have started to do is introduce outcome measures that we focus on, and as I said, we're in the early stages of that, but very much along the lines of what the BHF shared earlier. We're starting to include in our contracting, not with any incentive, but purely as a measurement exercise around quality outcomes.
I'm just interested in a few of your indices, both your process and outcome indices, if you can give any.
Okay, I mean, so we set timelines within which if someone forms in for a hospital authorization, how long the time should be to wait, within what period that authorization should occur, the adjudication of claims, the payment of claims. So each of the service elements, there's defined standards against which they're expected to perform.
And if I'm a member and I'm phoning in to ask to resolve an issue, do I know who I phoned for what? Because I could be phoning one of two different people.
We have a single call center number for all members, and then we have a provider call center for providers. So for the member, there's one number that they dial, and through that, then they will be directed to the relevant service.
You didn't make written submissions initially, right?
We did a while, July 2014. July 2014.
Well, that was to the revised statement of issues. To the statement of issues. I mean, written submissions that were called for on the 1st of August 2014.
Haven't made any subsequent.
Is there any reason why that didn't happen?
No, I think that we've been, wherever possible, whatever information requirements, and we've been submitting extensive information as required. But we commit to following up.
I can't hear you.
We commit to following up on the matter.
Yeah. Okay. No, I'm just curious to know why is it, being one of the largest medical schemes, why you didn't make written submissions initially when these were called for. I thought perhaps there were some reasons. There were reasons for that. You don't know.
I would say that we've, at each stage, we've attended all of the public briefings. We've made an initial submission. We've met face to face. We've been asked extensive additional information which we provided, and we're very willing to be part of the process.
No, I understand all of that. Most of the stakeholders responded to a call for written submissions. Right? And you didn't respond to that call. That's all I wanted to know. I know that subsequent to that, you've met with the technical team, you've responded to questions, and so on. But I wanted just to find out why that happened, whether it was an oversight or whether...
No, it wasn't oversight. From our side, we thought that the issues that we had wanted to raise, we had stated in our original submission and in what we've presented here.
I beg your pardon?
We did make an initial original submission, and what we've presented with the submission are the areas that we felt would be of value from our perspective.
Well, I understand.
Did your trustees at all indicate that they wanted to... It's something, I'm sorry, I didn't ask the other schemes as well, but did your trustees indicate that they were interested in presenting at the hearings? And for all other schemes you're presenting, I'm curious on this issue as well.
So we provide them with details around how we've been, at our last board meeting, we informed them that we would be presenting on behalf of the scheme. The trustees didn't indicate specifically that they want to present here, but what I would want to indicate is that on all of our member engagements, our trustees join us in engaging with the members.
Is there anything that you would like to add to what you've told us?
No, sir.
Yes, thank you. Thank you very much for coming to share with us information concerning GEM. We're sorry we had to keep you until late. We hope you will understand.
Thank you.
Thank you very much. Are you ready to proceed, sir?
Yes, sir.
Yes. Would you be kind enough to state your name and who you represent, and then you can then go ahead.
Okay. Good afternoon. I'm Dr. Sugain Naidu, and I'm representing EMC DFPA in this submission.
Yeah, just for the record, just give us the full names.
EMC stands for Emerging Market Healthcare, and DFPA stands for Dispensing Family Practitioners Association.
Yes. Okay, very well.
So, good afternoon, panel members and members of the audience. Thank you for this opportunity. Let me commence by stating that I'm a practicing medical doctor from Mitchells Plain, Samora, Michelle in the Cape Flats, and I've been there since 1991. I'm here in a leadership and a representative capacity to provide our perspective as an organized and committed group of family practitioners. Many of these have served the communities for over 30 years. On a daily basis, we experience the challenges of crime, patients who are seriously ill, burden of disease where we don't have enough resources to allocate. So issues of benefit design, DSP contracting, access, affordability are real issues to us. We have already witnessed the demise of the corner pharmacist. And as we sit here, although these issues may not be as real to the funding industry, it is especially in these poorer areas that the challenges of healthcare are highly prevalent. So against that backdrop, let me commence this presentation to highlight some of the substantive issues raised in our submission in October 2014. I'll provide a brief contextual overview, then give some input on what our organization and providers believe are challenges and competitive challenges in the private healthcare industry, and then conclude. Unlike other presentations, we'll be focusing on mainly the non-financial issues, on the rhetoric and challenges at the coalface. We can justify some of our statements in the answer sessions, and shall certainly try to do so. I trust the panel and the members of the audience will feel some of our frustration as we talk through this presentation. When we started as an initiative, The group was founded in 1984 as a group of doctors, and that's how an IPA started. It was effectively a medico-political group. As a business, effectively driven at the coalface as a non-for-profit that was started in 2004. But we always had the principle of two constants, that's the service provider and the patient. So we believe we have these grassroots credentials and service provision credentials, and we are therefore in favor of an inclusive patient and provider-centric approach, and hope that this approach will be collaborative with the funding industry. As we've stated in our submission, we support a code of conduct that abides by the ethical criteria of the Health Profession Council. And in one of the sections later, I will highlight that discord between the Health Profession Council Act and the Medical Scheme Act, as we see it. We believe that GPs play a crucial role in directing patients through the healthcare pathway. And the contracting environment should stimulate this positive sum competition between GP and specialists, thereby restoring, above all, collegiality and sound ethical behavior in a profession which is needed most. As an organization, we have tried to adopt an independent mindset. We've experienced non-vicious natures of discrimination in our stance. Based on this submission, we need to declare that we've been pyloried after our submission. We introspected and realized that as passionately as we feel about some of these issues, some of them have been too emotive to consider, and hence I will try to steer away from that in this presentation. We maintain our presence on administrative forums like that of Discovery Health and MedScheme, and on the positive side, we've witnessed how these administrators are moving to a more inclusive approach, and we believe our views are being respected. We'd hope that this environment and all of us here work to collaboratively and with good, sound, and qualitative governance to improve the plight of care at where we deem it the bottom of the pyramid. And I reference a seminal work from Hummel and Pralahad professors in the 1970s that talked about $1 at the bottom of the pyramid. We are already in trying times, and where this failure to change and adapt has borne its ugly head in various sectors and institutions, contributing dramatically to the prevalence of economic apartheid in especially the areas we serve. And I state that simply to illustrate some of the challenges. The challenges on how we operate, how we charge, that we see the burden of low-cost options, yet it's so tightly managed that we are unable to render appropriate service. I'll now move on to the section that covers market power and distortions at various levels. It goes without saying that matters affecting competition within the private industry have been deeply entrenched pre- and post-94. Whilst change and transformation have been advocated at higher levels, we have not seen this in the greater private industry, and they've remained resistant to such moral and needed social imperatives. With regard to profit extraction, as we've submitted, the upstream costs, and we can quote from your Government Gazette of the 2012 costs, there's clear evidence that it's private hospital driven, and there's evidence of over-servicing. And we believe this is taking medical inflation to unsustainable levels within the broadest South African perspective. We believe that the three private hospital groups are arguably in an oligopolistic environment. It is invariably this private cost and specialist extraction from the scheme payouts that have led to a benefit design that is skewed to a hospitalization rather than a renewed focus at a primary care level. The coding history, the development of such codes, and the authors of such coding have been instrumental, we believe, in sidelining crucial elements required in sustainable healthcare system like coordination of care, gatekeeping, and rightfully primary care patient attribution and allocation. In terms of healthcare contracting, we've seen the for-profit administrators, with their close relationships with the non-for-profit medical schemes, dominate that contracting environment. And like other doctor groups, we are simply have a facilitating roles at these forums. As such, non-healthcare costs are driven at an administrator level, and we have seen managed care interventions not bringing down general healthcare costs in a fair and appropriate manner. So in an environment and an information age where disintermediation is occurring, it is difficult to create a logic of layers of representation. And we've witnessed this where one group can get arbitrary advantage of another, or at times a doctor over another doctor. We've illustrated this in our submission. It can be similarly argued that tools that are used at our level, like peer management profiling, should be a secondary focus behind a commitment to radically change the medical benefit design and address organic growth in the low-cost options so that there can new entrants for beneficiaries that need to enter. The Gazette from 2012 states 8.7 million beneficiaries in that medical schemes environment. And it can be argued that such mechanisms for review of practitioner should be prospective and driven by actual peers with clear independence from any representative body, administrator, and certainly without any conflict of interest. There is also merit, given these large cost extractions at an upstream level, that such profiling should occur from a hospital level downward based on these historic claims data. Especially in the low-cost environment, there are certain DSP arrangements that fly in the face of ready, willing, and able contracting, creating restricted access, invariably reducing choice at both patient and provider level, and leading to potentially unethical supersession challenges. We have seen and we have cited this issue of cherry picking occurring at a low-cost option and a DSP arrangement to support that option. And we can state that the poor patient, especially in the geographic areas of the townships, can least afford travel and other indirect costs of seeking healthcare. Our points on barriers of entry and expansion of firms is about the quality of opportunity. It's an environment where there's naturally turf protection. And unfortunately, the structural barriers to new entrants have been inherent in the funding industry since the time of our inception. The corporate intrusion into primary healthcare has already seen the demise of the corner pharmacist, and we have to humbly ask the question, is the same fate going to happen to the township family practitioner? So in the paragraph on the factors limiting access by consumers, it is not an easy process. It is related to patient education. We will allude to this in my next factor. But suffice to say that the laws of DSP contraction within the Medical Scheme Act allow for such contracting. However, the moral challenge of choice, inclusivity, and access have been ignored, such that we've seen risk-sharing arrangement benefit the shareholders in a managed care entity for profit rather than appropriate healthcare benefits and access being offered. We've had challenges within our own founding group on that same point, which had a lot of political ramifications. As pointed out earlier, these low-cost options have become so tightly managed, and when they fill the rooms on a Monday morning, the practitioners complain with the hesitancy of what to do and the frustration of what to do. And inadvertently, we believe care may become substandard. The very nature of the Medical Schemes Act on leaving out primary care cover from the PMB regulations have meant that cost-effective primary care models cannot be developed for such low-cost options, and for that matter, the traditional options. So I talked about patient education, and I'm going to put that important factor under imperfect information. We accept that it's a market characterized by imperfect information. Administrators dominate the landscape with their claims data, profiling tools, and related. But what we see is that the patients are not educated about their benefit design. Whether it's at the brokerage level, at a sales level, at an employer level, is difficult for us to fathom. But a large percentage of our time goes into explaining to that beneficiary the actual issues of information related to that benefit. And within that, these concealed managed care concepts are not understood by the patient. Provider profiling is driven by claims data and not by practice output or practice data sets. And the data is often limited to scheme-specific sets and not factoring the overall practice demographics and practice burden of disease. The advent of the electronic healthcare record and supporting technology hopefully can impact positively on cost and behavior, and can leverage and let providers control and own their own data in a properly managed environment. The last points on the factors of the impact of the regulatory framework. As I alluded to, the tenets of the Medical Schemes Act and the tenets guiding ethical practice of the Health Profession Act, we believe, are discordant on a number of issues, including DSP, contracting, choice, and supersession. It's known that providers from all areas already have dispensing regulation, including the SEP regulation. So we believe that the Medical Schemes Act has to be dramatically amended to look at the sustainability of these low-cost options, and to have a compromise or an engagement to have these two clear regulatory frameworks talking to each other. The Health Profession Council Act, or the Health Professions Act 1973, is in dire need of being updated, as it is the governing framework for medical practitioners. There are various aspects, the Consumer Protection Act, POPI, as well as undesirable business outcomes, as evidence in the funding industry, that need to be incorporated. And importantly, there needs to be a review of the scope of practice. What is it that a family practitioner or a GP can do? At a primary care level, can that scope be increased to include bedside radiology, pathology, and procedures? Can that cater for the social constructs of an NHI environment and serve as a harbinger to accreditation and compliance with the right degrees of quality? It would not be easy for us to talk about the specific impact of interventions previously made. We know what the Competition Commission has ruled in previous or other sectors. We've cited certain examples, and we can talk to those examples if questioned about them. But we are pleased that the Competition Authority has broadened their scope beyond just price fixing, price setting, and vertical or horizontal collusion. And we're using this opportunity to illustrate some of the challenges that really occur at the coalface. This coordination of tariff setting and adoption of coding systems needs to be sorted out. And there hopefully can be a trade-off in organizing and reporting information to maintain this positive sum competition and rivalry among practitioners and or groups. From a legal and quality of governance perspective, it's going to be interesting how the relationship between practitioners and hospitals are going to be better understood, accepting what is right and addressing what is a perverse incentive and therefore harmful to costs, prices, and quality of treatment provided. We have stated the importance that providers need to be regulated by the Health Profession Council, and there needs to be clear ethical guidelines to abide by. In this environment, we remain for our blessings and sins that dissident voice, steadfastly refusing to be populist or simply rubber stamping matters. We see ourselves as part of this collaboration and an important and constructive engagement to sort out matters that are clearly unsustainable. We believe competition is occurring at the wrong areas and at the wrong levels. We've illustrated in our submission how group dynamics, gamesmanship can skew a market. But when we talk about governance, when we talk about board of trustees, we are really out of that loop. We are not sure what happens there. We don't have a bearing, and rightfully so. We are service providers. Before ending, it's important that I've not dwelled on the challenges of a fledgling black business in the private healthcare environment. It's not about the non-vicious discrimination. It is about the need for us to collaborate and embrace genuinely working with each other despite our differences. And I hope our story highlights this. In concluding, Mr. Chairperson, we sincerely hope that by advocating a value-based competition at a DSP or primary care level, there will be a renewed focus on treatment outcomes, geomapping, pricing transparency, information accessibility, and importantly, preserving of choice and patient and the right provider. We will answer questions and provide examples as you're deemed to ask the questions. Thank you.
Yes, thank you for the presentation.
Thank you very much. I read your submission and I listened carefully. I think I understand what you bring to our attention. I have a bit of a problem in really understanding who you are. Not you personally, of course, but the organization. That would be nice as well, try to figure out who you are. So you are a group of doctors, 2,600 doctors now, GPs, and you're representing the interests of these GPs, I take it. So you're, can I try and see whether I understand what you're doing? So you're a network of doctors, and I've said, so a network of doctors offering services. At the same time, you are a managed care organization that normally manages doctors. So are you managing yourself and then offer your services to a scheme or an administrator? Where do I put you on the scale of things?
Thank you for the question. I will try to answer it. I was assuming I'll get an economic question, but we will try to provide as crisp an answer as possible. I think it's a long story, not just who we are, what are organized doctor groups in the landscape of South Africa. Historically, there's been IPAs, Independent Practitioner Associations, and these have been, historically developed and positioned. Ours is one of those group, our founding group, the DFPA, the Dispensing Family Practitioners. Back in 97, this group, along with other founding groups, not IPAs, but what's called partner groups, had an agreement to form or change MASA to SAMA. That's our links to that kind of political thing. The group of doctors that we have as the DFPA as an IPA are predominantly based in the Cape Flats area. In 2004, they took a decision to look at trying to outline a network of practitioners and create a platform for IT infrastructure to look at the interests of township practitioners across the country. In this network, that's called the Emerging Market Healthcare. That's the 2,600 you referred to. These are contracted family practitioners then, majority of which are dispensing, many of whom have cross-affiliation to other IPA groups, and many of whom are non-IPA affiliated, but they exist in the country. As a service, we've attempted entering the managed care field, but we failed. We've not had capacity, we've not had balance sheets, we've had difficulty rolling out our IT infrastructure, and we've deemed it not singular mentality on the practitioners, we've just deemed it the healthcare landscape is dominated by administrators. So it's impossible to herd cats, as we've stated. Notwithstanding, we have these doctors that contract with us and give us certain mandates in terms of our healthcare contract with them. We per se, at this juncture, don't go to a scheme and say we can provide managed care services. We say we're a network and we're in a representative capacity in those forums I mentioned earlier.
That explains. So you presented us in your submission with 3 pages of where you present yourself, who you are, who the people are behind this, and there the concept of a managed care organization still is fully alive. And now you said we failed to develop that in a commercial sense, and now you're back to being a network.
Yes.
Yeah, thank you very much. That is clear now to me. One additional question. So you mentioned to us what you would like in terms of price transparency, etc., etc. But what is your real main recommendation to us? If you had our pen in your hands, write it down. What is your main thing?
Let me answer the question against this lens. First of all, when we have meetings with our practitioners, it's about clinical management, it's about accreditations, it's about upskilling. And the talk about the practitioners, the family practitioner, is what has been iterated in our submission. The frustration, issues of being regulated or managed in the funding industry. So rather than going into another rhetoric, let me compare the traditional managed care to what would be the ideal. You use the word pen in our hand. And I just want to quote some issues of managed care. So from the 2010 medical scheme data, we saw the criteria of traditional managed care being focused on hospital risk management, medicine risk management, including formulary, disease risk management, and then provider risk management, and the payouts are declared each year. On the provider risk management, the focus is on profiling, peer review, DSP contracting, and at times clinical consulting at an administrator level. However, if we change that around with the pen in our hands and talk of us being autonomous, obviously being managed, being regulated, with IT infrastructure that we can manage, we can answer a few of the questions, a few of the issues of healthcare that I'd like to raise and use that opportunity. So a patient with elevated cholesterol or high sugar often cannot explain his or her condition on why he or she should be on treatment. We face this every day. We have 15 to 20 minutes, sometimes 12 minutes for a consultation. We have well-educated people and sometimes not so well-educated people. We have an HIV patient who is not sure of his or her clinical indicators.
I'm afraid
okay.
It's quite a bit of text that we have to write in the report then, but can you?
Yes. So what I'm saying, and let me just do 2 more examples and maybe I can illustrate it better. A hypertension patient who's not taking their medication regularly, or a GP profile where antibiotics are being prescribed to treat upper chest infections where they should be treated virally. So we are saying those are not being managed. The managed care interventions are being done retrospectively on claims data, looking at provider profiling, looking at the wrong areas where it should actually be streamlined to empower the GP to get better healthcare outcomes and be incentivized for those outcomes.
Thank you very much. It's clear.
Thank you. In your written submission and in your presentation now, you talked about the challenges of DSP contracting and the cherry picking that you think is going on between the medical schemes and yourselves. In the written submission, you've included an addendum of your application you lodged with the CMS, highlighting issues of poor governance and also conflict of interest, and how the contracts that you were initially invited to, you were then later on excluded. What was the outcome of this? Could you tell us more about this complaint?
I believe we've been pyloried about this matter, but I think it's substantive enough, and thank you for asking the question. So I'll go back to the letters in our addendums on the 2nd of September 2004, and am I allowed to mention the scheme and give data? Yes. Okay, so the scheme was BankMed, and the scheme, I believe, had a noble intention to create this grouping of the various organized doctor groupings. And one of our concerns, ironically, at that stage, before we were a founding member. So one of our issues that a founding member cannot just be kicked off or their views not appreciated. And we wanted a governance where we actually have a competition commissioner analysis. Apparently it was given to one group, but not us. And against that background, whether we went back to the scheme, tried to effectively, handle the politics that occurred amongst the groups, we were sidelined out of those negotiations. But the first and fundamental point is that we had legal advice. We were afraid that if we were in a company vehicle as directors, there were hefty fines. I can recall like 500,000 if there was any collusion or horizontal dominance of 30% or so. And we felt that if we are together, we can basically, be dominant in the market. So that was one of the issues. The second issue was exactly who are we representing it? Is it our constituent groups? Because then we should empower those groups and not create a central vehicle. So there were various other concerns. Our sadness was that we felt that the scheme itself should have engaged with better due diligence, with better understanding and appreciation of the various groupings there, and see to a relationships that could have been much better handled rather than the acrimony which it's currently being handled. Have I answered it?
I just want to see if I understand. Tell me if I describe back to you what I think that you're trying to tell us, if I'm right or not. You've got a different model, and there's a barrier to entry for that model because people aren't interested in it. And they're not interested in it because of the way the system works. Is that what you're saying? That you've got a new idea and no one's interested in your new idea, even although you can show that your approach is one that has patients' health outcomes as the primary concern? Is that what you're telling us?
Partly so. And I'll try to answer that as best I can. Obviously with the bias that we're a family practitioner group. And we're saying that the cornerstone to healthcare, like with NHI, which we should all collectively embrace, whether it be nurse practitioner, primary care practitioner, it is a good thing. And the same with primary care. A practitioner is engaging with coordination, with screening, with wellness, with the family at heart. Obviously, they must do the right things. They must be reviewed to address things that are not being done right. And that's why I always alluded to the ethical conduct of the Health Profession Council. But I am saying that, and we are saying, if the administrators can actually appreciate and empower groups like ourselves with us in our IT infrastructure, we believe that the costs, especially the non-healthcare costs, can be dramatically reduced, and there will be a better and more appropriate claims payout to practitioners that are driving better healthcare outcomes. Meaning changing a healthcare outcome from a diabetic whose HbA1c is 8% at a year start and changes to less than 6% at year end, and that's where money should be appropriately spent. Or for the patient that's treated properly for back pain rather than having surgery at a hospital.
So you'd prefer, I mean, are you putting on the table a geographically located capitation model that would then go to you and you get a per capita payment and you measure it on outcomes? Is that what you're putting forward?
So confidently about outcomes, we can say that, because the nuances of practicing in the township is that you can't balance bill. We can give you the rates that we charge our cash patients. The fact of the matter, in the low-cost environment, what is seen to be the norm is a hybrid form of capitation, meaning you played a small cap fee, then a global encounter fee, and kind of patients that you see out of network, a fee for that as well, to try and manage that component. But the facts as we see it is in the low-cost options that the burden of disease is higher and patients need care more. And hence, this issue of just blindly taking risk transfer may not be sustainable, especially in the current medical schemes environment. So what we're postulating is actually a radical change to empower primary care benefits. And then based on that, we can review our business model, as it were.
No, thank you, Dr. Naidu. I think on the one side, I hear, well, I'm getting a sense that there's frustration that you can't, or you're battling to sell your model to the administrators of the schemes. But I just want to ask directly, is that a function of maybe they're just not being aware of the benefits of your product? Or as Prof Fon has asked, is it an issue of you being blocked, whether it's by competition, that makes it difficult for you to access this market? Is that the issue?
Thank you very much, Doctor, for that question. As we stated in our submission, the contracting in a primary care basis is being dominated by an administrator. So the consideration should there be a standard unified contract? Because there's so many, there's a plethora of different rules and contracts. Two, should we, as part of those organized doctor groups, demonstrate and show our skill and capacity and be empowered to deliver and have deliverables against our bundle model? And certainly the answer to that is yes. Thirdly, the challenge we're facing and where we are blocked is that administrators are dominating the ownership of the healthcare record. So it's the claims data, it's the healthcare record with their learning curve effects, which means effectively we just have to partner, but at a low level. And it's therefore that frustration, effective stymieing of what can be done. The last point on that is very important. Let's assume we have a scheme contract, a new scheme. We are given a scheme contract. And we put in a code of conduct, look at our contract, give a reimbursement. I would state here clearly that it's easy to develop a network.
Okay. I mean, I mean, you make reference here in your submission as well about some of the words you referred to as old boys club, and I'm just thinking as well where you seem to be channeled when you are going for business. You're being told work with these guys who basically are your competition. Have I got that right? Is that one of the problems? Meaning that to get a certain type of business, you must be in partnership with well connected or favored competitors to you?
I think the best answer is let me speak against our history and facts as we see it. I think for us as an entity, when we had a founding group located in the Cape Town area and expanded nationally, we almost barked more than we could bite. That's the first point. The second point is we did develop the IT infrastructure to manage that. And thirdly, I think it's a challenge where and we need to introspect ourselves. Amongst us organized doctor groups, there's representative forces, there's relationships. That mentality we alluded to in our submission certainly existed, and we found that challenging. But look at it from the other side. Those parties could claim, but that doctor belongs to me. And we advocated clearly upfront, no differentiation between an affiliation. We actually advocated don't pay the non-IPAs a membership fee. And I think that's part of the constructs that we faced, and we maybe have been too ambitious about that, noting how deeply entrenched some of those issues are. However, we stood firm that as we went to providers in whichever area they wanted just two things, wherever they are. They wanted to know what was the volume of patients, what was the reimbursement, what was the risk they could engineer, what could we do as a value-adding service. And therefore, we could advocate that setting up a network or competing is not necessarily a bad thing. It will jack us all up to actually develop capacity at the core phase where it's required.
The doctors that you represent or that form part of your group are based largely in the township, is that right?
Yes.
These practitioners, as I understand it, they have special needs and special problems and special challenges.
Chairperson, if I can paraphrase what you're asking, you want me to comment on what our practice issues are and what we can and can't do.
No. You've got specific challenges that you face from practicing in the township.
Okay, so I will illustrate a few. I'll start with the sort of package area, which is a very important issue you've brought up.
Perhaps before you give me the example, can I understand this? Do the sort of challenges that you face from practicing in the township differ from those challenges facing your colleagues who practice outside of the township?
At the risk of not being too detailed, I'll answer the question, Chairperson, as follows. First of all, in our areas, we have to dispense. We cannot script because there's no corner pharmacist. Dispensing is integral to our service. Secondly, certain of the procedures we do are done on an events basis, injuries, dog bites, whichever. And the procedure aspect is sometimes very onerous, especially at busy times. The pricing we look at has to be what's affordable in our areas, because down the road we'll have a colleague that charges 150, another colleague that charges 200, and patients at that economic strife are very price sensitive. Almost at the same time, if a medical scheme has a levy, we in the main are forced to write it off because that's the behavior. And over the years, it's very rare if we have one or two practitioners contracting outside the so-called tariff that has been set. And then the last point on the peculiarity of the medical scheme, be it 2012 8.7 million beneficiaries, whatever component of that is in the low-cost options, we believe we're seeing the bulk of it. and we are getting a differential reimbursement than those, I would call it, above the railway line. At the same time, our vested interest, the practitioners are for business, and they would want to make more money, but they are constrained at how they charge. We're obviously advocating right practice, proper business for proper outcomes and proper pricing.
Precisely what constraints do you face? Are these because of the environment in which you practice?
So the constraints can be very unique to practices. Some practices are still in very crime-ridden areas. Computers get stolen. The age of the practitioners, getting IT literate is a challenge for the doctors. The frustration about how to code and how to understand coding of ICD-10 to be better equipped to get doctors to be empowered and trained. The resource constraints at the township level, where we would want to be able to afford nurse practitioners and so forth, but we simply can't.
You suggested in the course of your presentation that the practitioners in the township are under a threat, just like the pharmacists, unless something is done.
Thank you, and I did say that, so I have to substantiate it, or try to. We see entities, large corporate entities, wishing to employ a practitioner. We see corporate groups, sometimes vertically integrated to hospital groups, setting up medical centers. But the solo practitioner is there with a sort of set level of standards, of hours, rendering care for 30 years, trying to enhance care, but committed. And the competition or the multidisciplinary approach brought by corporate is not necessarily respecting that practitioner that is there. And in the similar environment, the corporate basis of managed care, where risk monies were taken by the managed care entities, and as the young lady asked there, that cherry-picking exercise meant, for example, in our group, which was a real issue, that, in an area of 50 practitioners, 5 were chosen, or 2 were chosen. And that is against, we believe, the grain of a ready, willing, and able basis.
Do you know the basis upon which those who were selected were selected?
The answer is no there. We could question it. There was no data forthcoming on that part of the examples we cited. However, what is happening now, it's not a cherry-picking exercise, is that in the low-cost environment where we alluded to patient education, patient allocation, we would hope that the people who are doing that business of getting these people enrolled is actually allowing that patient to choose. We're often seeing a patient being defaulted to a practitioner based on historical claims, which is not necessarily the issue. That's the patient is given a choice to go to practitioner in areas.
You've proposed that the Medical Schemes Act must be dramatically amended. Do you have a sense of the respect in which it has to be amended?
I'm going to answer this by referring to those 2012 data, where 36% of premiums went to hospitals, 23% of claims payouts went to specialists, and then 7% went to GPs across the land. Now, GPs are a cornerstone of gatekeeping and coordination. Certainly, we cannot advocate for over-service at a GP level. But certainly from the burden of disease statistics, and we've been shown this at some of the forums we attend, that based on the demand and supply upstream, not enough care is being addressed at a primary care level. So we believe if there's a radical change or a re-engineering of the benefit design to incorporate a GP benefit like a PMB or risk-related benefit, that would, one, enforce better behavior from the patient in not doing self-referrals upstream. Two, make the GP care more onerous to the GP that he's being measured for providing outcomes. And three, allow the scheme and the basis of how they are regulated in terms of their reserves and payouts to actually appropriately reward care that's done at a primary care level.
Thank you. Is there anything else that you'd like to add to what you've told us?
Mr. Chairperson, no, thank you for the opportunity. We are willing to participate. If there's any information supplementary to our submission we need to provide, we can do so. We would have liked to put more numbers and clarity in our submission, as we believe this is a step in the right direction to correct some of the challenges that are existing out there.
Okay. Thank you for making time to come and talk to us about some of the challenges that your group is facing, and thank you so much indeed. Again, we apologize for keeping you for more than you would have considered necessary. Thank you.
No problem. Okay.
Thank you for your patience. The Cape Medical Plan. May I take this opportunity to perhaps take advantage of your generosity and ask if we could just have a 10-minute break, just to stretch our feet? Would that be okay?
Yes. Thank you.
Yes, thank you. Shall we come back at 6 o'clock?
No, they will be here, I think, but I have to bring them.
I think we can now start. And let me thank you once again for your generosity and extraordinary patience. I wonder if you would be kind enough just to place yourself on record and who's with you and who's going to lead the discussion.
Thank you, Judge. My name is Derek Shardlow. I'm the Principal Officer of Cape Medical Plan, and I have a colleague with me who will introduce herself, and also one of our trustees who will introduce himself. Thank you.
Good afternoon. My name is Charlene Skimman. I'm the General Manager of Cape Medical Plan, and I'm also a member of the plan.
Good evening. My name is James Wynn. I'm a trustee and a member of the Cape Medical Plan.
Thank you. I understand that in the submissions that you make, you are not in favor of administrators, but I do think that we need an administrator who's going to administer our time so that we can finish and hear people timelessly. Yes, go ahead.
Thank you and good afternoon. In fact, we're all members of Cape Medical Plan in our individual capacities. So the model that we intend discussing, it's something that we personally believe in as well. Our scheme, apart from a brief introduction, we'll be speaking a little bit about the regulatory environment and the other issues there around not-for-profit insurance, third-party administration and tariff negotiations, along with member choice. How do members choose a scheme? What about third-party payers, which is what we are? What are the issues around the strength of anti-selection and the billing rules contained in the doctor's billing manual? And then, of course, we can't leave out prescribed minimum benefits and coordination of care. The purpose of the inquiry is to determine whether the process of competition in the sector is working well or whether it can be improved. And for today, we've been asked to put some of our focus onto the various relationships that we have as a scheme with the different stakeholders. We hope that our presentation will go some way to answering these questions and perhaps even demonstrate that there are changes that can be made to the manner in which the private healthcare sector is regulated but also operated. We hope that this will in turn address the very real and urgent concern of the cost of healthcare that is actually undermining the constitutional right to access. Cape Medical Plan is a small, self-administered, not-for-profit medical scheme. Why do we even mention that? What is the importance of mentioning that for our members as well as potential members? And we hope to illustrate that this afternoon, or as my colleague said, this evening. Whilst we certainly are and do provide short-term insurance, which is what all medical schemes do, in other words, month-to-month cover, that's what it is in terms of the structure and the legality, which commences on the payment of each monthly contribution. We try not to administer the scheme just as a short-term insurer in a typical short-term insurer manner. The philosophy of Cape Medical Plan is to genuinely run the scheme as a mutual society, in which mechanisms exist for the members to be involved and have decision-making powers beyond those required by the Medical Schemes Act. And this philosophy is fully endorsed and supported and brought into being by our Board of Trustees. The framework exists and management structures are designed to allow positive member input and involvement. And we believe that this gives life to the social solidarity and mutuality principles, which after all is what a medical scheme is supposed to be about, if you look at the Medical Schemes Act. And if you look what a medical scheme is supposed to be doing. Cape Medical Plan certainly subscribes to and supports the fundamental concepts enshrined in the Medical Schemes Act of open enrollment, community rating, and the requirement to include prescribed minimum benefits. Having said that, we do also, though, have concerns about the unintended negative consequences of these concepts, as well as the way they are being implemented, and in some cases abused in an incomplete regulatory environment. We support other role players who share these concerns, but we do not support the withdrawal of these fundamental pillars, which we see as part of the equitable access to healthcare. The Medical Schemes Act does legislate a certain level of member participation rights, but we go beyond that because that is our underlying philosophy. The members are the scheme, and the scheme is the members, not just in theory, but in practice. And this is our model with which we operate the scheme. Right in the middle there, we attempt to promote mutuality, to create the balance between entitlement, because there are entitlements, and responsibility. We don't see one greater than the other. There's no entitlement without fulfilling one's responsibilities. And why do we do that? We do that so that we can provide the means to defray legitimate healthcare costs. We believe that doing that will create long-term sustainability. And we believe that that will promote social solidarity amongst our members and those who want to join the scheme. Because it's because of the collective that the individuals are able to get benefits, and we must never forget that. So, to achieve these ends, we have at the top there of the slide, it shows that amongst the mind and the spirit of the membership, we want to increase and create a sense of pride in belonging to this mutual society. We believe that the management of the scheme must be visible and practically accessible to the members, whether they're board of trustees, principal officer, general manager, it doesn't matter. Members have the right to engage with us. We hope that we show genuine empathy, but it has to be empathy that can be afforded and supported by the collective. We hope and try to create a peace of mind and confidence amongst the membership in our decision making, because sometimes the decisions are not liked. Sometimes the decisions are not what the member hoped for. But if they believe in the integrity of the decision, it makes a big difference to the final outcome and how they go away once a decision has been made. And to do that, we use IT, of course, we use knowledgeable, skilled staff. We believe that our product design and benefits support the needs of the collective and create long-term sustainability for them, even though legally it's short-term insurance. We try to balance those two concepts. We have, as our own system, a fully integrated system which processes and drives rationalized administration. And last but not least, communication. We try to communicate and meet members' needs by supporting a transparent approach to what we're doing, encouraging compliance with the rules, because the rules that the collective have agreed to is what creates the rights and the entitlement in practice. And we believe that the membership supports our governance of the scheme as we have it. And the Board of Trustees is one example All but one of our trustees are members of the scheme. So it's important to us, and that we've been able to achieve the skill set that's required out of the members. We have a system whereby we have contributions paid by the members, of which 100% of every rand that they pay funds benefits. We do not use monthly contributions to fund the running of the scheme. We'll talk more about that later. But it's an important component and philosophy of how we believe we should be dealing with members' money. In order to promote this relationship, the rules of the scheme, of course, they are considered by management, they are looked at by the Board of Trustees, they are proposed to the members with recommendations about why we think they should be this or why they think they should be that. But in the end, it's the members that vote and agree to accept the rules or not, and any changes to the rules. Sometimes that's a process. Indeed it is. And sometimes it takes quite a lot of explanation. But it's done and should be done. And we can do it in a scheme like ours. After that, they go to the registrar and say, this is what we and the members have agreed, and then the registrar decides to register them or not. And sometimes the registrar will make an alternative proposal, which goes back to the members, and an explanation is given. So it might take sometimes a little longer, but that's the price you pay for genuine member participation. In fact, our rules say that the members must approve the rules. The changes in the benefits that the members receive, sometimes it's additions, sometimes it's amendments, and sometimes it might be even a removal of a benefit, are proposed and discussed with the members. They'll then vote to accept or reject those changes each year before the benefit sets are sent to the registrar. Again, considerable discussion takes place, but it's worth it in the end, because then you get member buy-in, because then you get member support for what you do offer and what you don't offer. Now, obviously, there's a process whereby members need to be educated to some degree, and they need guidance and they need help with the decision making, and they need to be given that. They need to understand the consequences and ramifications of agreeing to this benefit and not the other. And then, of course, there's the PNB legislation, which creates a minimum base. The members cannot go below that. They cannot vote to take out something that's a PNB. So there are controls, checks and balances in this process. Cape Medical Plan believes that all of this gives substance to the view that CMP is the members and the members are CMP. And consequently for us, there's no rational, devious or profit-linked reason not to pay the legitimate funding benefits that the collective membership themselves have approved. To deny legitimate benefits in our particular scheme would mean that members act against themselves, which is a powerful, we have to live up to that expectation. We have to be able to explain to an individual member why something has not been paid, because they know that that's how it works, and they can call us to account on that. We purposely operate the scheme to ensure that the rights of the collective and the rights of the individual who make up the collective are balanced and in synchronization with each other as far as we can. That does not mean that members don't ever complain. It also doesn't mean that every individual has every expectation fully met. And it also doesn't mean that we don't get complaints going to the council periodically. We get all of that. How much we get, we think is reasonable and we think is fine. And how we deal with it matters. Every member, for instance, who makes a complaint, if it can't be dealt with quickly, it gets escalated to Charlene or myself, and we discuss it with the members. We will meet with the member. We have face-to-face with the members so that complaints are resolved and misunderstandings are corrected. And we think that's the way to do it. I would like to hand over to my colleague, please, to continue with the next part of the presentation.
We have two diagrams that we've drawn up because I think it simplifies where we stand as a scheme and some of the players that are involved in the scheme. The first diagram represents who Cape Medical Plan is. We are the members of Cape Medical Plan, and the blue around is the scheme. That's who we are. We support the members administratively. Now, it's been spoken about in many of the documents, Alex van den Heever's report, the Minister of Health's report, that the consumer coming into this environment finds it very difficult to assess information, and as a consumer of a normal product, usually they can withhold demand, they can have a look around, see what's on offer, look at the prices, and make decisions based on that. This is not always possible with the consumer of healthcare. They are going ahead, they are buying a product, and often they only get to use that product when they need it and they're in a health situation which could be critical, and there's also a lot of emotion involved, so they don't always make logical decisions in terms of price and quality. And this is where we as the scheme come in. What we are here to do is to act as a provider of information to the member and assist with the buying process so that informed decisions can be made. If we have a look at the different blocks, we would deal with the healthcare providers, being the hospital groups and all the other healthcare providers. Our function is also to deal with other service providers. When I talk of other service providers, I mean anything legal that we need to have done, actuarial services, IT support would all come under other service providers. If we move to the left of the diagram, we have other entities that are very strong in the market, and as Cape Medical Plan, we have not found the need to deal with these entities, and we'll talk about that later, being your outsourced administrators, your brokers, and your managed care providers. So this basically encapsulates who we are as a scheme and what we do. Having a look at the second diagram, now some might say I've overcomplicated it, some might say I've simplified it. But what we see in terms of a lot of the other schemes is that you have the scheme and the members. You have the healthcare providers, the other service providers. You have the interaction with outsourced administration, the brokers, the managed care providers. And then you also have providers of other products. For example, the products you have there are things like incentive programs, etc., and some of the products that fall under the insurance ambit not covered by the Act. The member is sometimes dealing with the broker, they're not dealing with the scheme. In fact, sometimes the broker is dealing through an employer and they're not even dealing directly with the member. The member has contact with the healthcare provider, there's contact with the outsourced administration, managed care providers, but often there is not a lot of contact between the entity being the scheme and the members, which we think is not the ideal situation to be in because the members are the scheme. The scheme does not exist without the members. And what is the scheme's function if they are not going to be there for the members? Moving on then to the different areas of the presentation. The regulatory environment has been spoken of a lot. We've had it in the BestMed presentation, we've had it in the BHF presentation, and we would just like to enforce that the regulations that were set up to support social solidarity, being your open enrollment, community rating and inclusion of PMBs. Cape Medical Plan supports these. Open enrollment is necessary, so there's a non-discriminatory access into healthcare financing. As far as community rating is concerned, there is no individual risk rating and we support this. The requirement to include PMBs means it extends the social security network to ensure that the vulnerable groups are protected from catastrophic out-of-pocket expenditure. However, what we have seen happen is that without other regulations coming into play, the mutual society has no protection because human beings, sometimes being what they are, know how to work the system. And we will talk about it more under anti-selection. But there is no mandatory cover. There is no payment tariff in terms of PMBs. There's no form of equalization of risk. or even a statutory reinsurance. We don't say that there has to be a risk equalization fund, but there's got to be some type of equalization to support the regulations above. These do not exist. What we have found is that consumers have learnt how to get into the system, to actually, what we refer to as take a contribution holiday. They enter the system, they do not remain in the system, and what it does is it interferes with the long-term sustainability of the mutual society. Now, we understand there are economic pressures, but people will come into the market and they know that they have a healthcare risk that needs attendance, and it needs to be attended to immediately. And therein lies the problem. You also have issues with non-payment of contributions and members that we pick up who knowingly don't declare a medical condition. Now, in terms of that, they are removed from the scheme, but they can come back the next day and join. So you have this gaming that's going on as well. And this behavior, unfortunately, we have found is very significant in that age group that you need to cross-subsidize others who have been in the system for a significant number of years. These are the vulnerable who now require funding. And often that 20 to 35-year age group is where you see a lot of this behavior that takes place. The other regulations, well, it's not really regulations, but the other legal positions that actually have an effect on the medical schemes is the insurance area, where we've spoken about the demarcation. Insurance products are on the market. They're not subject to the same regulations that we are. As far as the consumer is concerned, the consumer has no protection there. They all think they are buying A, and when they actually need to access something, they find they're buying something completely different, because they see these insurance products as medical scheme cover, which they are not. What we do find is that we have members who are buying down in terms of the medical scheme product. So in other words, they will buy a benefit cover option that is lower than they'd normally choose because they buy an insurance product known as gap cover. And this is often promoted by the broker fraternity because of the commissions that they are receiving on this. And in fact, if you go into some of those online broker sites, there are questions that are asked, and those questions for an uninformed consumer: would you like gap cover? Oh, I don't know what gap cover is. I want extra, and you'll tick yes. And when you actually get the list of the options that the schemes are offering that come up, they are the lower options that are coming up with add gap cover. So the consumer doesn't have a choice of saying, I'll take product A, B, or C. It's B plus gap cover. And that's not always in the interest of the consumer. The hospital cash plans that are out there also have an impact on the schemes. What has been discovered, and this was verified by Discovery, is that individuals who are on these plans often go to hospital more often. They also stay longer. Now, the impact on the scheme is that they are picking up the cost of the hospital cover, because sometimes these cash plans will only pay out after a certain number of days. So the incentive is to stay in hospital a day longer, because then I'm going to get my cash plan as well as my scheme covering my hospital event. And sometimes if we are looking at that, the cost of that can be anything from 10 to 15,000 Rand a day, depending which wards those particular members are in.
I think it's clear to everyone that South Africa is a developmental state, and that means certain things. Nevertheless, we do need economic activity which grows. We need economic activity that not only grows but makes sustainable profits so that taxes can be paid, so on and so forth, and a reinvestment back into the economy. Those are absolutely necessary, and we know that without them the country can't move forward. But there are different parts of the economy, and we think that the healthcare economy isn't the same as the rest of the economy. We have to understand that there need to be necessary and careful limitations on allowing the uncontrolled growth of for-profit healthcare financing, such as the insurance products, and for-profit healthcare delivery, be that through administration and or medical practitioners. We're not saying ban it, not at all. We're saying there need to be considerations given to whether healthcare is a social public good or whether healthcare is a commercial commodity. And the question needs to be asked because it makes a difference. The answer makes a difference as to how you need to regulate and deliver it and how people can access it. And the bottom line in South Africa at this point in time is that medical scheme contributions are just way beyond many individuals. The fact is they can't afford it. And often there are people who could have afforded it 2 years ago or even 1 year ago, and subscriptions have gone up all over to such an extent that they fall off the back end of this bus and everybody forgets about them. Those are the people that have been on schemes for 40 years, 50 years. Now they've got hypertension. Maybe they're not even very sick, but they can't afford the contributions. And that's not right, and that's not just, and it isn't how it should be. But we do recognize that it's improbable and probably not even desirable at this point in time that all for-profit healthcare provision, service provision from practitioners or healthcare providers should be or ought to be removed from the equation. We're not saying that. We're saying that there needs to be a greater scrutiny of fees and profits. It's in the public interest, especially if you think that healthcare is a public good. Those things cannot be hidden away. They are not the same corporate competitive secrets that you get in the rest of the economy. This is a different part of the economy. And the consumers in this part of the economy, the members, the patients, cannot exercise the same level of control over their demands and needs for healthcare as they can for other necessities. You need a pipe unblocking. You go to a couple of plumbers, find out which one you can afford. Let's talk a bit about how they're going to do it and make a decision. You can't do that with most of healthcare. It's utterly impossible for the average person to do anything nearly like that. So it is a different situation that we find ourselves in. We do recognize and want to state that there are advantages to the economies of scale of large administration organizations. It's not true to say that there are not. It might be debatable as to how effectively those economies of scale are being transferred to members, back to members, but they still exist. But we still would say that there is a place for what we would call not-for-profit administrators and managed care organizations. And how we see this developing is just as you have the not-for-profit medical scheme that's governed by a board of trustees subject to the will of the members, why can't that be extended to 3 or 4 medical schemes getting together and through their boards of trustees and under the control of their members having a shared facility, which you can call a not-for-profit administrator or a hub of shared activities where you can gain the economies of scale, where you can get the intellectual capacity, where you can get the ability to deal with managed care on a probably better basis than each little scheme can do, which is after all one of the reasons why administrators and managed care organizations came into being. But why do they have to be for profit? Why can they not be not for profit? Well, at the moment they can't be. We're not allowed to do this. It's as simple as that. And there's no one organization or rule or people to blame. It's various things. We're not allowed to collude, if you like. We're not allowed. How would we form this organization from a Council for Medical Schemes point of view? How would this be governed? How would the accreditation be done? Those are questions that need to be asked, but there's no point in asking them unless there's a willingness to look at that model. So we're asking, one of the things we're asking is that the panel will consider, is there a role and could there be a usefulness for the formation of not-for-profit administrators? They could be fully owned by the scheme members in the same way that they own their own scheme.
If we have a look at third-party administration, as Dirk has said, there are advantages of a large administrator. The problem Cape Medical Plan has with a lot of this is if we have a look at the administrators, 80% of the administration services are done by the insurance companies. They're done through Discovery, Liberty, Momentum, Metropolitan. Is it in the best interest of members? These are the questions we ask ourselves on our board. Is it in the best interest of members to be controlled by insurance companies? There's definitely a difference between their commercial goals and those of a not-for-profit organization. Even if we have a look at MedScheme, with the recent sellouts, etc., with Afrocentric and then taken over by Sanlam, and we have a look at the Financial Mail article where Sanlam stated why they had done it. They said it was to close critical gaps. It was the absence of healthcare products which made it difficult for brokers to provide a complete solution, which shows that the brokers out there are selling a whole lot of products. They're not just concentrating on the benefit of the member and the medical scheme product they should be choosing. The other comment that was made in the same article was that even though the administration fee is capped at a certain percentage, 10% of gross contribution income, it is still a very resilient business to be in. And we have questions over that and whether that can be at any advantage to members of the scheme. If we have a look at the economies of scale, we are not seeing economies of scale being evident from the administration side. We also have a concern is that if we had to go into that kind of arrangement, what information are our trustees getting? The trustees become completely reliant on the information given to them by the administrator, given to them by the managed care company. Would such a company show that they are not doing a good job for you as a client? It's a question we have to ask ourselves. The Cape Medical Plan administration costs, our last published figures, was 108 Rand per beneficiary per month. For a very small scheme, I think that's an excellent figure. What we must remember there is it's not just the administration cost, it's the complete non-healthcare expenditure, and that is what it has to be compared to. Because for others, they have the administration cost, they have their cost to the managed care companies, and they also have massive payouts to brokers. And we have seen, looking at financial statements of some of our competitors, that yes, they might make underwriting surpluses, but after they have paid all of that out, the bottom line for the members is there is nothing to add to reserves. In fact, sometimes they are taking out of reserves. Our philosophy is to add no extra cost layers, and those administration costs are entirely funded out of investment income. Now, what does that mean for the members of the scheme? Where other members are paying into schemes, part of their subscription is going to fund all those non-healthcare expenditure. At Cape Medical Plan, if we take that 108 per beneficiary per month, the members effectively have another 1,296 Rand because all the subscriptions go to pay out benefits. For a family of 3, that will equate to another 3,888 Rand per annum. The broker thing seems to be of interest, and the panel has mentioned that Cape Medical Plan does not use brokers. We have a lot of reasons for this. One of it is we see that a lot of the brokers are financially locked into commercial arrangements with the administrators and often all the insurance companies. They are often selling a basket of products of which the healthcare is just one. So they will walk into an employer group and they are offering life cover, They are offering income protection, they are offering gap cover, they are offering cash plans, and by the way, they are offering medical scheme cover as well. It is seen as a basket, and often they are not always considering the value for money of the scheme options that they are selling to the members. We don't have a problem if our member wants to use a broker. If a prospective member approaches us with a broker, then we will deal with that broker. But then the member who has decided to go to the broker will pay that broker. We don't see it necessary for the scheme to pay the broker. We don't agree with it because often the broker's decisions are not in the interest of the collective membership of the scheme. We have experienced a lot of cases where brokers have materially misstated Cape Medical Plan information, and these are large brokerages. We have also seen a report that's recently come out, a 2015 report, where it did a medical aid survey report. And we were not invited to participate in the report, but we were in there. And we were concerned over the information on the product that Cape Medical Plan offers, because we do not feel that the correct information was put into that report. So we have seen a lot of negativity emanating from non-use of brokers. As we don't use brokers, we have seen quite clearly that we do not receive employer groups. Employer groups do not come into Cape Medical Plan because the employer groups are definitely governed by the brokers. And we have seen a shift in our membership from employer groups to where we're now sitting at 80% of our membership actually comes from what we refer to as the private membership. It's individuals coming to the scheme who are generally not subsidized by their employers. Moving on to tariff negotiations. Having a look at tariff negotiations, once again we are dealing with a group. The three largest hospital groups are all listed on the Johannesburg Stock Exchange, and that clearly means that these groups are very vulnerable to investor sentiment. So decisions that they are making, their driving goals of the listed companies to ensure value for money for their shareholders. And this goal is often not aligned with the consumer's need for affordable health care. All three groupings have managed to achieve above inflation returns on investment in the last few years. And in fact, they have consistently high ratios of operating earnings before interest, tax, depreciation, and amortization. As a scheme involved in tariff negotiations, quite honestly, we're a price taker. The hospital groupings will come in, a weighted average increase is presented. Often we would be able to negotiate maybe 1 or 2% below this rate, but quite honestly not more than that. We know that in order to get a lower rate, we have to guarantee more hospital bed days, which means you have to go into some type of preferred provider contract, which might not always suit the members of the scheme. Our members are spread over different geographical locations, although a lot of them are in the Western Cape, and those are considerations we have to take into account when looking at that kind of thing. Alternate reimbursement models are also being offered by the hospital groupings. We know that the fee-for-service model is not ideal. It leads to all kinds of problems, but we do feel that some of the other models are not transparent. And one of our concerns is that as a small scheme, if the billing arrangement is not fee-for-service, there is a potential for hidden costs. And once you lose that information, it's gone forever. Collective bargaining for medical schemes was outlawed by the Competition Commission in 2004, but it is still occurring with the administrators. The administrators have a few schemes under their umbrella, and although they negotiate, they say to us one-on-one, there is some type of joint bargaining going on. As a self-administered scheme, we do not have any advantage as far as that is concerned.
We've spoken a lot about how the scheme runs for the members, but what about people who aren't members? What about people who are looking to join a scheme? How do they know which scheme and which option to choose? Well, we've already mentioned that we don't go through paying intermediaries of any kind, any form of fee, commission, or anything else. or any kind of inducement to bring members. We believe that a member who's looking to join Cape Medical Plan should do so on the basis of independent advice, on the basis of agreeing to and wanting to be part of the member-centric concept of the mutual society, and very importantly, understanding what their level of funding cover needs to be, what type of benefits that they need to have. And they can get that information from us, but they should be able to get it from anybody in any scheme in an understandable manner. This is not going to be easy to achieve. We have 3 benefit options at Cape Medical Plan. And they are structured in such a way that as you see a change in the need for your health care, or your family size changes, or your circumstances change, you can move between one and the other. We're not saying they're perfect, but they're designed to complement each other and create a pathway for members. It isn't one that's better than the other. That's not how we see it. One is more suitable for you, depending on your needs and where you are in your life. So they're not complex, and there's not large numbers of them. We're not in the business of enticing people through sophisticated marketing techniques or advertising campaigns, which just make it difficult for people in our society to identify their true needs. We have a lot of people in our country who are not used to that kind of activity being thrust upon them. You've only got to watch the advertisements on television for insurance products and how glamorous it sounds that you're going to get so many thousands a day for every day that you're in the ward. The reality, of course, is the ward fees are much more than that. But you don't know that. And it looks so good. We don't do that. Most of our members, because they're not employer-based for the reasons already mentioned, we have some, but the majority are not, actually join us through referrals. They join us, they phone up, the staff are knowledgeable. We put the philosophy forward so that people feel comfortable or uncomfortable from the beginning in what we are, so that they can make their decisions. What helps us is that we have our own IT system that we've developed and we own, and you will hear a bit more about that. This IT system that's ours is also used by other schemes, incidentally, through third parties, and we get royalties for that. So it's an income stream for our members. And we think this is a good example, and the Council for Medical Schemes knows about this. This is nothing secret, nothing hidden. It's a very good example of how self-administration can work in such a way that it benefits the members without increasing the costs and layering on more costs. We've spoken about the fact that we're a member-centric mutual society, but you need to communicate. And how do we do that? Well, we do our best to use plain language. Not that I find it easy to write short letters, but that's me. But we try and do this consistently and openly. We use electronic and paper-based communications. We hold open days with our members. We have benefit information sessions. We meet with members who have particular problems or specific problems that aren't easy to resolve in any other manner. Members make nice cups of teas in their houses, believe me. It goes well sometimes. But that's what it's about. It's about the members. Now, I know that's difficult when you're massive and when you've got members everywhere. Well, we haven't. So we're leveraging the benefits of what we are and the size we are for the benefit of our members. But fundamentally, one of the things that I think we can't ignore is that as a society, as a country, as a nation, sometimes we need to change our attitudes, the attitudes of our citizens, the attitudes of our organizations. We do not exist just for ourselves. And unfortunately, it looks like the medical schemes industry, as we like to call ourselves. We're not an industry, but it looks like that's what we exist for, just for ourselves, and not for the good of society. It needs to change. But it won't change unless we encourage and develop a well-informed society. And then we can have our rights safeguarded. Then our own rights will not be compromised, it's supposed to say there. And actually, I don't think too many schemes genuinely have a member-centric approach, and we need to look at this. I think it's one of the ways of genuinely looking at where we spend money. Because you see, if we don't do these things, and if we're not member-centric, it is difficult for members to exercise their rights. And quite frankly, schemes do not pay PMBs as they ought to in very many cases. And I know this because as the principal officer of a scheme, I also have friends. I know the two are not necessarily mutually compatible, but I do. And those friends come to me and say, you know, I've got this problem and I've got that problem with my scheme. So I will write them a letter, give it to them, they sign it, they send it to their scheme, and hey presto, voila, it's paid. Why must it be necessary to do that? Why should you have to go through that? And often, I might add, these are schemes with sophisticated administration processes. They know the things that are being told in the letter. Why aren't they paid? So I think we have to admit as schemes that things are not always the way they ought to be. So what are we going to do to change it? And how are the regulations going to be changed, looked at, or encouraged? And how are the models going to change to encourage things to be done properly?
In the system, the scheme is a third-party payer, and therein lies its own problems. There is not a complete lack of transparency in the price that someone has to pay for a health service. Your consumers are not always able to compare or evaluate the prices. In fact, often the consumer only gets to see the fee that has been charged after the service has been rendered. Everything's very electronic. You walk in as a patient, you see your doctor, the claim comes into the scheme electronically, and at the end of the day, the member will get a statement to say what the scheme has paid. This third-party payment mechanism can distort the incentives of both the consumer and the provider of healthcare to actually look at the prices that are going to be paid. The consumer sometimes has very little incentive to take costs into account. And as I've said before, the consumer often enters this market when they are feeling ill, when they are emotional, and the last thing they want to think about is price. They just want to sort out and get better. In fact, even on a dental procedure, if you're going into a dentist and your mouth is aching, the last thing you are worried about is how much is this going to cost. All you want to know is get rid of this pain, and somebody's got to pay for it. The consumer often cannot withhold demand, and this often you see service costs increasing because of this, because they don't have the chance to shop around as they would. If we take the dentist example, it is often difficult to get into a dentist, so you're just going to get the first appointment you can take. You're not going to say, how much do you charge, and I can wait 3 weeks' time to get a better price. There are also opportunities in the system for suppliers to provide more services than are required. There is a huge opportunity here for supplier-induced demand. We often find excessive and unnecessary consumption with no improvement in outcomes whatsoever. The incentives for suppliers to overservice is escalated in the fee-for-service model, and we are very, very aware of this. The supplier who maximizes the volume of his service increases his revenue, and there's little incentive for the provider to coordinate the care of the patient. We often find that treatments get duplicated. If people are going for a second opinion, the second specialist does not want to see the scans from the previous specialist. The process starts all over again. The pathology accounts come in, the radiology accounts come in. Then we have the issue of the vertical relationships that are there between the suppliers and the hospitals, where you have shares held in the hospital groupings, and you have the hospitals who are dependent on the specialists to generate utilization of the facility. This has the potential for over-servicing and supply-induced demand. Hospitals compete for specialists, not for the consumer. And in competing for specialists, they then import very expensive machinery and equipment to be used by those people, and sometimes it is not the most cost-effective treatment. Then we look at anti-selection. We've had cases where the provider has assisted the consumer who is not in the system to access the system in order to ensure continued payment. We find there are differential rates charged by the suppliers when this is going on. Excuse me. In 2014, we had a case with renal dialysis where one of our members started to have renal dialysis. Now, remembering this is treatment that happens 3 times a week. So when you're talking about a rate of 118 for a private patient, multiply that by 3, and then you take it over the rest of his life. Now, the patient started the treatment. The scheme then agreed to pay for the treatment. We needed invoices. The supplier had been paid. We then asked the supplier for copies of invoices only so we could refund the member. The supplier then went ahead when they realized that we were going to pay. They reversed all the 1118 amounts and charged us 1880.79. Needless to say, we did not pay it. We had discussed the issue with them. We then had the same case with renal dialysis in 2016, where it was 1642 for private and 2172. Now, we question why on earth the difference, and particularly in the first case where the monies had been paid to them already. It's not that there was a cash flow issue and they actually had to wait for their money. You have supplier referrals happening. Sometimes a scheme will look after a few patients who have a certain disease, and the supplier might say, well, that scheme is doing this very, very well, and they will refer more of their patients to us. This is not always to the advantage of the collective membership. The other thing that happens in terms of anti-selection, which we have referred to before, is the consumers moving in and out of the system. And they move into the system knowing that they are going to have a procedure. And in terms of the regulations, we have to accept them. We're happy to accept them. But the problem is when you actually find out that there is a non-disclosure, the onus is on the scheme to prove that. So it is sometimes quite difficult for us to get proof. We have to start phoning doctors. In fact, I've had cases where I visited a doctor to actually get the information. So the onus is on the scheme. You know that they couldn't possibly have not had that illness a week before they joined you. But you've got the onus is on the scheme to prove that, which can become very costly as well. So anti-selection is there, as we said. It is human beings, and they actually learn how to work around the system. And we are finding with the economic conditions at the moment that people are getting cleverer with that. They know that they can be on a scheme, come off that scheme for 2 months, and ensure that they come back within that 3-month period, and they don't get waiting periods. And I can promise you this is happening. If we have a look at the billing rules, medical schemes use the tariff coding system to reimburse medical specialists. The reliability of the system is weakened because healthcare providers are using the system to maximize their income. And I won't go through the example again, but the orthopedic example that was used in the BestMed presentation, we have picked that up in our scheme as well. So that is one of the things that they are using. They are unbundling the codes. And these changes are made unilaterally. It's not discussed with the payer, and definitely the member doesn't know about it. In terms of some of these things, we have a process of pre-authorization at Cape Medical Plan, where it is a planned procedure. And the members come in, they ask to go for the procedure. We tell them to get quotes from the doctor. We then go through the quote and tell them what was paid. And on that, we would get those tariff codes. And then we can say, listen, we're prepared to pay for this or not for that. It does give the consumer more power in deciding which specialist to use. And it does give them an ability to negotiate when it is a non-PMB, because we do not want our members to be out of pocket. We do not believe that members should be subsidizing anything. As far as the billing is concerned, the other issue that happens is the interpretation of some of the codes that are used. And BHF mentioned earlier the modifier 0019. Now, in terms of that, it was used initially for surgery, and then they decided to use it for infants in ICU. It adds 50% to the bill. The weight of the infant was upped to below 2.5 kilos, so it involved another level of a whole different number of patients were involved in this. We had an example where we had a set of twins in a facility. The doctor did not do surgery on them. He charged the modifier every day. He visited 2 of them. And one of the twins had a problem that was not picked up for months. Now we question, why did he charge that extra? Where was this care that was given to this infant? Why was this problem not picked up? So there is a lot of gaming that is going on as far as the billing is concerned.
As we've already mentioned, we use 100% of contributions to fund benefits. So, quite logically, if benefit spend increases, so does the amount of money required to fund this. And out of whose pockets does that money come? The members, the people. So it does matter if PMBs, and particularly those linked to the end-of-life care aspect, rise much faster than non-PMB benefits and general inflation. So do they? Well, the presentations this morning from schemes far better equipped than us to demonstrated that quite clearly and unequivocally. It is a fact. And it's a problem. Not the fact that there's a compulsory inclusion. We all understand that was good. And it's good for social solidarity reasons. And we've heard about the whole paying full at invoice cost and the negative effect that that's having. And, you know, everybody's discussing that. But for us, it has a direct effect on our members. PMBs cost us several million extra last year. So several million has now been collected back from the members. That's the reality. And actually that's the reality in every scheme. Doesn't matter how you dress it up, doesn't matter how you hide it. In the end, that member pays for it. It's just very, very, very clear in our particular example. People may say, well, that's what the reserves are for. Certainly, the reserves help to fund that. But as we've already stated, we use the income from our reserves to fund the running of the scheme so the member gets maximum benefit. But eventually, no matter which model you have, if you keep funding from the reserves, there won't be any left. And it's not about the 25%. It's about what do you need in your scheme to keep your scheme stable. We need more than 25%. It's not an issue, the 25%. It's about the amount of rands in our particular case. And eventually it is for everybody. And sooner or later, everybody will get to that position. Doesn't matter what their reserves will be. In the end, they will pay more for PMBs out of monthly subscriptions. There are different mechanisms that get used. Sometimes a scheme will incentivize a clinician, and we heard a bit about this, to limit expensive treatment. But should we be doing that? Is that right? How are we doing it? People have complained about the treatment that they're getting. They can't get this, they can't get that. So, on the one hand, perhaps you'll pay a practitioner more to be more careful, to look at the costs more carefully. But there's the other side to that. Should we even have to be doing this? But if we don't, does the bill simply get maximized? And then it has to be paid. Doesn't matter what it is, it has to be paid. So is the current environment, in this environment that we have, are unnecessary costs being added? We think they are. And we think today a number of the role players here have demonstrated that. Yes, it is necessary, and there is a necessity to have coordination of care. And we agree that the general practitioner is the doctor to help achieve this. Because at the moment, private healthcare delivery is extremely fragmented. You heard one or two examples about this scan being repeated and the next one and different tests being repeated, but it's fragmented in many other ways as well because people have multiple conditions. And often it's clear to us as the receiver of claims that one practitioner doesn't have the faintest idea what's going on with the other practitioner. That is not a good delivery model. Not only does it increase costs, but possibly downgrades care as well. So what we need, for very many reasons, these reasons and the reasons around trying to determine what is an appropriate level of care for a prescribed minimum benefit. Is it R1 million worth of treatment for this particular thing, or is it 50 rands worth of treatment? Not just in rand terms, but in terms of actual appropriateness as well as cost effectiveness, in terms of clinical effectiveness. And in South Africa, the tendency is that clinicians make their own decisions about this. Isn't it time that we start looking at having clearer, ethical and realistic protocols that are nationally supported and drawn up by independent clinical people and bodies with no link to any hidden financial gains? They have it in other countries. We have the sophistication here. We have the ability to do it. Is it not time that we did? In doing that, we can help alleviate some of the problems associated with prescribed minimum benefits and treatment in general and a fragmented healthcare system. Colleen. We actually have a couple of cases here just to illustrate where protocols would probably have been hugely valuable, not only in terms of cost effectiveness, but actually in the treatment of the patient.
If we look at our first case study.
Sorry, Chair, can we just finish off on these two cases? Or I know we've taken our time.
Thank you. With the first case study, and these examples of since prescribed minimum benefits have been in, where we have seen treatment taking place that has not benefited the patient, it has not benefited the family, never mind the collective membership of Cape Medical Plan. The first case we had was a neonate born prematurely at 25 weeks, weighing 510 grams with respiratory difficulties. That in itself, not a problem. Pediatricians will tell you they can do something about that. The neonatal intensive care and estate department has certain exclusion criteria, and we had looked at that at some point in the case, but baby was in a private facility and we were obviously not about to move the child. The scheme also did not have all the information. We battled to get information from the treating specialist, and all the way through the case, which took place over 7 months, we were denied enough treatment to institute clinical protocols and decisions. And we have reported the case to the HPCSA. It is well over a year and we have had nothing from HPCSA. The neonate in question was also born with brain damage incompatible with life, and the outcome would result in lifelong serious physical, mental handicap, suffering, irreconcilable with a meaningful existence. Now, these were not things that we assessed on our own. This was reports that we got in from other specialists who dealt with the neonate further down the line. The neonate was born with missing temporal and occipital lobes. At some point, the reports that we were getting from the hospital, because those were the only reports that we were getting, showed that there was white matter seeping out. The neonate had started to hemorrhage. He had rashes so bad from the antibiotics that he was on that his skin had split open. Baby had stopped breathing after a few weeks but was resuscitated. And this we found out. We had actually gone to the hospital, it wasn't a local facility, to meet with the family, to meet with the doctor, to meet with the carers in terms of the hospital to see what was going on there. The specialist at the time was not very helpful. In fact, he told me I'd spoiled his day. Baby suffered and struggled for months and passed on after 7 months. Would this have been any different? The cost to the collective was 3.2 million, and I think even worse than that is that the family sat going through a period where they had no information and they thought there was going to be a positive outcome. We were sitting with medical information where we could see clearly there was going to be no positive outcome here. And certainly as far as the patient was concerned, this was not the best treatment. Case 2 happened more recently. A patient underwent an uncomplicated right carotid endarterectomy. He developed a cardiac arrest and remained in a depressed conscious state. He showed no signs of recovery, no reaction to pain, verbal commands, no spontaneous eye movement. Once again, further down the line, we received a report from the neurologist where he confirmed that the patient had suffered hypoxic brain injury and was in a vegetative state. He wasn't responding to external stimuli and showed slow frequency activity. The patient remained in ICU fully ventilated for a further 3 weeks after the date of this report. We unfortunately got the report later, so we only had this information further down the line. But surely when the neurologist had found this, at this point palliative end-of-life care should have been instituted. The case cost us 2 million rand, the collective membership, of which 600,000 was incurred after the neurologist confirmed the patient was in a vegetative state. This excessive treatment did not change the final outcome. And I think in terms of this one as well, we had since found that our member had a living will. So this was almost his worst nightmare, quite honestly.
And inclusion, if I may, panel. The question we're asking, and we're asking to be considered, is this. Is the self-administered mutual society a better option than private healthcare run by companies listed on the JSE? We believe it is. And we believe it can be, and often is, a more cost-effective and fairer model. We believe it supports the intentions of moving healthcare into the domain of a social good. We believe it will create a transparent environment where competition in the sector will work for the people it's meant to serve. And we also believe it will begin the lowering of costs, which will support the constitutional imperative of universal coverage and can run concurrently and support national health insurance. Panel, ladies and gentlemen, thank you for the opportunity.
Yes. What is your role, sir?
Chair, I'm simply a trustee at the medical plan.
Now, are you going to say anything? Or?
Not unless I'm asked a direct question, Chair.
Okay. Can I take it that you were here just to make sure that what they say is what you know?
Exactly. And to manage time.
Well, I take it because you didn't raise your hands at any stage to object. Whatever they say is what you know.
That is correct, Chair.
Yes. Thank you.
Thank you very much for the interesting presentation. I just want to find out regarding, what aspects of the Medical Schemes Act of the top of it prohibit the establishment of the non-profit administrator, as you stated?
There are one or two areas. A scheme cannot own an administrator, so that alone prohibits that. There's also the collective bargaining that is not allowed to happen with schemes, which is not really part of the Medical Schemes Act, but schemes cannot collectively bargain with hospitals, which would happen in that kind of environment.
Okay. Yeah, in terms of this, it's obviously a very low-cost operation. How does the scheme compare with similarly sized, maybe similar demographic type of other conventional operations in terms of products?
If I may say, there are very few of us, being an open scheme that is completely self-administered. And our size, there are one or two schemes. Our product offerings are very comparable. Our prices are excellent in the market. In fact, that is one of the reasons we have a website where members can apply to be members. And that is one of the reasons that they approach us. We try and keep our products very simple, but we think we offer a range of products to give members a choice.
Like, what percentage of your budget goes towards ex gratia? And I'm sorry, I don't know off the top of my head what would be more or less the benchmark, but if you can help with that, yeah.
Yeah, answer, thank you. In terms of ex gratia, the scheme does not pay out ex gratia. We have another system whereby a member can approach. If a member has something that they need paid that is not a PMB and it is outside the rules of the scheme, then they can put it forward to the trustees. It goes to the board of trustees at the meeting. The board can then decide to put it to the members, which we actually have done. We will then call a special general meeting or a special meeting, and it is at that meeting that the member will present their case and the other members will decide whether they're going to fund it or not. We did have a case a couple of years ago as well, where it was a financial decision. The case was put to the rest of the members, and the members did decide to pay it. But we don't have an ex gratia as such. But we have the mechanism that can be taken to the members.
But it sounds like the trustees are almost not empowered to take decisions on behalf of members, as it were. I'm not saying that's wrong. I'm just saying if you have to call a special meeting to make a call about, yeah.
This is because that's what the members asked for. The members objected to the ex gratia committee system that Cape Medical Plan used to have. They felt that the decisions that the ex gratia committee made were not really fair. And, you know, it's quite difficult sometimes to be transparent and justify an ex gratia decision. And historically, and I'm talking probably 16, 17 years ago, their members said, now, no, we want this changed. And this is what we agreed to and has been in operation ever since. That's how it came about. So, yes, in a way, the members took that power away from the trustees, but that's their right to do so. But for many other things, of course, the trustees do make the decisions. But if you're going to operate the scheme in such a way that the members are involved, you have to have that compromise. Thank you, sir.
Yeah. You also made reference to the fact, which was that the administration costs are paid purely out of investment income. In the event that that pool is actually depleted, is there provision that at that point you can start using premiums to run the operations?
We would do that. It would have to come into the pricing exercise that we do annually.
Okay. All right. So it's not so much that in your founding documents you're just not allowed.
No, we're not prevented from doing it in any kind of rules. It was a decision taken. And the scheme has decent reserves, and products have to break even. So in order for, you could call it a unique selling point for a member to want to belong to Cape Medical Plan, they can understand that those reserves do have a benefit for them, that the reserves are there to assist them in some type of costs.
Okay.
We can't use it to subsidize claims, but we can use it to cover the cost of administration.
Okay, my last question, maybe it's a comment, but it would seem like that the model itself probably makes it impossible to grow beyond a certain size, for the scheme to grow beyond a certain size. So if that is the case, is it one that is sustainable or that you see becoming popular?
Yes, that is correct. We believe that a size of somewhere between 12 and 15,000 after that would become unmanageable, which is one of the reasons why principal members, sir, which is one of the reasons why we would like to encourage the development of the ability to go to shared administration, because then the size could increase accordingly as well. Thank you.
Good, I have less questions because Ntuthuko asked exactly what I wanted. The one question I wanted to explore with you is you made a comment that if you have a third-party administrator, trustees are completely reliant on the information given to them. I know that's not your situation, but I'm interested in your opinion on why you think that's true. Is it true because they're too lily-livered to ask for different information, or because they're not skilled or knowledgeable enough to ask for that information, or because they're captured, or all of and any of the above? Why? I mean, is there something in the rules? Is there something in the that prevents them from asking relevant information?
It's a combination. The data then sits with the administrator. So any information pulled out of the administrator is pulling it out. And we all know with data, you can do things with data. Now, the way around it would be for trustees to get another party in to actually take that data and analyze it, but that would increase costs. So there is a problem there in terms of some of that information coming out. For example, asking how many hypertensives. How do you know that that information is correct?
Let me put it this way. Say, for example, all the people who are trustees on your scheme left, joined another scheme and became trustees on that scheme. Maybe you can answer as a trustee. Would you then know questions to ask that potentially other people wouldn't? I mean, I suppose I'm asking two things. Is there a structural impediment? Is there a legal impediment to them getting it? And could you, if you knew what to ask for it?
To take that last question, I think, yes, if you knew what to ask, you could ask for it quite easily. There's no structural impediment to information, in my opinion, as a trustee. It's more of a practical impediment, not knowing, as you correctly point out, the correct questions to ask or the pertinent questions to ask. Not often knowing the healthcare industry particularly well. I'm a relatively new trustee of less than a year on the Board of Trustees of Cape Medical Plan. And I've had to go through my own training, some of which is run by the Cape Medical, the Council for Cape Medical Schemes, otherwise through interacting with the management here. And it is a highly regulated environment, which takes a lot of getting used to. So I think for new trustees coming in, it's a big ask. But you can empower yourself, you can get the information, but you are almost inherently reliant, in my opinion, on your management to give you the correct information.
Do you think there should be obligatory qualifications for trustees or obligatory training and induction for trustees? How could you make trustees more trustable?
Yes, I think you could have obligatory training. I think it's quite difficult to put a bar for trustees because you want to encourage people to step out of the general body of members and become trustees, and you want a representative body of trustees. So having certain individuals who are earmarked as being particularly smart or particularly well versed or experienced, I think detracts from that. So I'd like to say open it up to everybody as is currently the case, but perhaps bring in more training and make that obligatory.
May I add to that? Thank you. That's the point of appointed trustees. They are there to fill the gaps. And the Board of Trustees, together with the management of the scheme, need to carefully look at where are the gaps, where are the skill shortages, so that they get the right people without diluting the democracy aspect. Thank you.
Thank you. Mr. Wynne, I thought you'd get much more questions than you did. But your answers were very clear. Maybe the three of you. So what I try to understand, I see in the red line in here, you are more cost effective and more fair. But still, you are a small medical scheme in the Cape region, isn't it? So the question obviously is, you know, if you're so good, why aren't you rich? But then put it in a different way, why aren't you growing very steep and almost very fastly hitting your ceilings? I want to come back to the ceilings.
I think firstly we are strong Western Cape based, but we also have a large pocket of membership in Gauteng, and we do have throughout the country. So we're not just Western Cape based.
And how many members do you have in total?
In total, our membership's just below 6,000. So we're looking at 14,000 lives plus minus in terms of lives. And of that, about 70% of it sits in the Western Cape area.
That's right.
But it hasn't been because we've purposely only targeted Western Cape. It's just the way it's turned out historically.
So you're concentrated in two regions?
We're concentrated in two areas, but we have pockets throughout,
that's right.
throughout the country.
But Cape Town is, of course, big. There's a lot of people. Why aren't masses of people trying to get in?
We do not use brokers. And in terms of the employer groups, employers use brokers. There's very few of them that don't. You have the small companies, and we understand clearly why they do. It's a very complex industry. You're sitting in human resources, and you're dealing with income protection, you're dealing with group life, and you're dealing with all kinds of other things. For heaven's sake, just give it to one broker, come up with one solution, and you don't want to deal with a whole lot of brokers. Now, the fact that the scheme itself does not pay a commission obviously is a deterrent for brokers to bring any kind of group to us. The only time we get a group is when everybody else says go away. The other problem we have sat with is that where we have had some of the bigger employer groups in the corporate areas is that the brokers move in. And we've had employers who said to us that as far as the scheme is concerned, the medical aid side, they're happy with us, but they just want to do a one-stop shop to deal with the broker. And this is where the brokers are linked in and selling all kinds of other insurance products. So that is one reason on the employer group side. On the individual side, we work through word of mouth and that kind of thing. We haven't openly marketed. It's been quite a hostile environment as far as the schemes are concerned. And we do take on members. It's not that we are not taking on members, but we are definitely finding with the economic times that we are also having members leaving. And they're not, and this is really where we are concerned about the problem, because the members are not going to other schemes. They are moving out of the system. And these are members, some of them who've been with us for 30, 40 years. In fact, what we see they start to do is they start to dilute their family grouping. So instead of mother, father, and 2 children on the scheme, it's mother with 1 child. And it's usually the child who needs something. So they start splitting the membership. One of our members who'd been with us for 40 years, he actually took his wife off because he was ill, she wasn't. And interestingly enough, he gave us a written submission asking us what we were going to do as far as the industry was concerned, because he was so worried about costs. And the member support that we hear at the Competition Commission, they've actually said to us, you know, good luck. But yeah, we're not out there openly advertising and using brokers.
May I add, sir? Because the majority of our members are not from employer groups, they're individuals. They don't get any subsidy. they get no help. So the economic reality of being able to afford a monthly subscription bites a lot harder and a lot quicker amongst that kind of member. And that does make us vulnerable to some degree. We realize that. We're not going to be able to change that with the broker situation the way it is and with our approach to brokers. If we changed our approach and we paid them, I'm sure they'd come flooding through the door.
So what you tell us is that you can be good as a scheme, or you can be even very good, cost effective, fair, all things that consumers want from you, and still not grow considerably, because there's one factor that keeps you from growing, and that's the fact that you object to using brokers. So the broker system defines growth of your, is that what you say?
I think it is, sir. And I think that the other presentations, when you've asked questions of people around why they use brokers, it's been interesting to observe the answers, not so much as what was said, but what wasn't said. Once you're in that model, you dare not get out, because if you do, your members go with them. This is a model that's got lots of ramifications. It needs to be very carefully looked at. The model where the scheme pays the broker. It really needs looking at, sir.
We will.
Just to add to that, we've had experience with brokers where if they hold a large percentage of a medical scheme's membership, they expect special underwriting, which is that fair to the collective. And they also start moving them out if they need to, until eventually the scheme is in such a position that they are sitting with the vulnerable members who have nowhere to go, and they end up having a merger. We've also had situations where the brokers have moved in on some of our employer groups, and they try and leave the more vulnerable members, which is usually your pensioner members, and move the employed people off somewhere else and leave the others with us. And we have members phoning us saying, my ex-employers just said, go and find your own medical aid. And they've had 33 years of cover with us.
Thank you.
Perhaps I might refer the panel to what happened with NMP. It would probably be a good thing to look into the history of what happened to NMP medical scheme and how their demise came about and what role the broker fraternity played in that.
I'm sure that Mrs. Halsa has made a note of that. In response to my colleague, Dr. Bengu, on the number of beneficiaries that would fit into a system like yours, you said probably be around 15,000 beneficiaries. That's a sad thing to say. So what you said is a member-centered scheme has a sort of natural limit of 12, 15,000 members. Can you explain to us why this formula couldn't be 150,000 or 1.5 million members? What would a professional organization not be able to do if it would be patient-centered or member-centered that you are able to do?
I think, sir, if you look around the world, large organizations very rarely achieve the ability to deal with people as individuals. And I just think it's a practical issue. We think that there could be a development of the member-centric concept through having separate schemes who do work together and share resources that wouldn't impact negatively on their ability to deal with their members. I mean, I know for ourselves, depending on what the issues are, sometimes a lot of time is expended, and you have to have the right people, the right resources, the right resources to be able to properly give people the attention that they should get. And as a single scheme like this, it becomes inordinately difficult to do that beyond certain numbers. And I don't know the answer exactly, to be honest, but could probably be increased, but it would be about working hard to do it. Because the complaints that one gets is always, some individuals get dealt with fairly and nicely and properly, but there's this impersonalness that people complain about.
Your organization has been in existence now for what, 55 years?
Since 1961.
Yeah.
It was a friendly society to begin with.
Yeah. Do you know how many schemes are self-administered in this country?
We talk about self-administered, but even within that self-administered environment, there's a lot of outsourcing that goes on. So even though they're self-administered, they could be outsourcing their managed care function, etc. So if you are looking, we always say, if you're looking at comparative schemes for us to have a look at, completely self-administered open schemes, because I think the environment of an open scheme is very different to a restricted scheme. A restricted scheme is often a type of HR arm of the business and the people that are working for that particular company. So we're probably about 5 that we would say we would look at to say similar kind of schemes.
And these are schemes that are neither administered.
Sorry, when we're talking about that, I'm talking about open scheme that's self-administered.
Yeah.
Yes.
Yeah.
The rest of the schemes are administered by one of the big administrators.
Yeah.
There are restricted schemes who are also self-administered.
Yeah. And do you know what numbers are we talking about here?
If I'm looking at similar size, similar to us, probably about, I wouldn't even say there's 10. Not even 10.
Now,
some of them are much larger.
Yeah. I mean, are there any larger schemes that are self-administered that you know of?
Yes.
What are those?
You've got, but MediHelp has had a management buyout, so they've still got an administrator.
I beg your pardon?
There was a large one, MediHelp, but they've had a management buyout, so they're administered by their management team, who's they've formed an administration company. But it was almost like a self-administered scheme. You've got Genesis, that is an open scheme that is self-administered. You've got SelfMed, that's an open scheme that's self-administered. And then you've got MedShield and BestMed, of course, that spoke today.
Yes. No.
I think MedShield is probably the biggest.
Now, you have what one may call, for want of a better word, a very unique approach to medical schemes, which is member-centric, to use the word. Is that right? Is that a fair characterization of your approach?
Yes, sir. Thank you.
Now, can this approach be applied to bigger schemes, the biggest that you can think of in this country?
I think the answer to that is yes, sir, but it may not be easy, maybe not be that easy in a huge organization. But certainly I think certain philosophies and attitudes could certainly change and could certainly be more transparent and certainly be more member-focused than seems to be the case if you listen to the submissions that have been made to this commission over the past few weeks. One wonders sometimes, why do we even have medical schemes? Because they just seem so removed from the needs of their members. It's not all true, of course, but there's that pervasive attitude out there that we are not doing what we are there for. But yes, I think it can change for the better and can improve. But a big scheme might find it more difficult to do what we do.
Why is that so?
If I may just add to that, I think on a big scheme you'd have to have a look at where that membership comes from. And you could, theoretically, divide it into little pockets of business dealing with the different employer groups or dealing with the different geographical areas. So it would sit under one umbrella, but sitting in different pockets depending on the membership they were dealing with.
I think, sir, that when James gave their presentation, they gave some interesting views about how they were moving to communicate better with their members, be more involved with their members, and I think that they touched on some important ways around how they're going to do that, so that there was an effort being made to improve that side of things.
Yes, but what makes this concept difficult to apply to bigger schemes? But you've just, in response to my question, said it will be difficult to apply this to bigger schemes. And I just want to know, why is it?
If you had to look at a breakdown of a bigger scheme and sorting it out into different business units, you could potentially push up administration costs. So if you had to operate, say you had a scheme of 100,000 members and you had to split it up into groups of 10,000 and operate it in that, it might. Certain things they'd share, but it might. But I think the important thing is that the only way the model works is if you treat people as human beings.
I just add to that.
Yes.
Even as a small scheme, we still are faced with challenges like communicating with our members. So while we pride ourselves on communicating with our members, it's still a constant challenge. We've got to dream up the next newsletter to go out next month. We've got to hold the benefit information sessions, and not just here but elsewhere. We've got to make sure that members are aware of what we're doing and how we're doing it. And that's difficult enough at our level. I think what we're suggesting is it gets more and more difficult the more you go up in numbers. And it's that kind of thing that makes things quite difficult. The second point I'd like to add is certain level of care cost, let's take a figure of say 200,000 or 300,000 rand, becomes a big issue for us. We look at those kind of cases very, very carefully, and management can add a lot more than I could as a trustee to this. The point is management gets heavily involved often at that kind of level, and as the cost goes up into 700,000 or 800,000 rand per claim, for want of a better word, that level of care that we have to take, that level of involvement as a plan that we, as a medical scheme, that we have to consider and visitations to members, etc., becomes that much larger, because those kind of claims to a small claim like ourselves become more and more of a factor. And I think the concern is that if we start, we can manage that at our level, but we're not sure we could manage it if we started extrapolating the numbers, if that makes any sense.
Now, you said that 100% of the monthly contribution, they go towards the funding benefit, the fund benefits. Is that right? Yeah. Now, there is an amount of 108 rand, I think it is, per month. Is that outside of the contributions? Is this an additional amount that goes towards the administration cost?
Yes, sir. Our reserves are such that the earnings that we make on them are sufficient to fund any underwriting losses that we've had to date, as well as the costs of running the scheme. Sometimes we're fortunate enough to even add a little bit still back to the reserves, but it comes from the earnings of the reserves, yes. So we're putting the reserves to work for the members. They're not just sitting there. It's our way of saying we need the reserves, it gives us stability, but it isn't just idle money. It's being used to get you better benefits. That's how we look at it. So.
Now, has this, the philosophy that you're pursuing within your organization, is this the philosophy that you've always been pursuing since inception in 1961? Or has it evolved over the years?
I don't think it was there right at the beginning, and perhaps in the way that it is now, but to be honest, I don't really know because I wasn't there. So I'm going to ask Charlene.
Well, I wasn't quite there in 1961 either. But the scheme was originally set up by doctors actually to assist. To assist them with payment. Obviously, we went through the period where you could risk rate. People had exclusions and they stayed on for life, and that was a different time. The philosophies really developed because during that time and membership started moving, the scheme had decent reserves. So really since the implementation of the changes in the Medical Schemes Act, being the open enrollment, etc., more or less from that time we've started adopting this philosophy. When we realized we had decent reserves and this is what we could do. We were always very, very aware that cost is a factor, and we always, when we priced the product, we looked at it to break even on underwriting, because we didn't want members to have to pay higher than they needed to. In fact, we have had a time where we gave the members a subscription decrease.
And so, I think it's evolved. I remember when I joined the scheme as a member in 1985, I was impressed with the fact that at that point in time, our trustees did it for nothing. I thought, this is just great. It's how it should be. And I come from a background where the mutual society is a strong idea. My upbringing was such, so I recognized it. And I think that we felt that that was a valuable thing to develop. And I think, to be honest, it's developed to where it is. And yes, we do have concerns that it may not continue to develop and may not continue to survive, to be quite honest.
Are you, well, I know that you've said that your philosophy may be difficult to apply to bigger schemes. It's not clear to me why is that so. I mean, as a basic philosophy that a scheme ought to pursue, which leaves aside the question whether or not it should be administered by somebody else, because the bigger you become, it may be necessary to outsource or to develop some other means of administering some of the costs associated with the running of the scheme.
Yeah, it is a difficult one. I think, if you're self-administered, it's different. If you're being administered, there are certain decisions taken at administration level to keep those admin costs as low as they can, because they have to, there's competition out there for schemes. They don't want to lose their customers. So they will do things that might not necessarily be in the interest of that particular scheme, but it assists them in keeping those administration costs low. And sometimes this even moves down into the managed care area. And we've had an example recently of a machine that is being used in a hospital. It's usually only used in the cardiac unit, but they found uses for it outside of the cardiac unit. And there is an administrator we know who just approves it. Now, the consumables for that machine alone are 160,000. I understand their decision because they do maybe 2 or 3 of them, and what's 160,000 for the scheme, we'll put it through. Whereas for somebody like us, we're looking at it and saying, no, this does not serve the collective membership, and it's certainly not going to improve the outcome for the patient. So different decisions get made because you're bigger, and sometimes just to deal with 40 queries, you've got to have so many staff involved, it's not worth actually looking at those things.
But I think, sir, if I may add, in theory, there should be no reason, actually. Philosophically, there should be no reason. I'm just not sure that practically it will come about.
Right. But as I understand your basic philosophy to medical schemes, it is a philosophy which is deeply rooted in the notion that these schemes are member-centric. At the center of the scheme are members. Is that right? Now, is that concept not applicable to bigger schemes?
Well, it should be so, because otherwise, what's the rationale for existence? You don't have a scheme just for the sake of having it. If it doesn't serve the members' interests, then what's it there for? So, yes, I agree it should be, and probably is to a greater or lesser degree, depending on the ethos of the particular organization, because I think you can't get away from the fact that ethos and values and ethics, they play a huge role, a difficult to define role, but they play a huge role in how you do things. Ethos sometimes gets lost.
Why I'm raising this is, I read the preamble to the Medical Schemes Act, and one of its declared purpose is to protect the interests of members of medical schemes. Now, which seems to be at the center of the Act. I just wonder why that can't be applied to bigger schemes.
Again, sir, the only answer I think I can give you is, in theory, I don't see any reason, but I wonder what the view of the Council for Medical Schemes is about whether it's so member-centric out there. I think they may have a better and a more informed view than I have.
I mean, you've been a member of this sort of scheme since 1985, right? Right. Now, do you think that if there is a change in attitude in how people view medical scheme, where you place members at the center of the scheme, would that change attitudes towards brokers, towards administrators?
I believe so.
Toward the attitude of trustees, for example.
I do, sir, yes.
The attitude of administrators, the attitude of managed care organizations.
I do, sir, yes, because it's one thing saying, oh, we have to report back to the members, and yes, we've got to do this, we've got to have an AGM, and it's another thing really reporting back and really being accountable and really being held to account and having to justify your decisions. They're not the same. And attitude plays a huge role in how you go about doing those things, and whether you just play the game and tick the boxes or whether you really do it. So I do believe it would change the attitudes and the decision-making of trustees of schemes. Yes, sir, I do. And some of the things that have been going on in medical schemes, be they self-administered or otherwise, just show exactly what the attitude of some of the trustees has been and how cavalier they've actually been in using the members' money for their own gratifications in some cases. And you've only got to read what's been going on, and it demonstrates quite adequately that feeling of accountability and feeling of the proper, fit and proper approach to handling somebody else's money has not been there in so many cases.
Thank you. Is there any other issue that you had wanted to draw to our attention, but which you didn't have time to do? Yeah? Yeah.
No, sir. Thank you.
Yeah. And I take it they did perform to the best to your expectations.
I will be having words with them hereafter, Chair. Also, I just wanted to add that my remuneration isn't covered yet, and I have to have a chat to them about that as well.
Yes. Oh, thank you for your generosity as well.
Thank you.
Yes. Okay. Very well. Now, we've come to the end of your presentation. But just before that, what is the international experience on this issue? It's okay.
I don't know, but I come from a background where the state provides the majority of healthcare, and obviously it influences my thinking. But I don't know the answer to your questions.
I understand. Okay, very well. Thank you for coming to share your experience with us. And thank you again for your patience and for being here until this hour very late. Thank you so much for your patience. We've come to the end of this session. Now, tomorrow we're going to start at 8:30, just to see whether we can make up for lost time. So, if there are members who will be, there are stakeholders who will be presenting tomorrow, please make sure that you're here at least by 8 o'clock, so that we can start promptly at 8:30. I mean, this is not to suggest that the day after we'll start at 7:30. Let's see how we perform tomorrow. Thank you for your patience.